One thing, go to meeting, go to your settings to ensure the microphones. The commission or commission staff immediately if you are experiencing technology failure that prevents your participation at any time in the proceeding. Attorneys should contact staff at the previously provided cell phone number. The hearing today is for the purpose of taking evidence on Lg&E and KU's proposed net metering tariffs 1 and 2, the small qualifying facilities and large qualifying facilities tariffs, and those items noted in, I believe, last Thursday's rehearing order. At this time, we will have the entry of appearance of counsel for the applicant.
Good morning, Your Honor. Kendrick Riggs and my colleague Duncan Crosby, along with Allison Sturgeon, managing senior counsel for regulatory and transactions, and Ms. Sarah Judd, remotely senior corporate counsel.
Thank you, Mr. Riggs. And for the Attorney General?
Well, Your Honor, Larry Cook was online. He may be having some more conductivity issues, but he was going to kind of be the conductor for the Attorney General's office. But there's also John Horn as well appearing in person.
All right, thank you, Mr. Horn. For KIUC?
Thank you, Chairman. Mike Kurtz and Jody Tyler Cohen for KIUC.
And for Kentucky Solar Industries Association?
Good morning, Mr. Chairman. Randy Strobo, David Spinard on behalf of CASIA.
Thank you. And for Mountain Association, Kentuckians for the Commonwealth, Kentucky Solar Energy Society, and Metro Housing Coalition.
Good morning, Mr. Chairman. As Vice Chair, Tom Fitzgerald representing the joint interveners.
And I see Mr. Miller for Sierra Club.
Good morning, Mr. Chairman. Good morning, everybody. Yes, Matthew Miller on behalf of Sierra Club. Also on the line is my co-counsel, Joe Childers. Joe will be taking over at the end of the day. We have no witnesses. Thank you.
Thank you, Mr. Miller. And for commission staff?
Nancy Vinsel for commission staff.
And Ms. Vinsel, Mr. Riggs, I've been told that public notice has been given and filed into the record. Is that correct?
Yes, Your Honor, it has.
And Ms. Vinsel, are there any outstanding motions?
Yes, Chairman, there's several outstanding motions. I'll go through them each. We have several pending confidentiality motions. They will all be addressed prior to September 24th. There is one item that confidentiality was not required, but it was filed in camera. This was Lg&E KU's response to staff's 6th data request, item 6. These contained a substantial number of responses to an RFP. And again, there was not a motion filed with them, but they were asked to be viewed in camera.
Right, Mr. Riggs, I remember that at the hearing, I believe, the chairman at the time said to file something or to send it along, and I think we have an email on record copying counsel.
You do.
Regarding that.
Yeah,
is that correct?
Yeah, the responses to the RFP were requested. We expressed an objection, asked that they be reviewed in camera. The chair at that time said that the commission would review the documents. They were submitted in camera by an email just to the then 3 commissioners and staff counsel. And within the next morning, the chair confirmed the production on the record. And I believe there's an email also confirming that. Madam Vice Chair, if you would like access to that material, if you will say the word, and that will be provided to you today.
Yes, please.
Then it shall be provided.
Thank you.
All right. Those documents are produced on our document production site through confidential access, and we will ask that access be provided to you today. So
I think
that's where it rests.
Yeah, I think my request would be if we could supplement the record with something formal to continue to request that information be kept confidential and to, continue, I think, for the companies pleading that it be subject to only in-camera review and limited to I think at this point, it's limited to myself and Ms. Bensel.
As we speak, that's correct, because the former chairman had access to it, as did former Commissioner Matthews. And we will provide access to vice chair today.
Thank you.
And Ms. Vinsel has access to it. The former staff attorney had access to it, and we'll clean that up.
Okay. I'd appreciate, maybe in a week, if you all could file something formal with that,
That's what I was going to ask, about a week. Yeah,
that'd be great.
sure.
And then Ms. Vinsel, I have also that in addition to the petitions for confidentiality and the company's response to staff item 6, which we just spoke about, there are also a couple of other motions. One, to file corrected supplemental rebuttal testimony of Mr. Conroy, is that correct?
That's correct.
And are there any objections to Mr. Conroy, that motion? There were none in the record. To be frank, I don't know if the 7 days has run to respond, but is there any objection from any of the other parties?
No objection.
Okay, so I'll go ahead and roll on that for the purpose that we at least have the correct testimony for today's hearing, so I'll grant that motion. And then we have a pending motion for leave to file supplemental rebuttal testimony for Mr. Sinclair that I think the company's filed on Thursday or Friday of last week. Is that right, Mr.
Yes.
Riggs?
Yes, it is, Your Honor.
Okay, and at this time, I think Mr. Spinard, your client has filed a response to that, is that correct?
Yes, Mr. Chairman, that's correct.
Okay, and I know, again, short time, do any of the other parties, would any of the other parties like to be heard today in response to that motion? Since the 7-day window has not run, I think that will also allow us to narrow the hearing today. All right, and Mr. Riggs, not hearing anyone else respond, I guess I'd give you an opportunity this morning to reply to, I guess, the objection or the response to the motion by Casilla.
Yeah, well, thank you, Your Honor. We do take exception to the response filed by the Kentucky Industrial Solar Association. We believe that our due process rights necessitate submitting this rebuttal. When you look at the response that was filed, it does not contest the cause that we stated for filing the supplemental rebuttal, and acknowledges that the supplemental rebuttal could still be provided following our cross-examination of Mr. Barnes on this very issue. It seems, accepting for the sake of that argument, that if that were the position, this would be the more efficient way to address the matter by allowing the submission of the supplemental rebuttal and Mr. Sinclair presenting, when he takes the stand, his supplemental direct, his rebuttal, and the supplemental rebuttal together is one offering. The calculation of the proxy method that appears in Mr. Barnes's rebuttal testimony is the first time that information has appeared. Mr. Barnes made the assertion in his March testimony in concept, provided no calculation. When he filed his testimony in July, he continued to recommend it, and only when he filed his supplemental rebuttal testimony did he actually provide a calculation for it. As the party with the burden of proof, we should have the right to address and have the last word to that and to respond to that calculation in the form of rebuttal testimony.
So I'm going to go ahead and grant the motion to allow it, if for no other reason in this single instance that Mr. Spinard will now have, and the other parties will now have an opportunity to conduct cross-examination on that rebuttal. I think that's much more efficient use of time than to allow that direct examination to be done on redirect and then another most likely lengthy cross-examination on the issue. So I'll grant the motion and overrule the objection. I appreciate it, Mr. Spinard. Thank you for the perspective. There's also a pending motion for a deviation regarding the ProSim modeling output. I think the pleading, Mr. Riggs, states that it's approximately 5 gigabytes.
It is, Your Honor. The file volume and format is the issue with uploading it to the commission's website. And so we have provided access to all the parties the same day it was produced, again, using our firm document production room. It is not confidential information, but the format and the volume of it is simply, too large to upload to the commission's website. Now, we certainly, upon commission request, we can provide that to you on a thumb drive if you wish, but
Yeah.
all parties have access to that data as we speak, Your Honor.
I think I'm inclined to grant the motion, or at least the alternative request in the motion, in that, at least with regards to production for the commission, it needs to be in a solid medium so that we can place it in the case record
Okay.
that we keep here at the commission.
Is there
So-
a preference, or should I just talk to staff about that?
I think the thumb drive or CD-ROM, whatever it may be, as long as it's not a floppy disk, I think we'll be content. I don't actually, now that I think about it, I don't know that 5 gigs fit on a floppy disk, but whatever one of those mediums that you all prefer would be fine. We do need a physical copy, and I think that production on the website would not satisfy that.
Yes, we'll do that. We'll have that produced to you by the end of the week.
Okay, and for the motions that I have rolled on today for the bench, we will subsequently enter an order for the record, just so that it's clear our position.
Chairman,
I was gonna say, Ms. Fensel, is there anything left?
I do have a request that when the thumb drive or CD is filed, that there be at least 2 copies, so that one goes in the case record and one can be viewed by staff, without having to check out the entire case.
That'd be great.
Would you like more than 2?
Yes, if you could provide more than 2. 4.
We're saving you on the 11 copies of things now in paper medium, so I hope we can get 4 thumb drives.
And I think I can speak very confidently on behalf of all who appeared before the Public Service Commission, and thank you for sparing us from filing the 11 paper copies of everything.
Or the 1 paper copy that have been accumulated over the last year, I suspect.
I think I would speak, again, with confidence for the industry and all that appeared before the Public Service Commission and filed, that everyone has a pile like that in their office. And we are grateful that we do not have to file that.
We're saving people's, we're not gonna put you all out of business, but we're saving people the expense of bringing them here. All right, Ms. Fensel, there are no other motions, is that correct?
That's correct.
Okay. We'll now move on to public comment. Should anyone from the public like to provide the commission with public comment on this matter, instructions to call in are located on our website, psc.ky.gov. The instructions to provide public comment have been on our website since yesterday. The phone lines will remain open for several minutes at the start of the hearing this morning. The hearing started at about 5 minutes after 9. It is now 9:25, so I suspect people have had plenty of time, were they interested, to provide their information and express their interest to participate. We will keep the lines open so that if there are no callers, or after everyone has had the opportunity to speak, we will close it. Should you call in, please state your name and address for the record before making your statement. Please keep your comments to 5 minutes or less. If there is more than one caller, please be respectful and allow one person to make a statement at a time. It should be noted that comments may always be submitted on the PSC's website at psc.ky.gov. In order to do this in a timely and efficient manner, I'll ask Ms. Vinsel to identify each individual who has previously indicated their interest in speaking. And so only unmute when your name has been called, and please provide your comments in 5 minutes or less. Ms. Vinsel?
Yes, Chairman, we have 2 people who signed up for public comments. The first is Jackie Cobb.
Ms. Cobb? Jackie Cobb, are you on the line?
Well, Chairman, while we resolve that technical issue.
Yes, hi, can you hear me?
We can. Please go ahead and provide your public comment, and you'll have 5 minutes.
Okay, great. Hi, my name is Jackie Cobb, and I'm a Louisville citizen, and I am a customer of LG&E on the residential side. And I am just calling to voice my support for retaining net metering prices that do not diminish the amount of money that a customer would get through net metering. I understand that, the mission of the PSC is to make sure that we have safe and reliable service at a reasonable price. And it is my strong opinion that encouraging rooftop solar installation is imperative to providing safe, reliable, and reasonable service. And the reason that it's retaining a higher net metering price is reliable and safe is that we are in a moment of climate change crisis, and it's really imperative that we do everything we can to encourage rooftop solar in order to reduce carbon and provide resiliency to the grid through a somewhat decentralized, grid. I know that to a centralized utility that has a monopoly over its customers, that is not something that, a utility maybe wants to foster, but as a society and as a community, it's really something that we need to go over to. And then also I understand the PSC needs to provide reasonable prices to customers. And I think that's what the utility likely will argue, is that there are costs to providing, the grid access. And that's certainly true. But you can look at many studies throughout the country and throughout the world that have looked at the value of solar. And, I was reading one in preparation for these comments and from Minnesota. And the PUC actually found that the value of solar, when looking at their net metering case, was 14.5 cents per kilowatt hour, which was 3.5 cents more than Xcel's retail rates, because they were looking into the value of the social cost of carbon, the avoided construction of new power stations, and the displacement of more expensive power sources that were factored in. So I would really strongly argue that there is, hold on, baby, I'm making a quick comment, 1 second. That's my 4-year-old. Sorry. That there is significant value to society, the grid, and the utility by fostering net metering and rooftop solar. So thank you for this time, and I will cede the floor. Thanks so much.
Thank you, Ms. Cobb. All right, Ms. Vinsel, you said we have another person that has signed up to provide a public comment?
Yes, Deborah Girth.
Ms. Girth, are you there? Deborah Girth, please make sure you...
This is Deborah.
Can you hear me?
Have I been unmuted?
Yeah, you are. Please provide your public comments, and you have 5 minutes.
Thank you. My name is Deborah Girth. I live at 461 Silver Maple Way in Lexington. I'm a residential customer of KU. I'm not an owner of a distributed solar system. I've already submitted written comments, and I won't repeat them today. Instead, I would like to suggest that the real question at issue today is not fair treatment of the owners of net metered solar systems. This is important, and the Commission should set a rate that accurately represents the benefits of distributed solar generation, a rate based on evidence and analysis, not just the opinion of the monopoly utility. Rather, I would argue that the question at issue today is whether, in the face of a climate emergency, the commissioners can serve the public interest. The Public Services Commission must represent the public's need for a livable Kentucky by demanding that the monopoly public utility make changes to act in that public interest. I believe the timing of this decision is serendipitous. You now have a critically significant piece of evidence that was not available before, the United Nations 6th IPCC report. It tells us that we are already living in a climate emergency. The time for business as usual treatment of monopoly utilities is past. The importance of distributed solar generation is enormous in this emergency, and it must be appropriately incentivized with a fair rate structure. Today, you commissioners truly have a once-in-a-lifetime opportunity to change the world, to use the rate structure to pressure KU and LLP to begin much-needed changes in their business model, to use the rudder of a rate case ruling to start turning this giant ship toward a better destination. I expect this was not what you signed up for when you took on this job, but this is what Providence is now asking of you. It is my prayer that in 2070, our descendants will look back on this decision as the moment Kentucky rose to the climate challenge and chose life over profits. Thank you for your consideration of my concerns and for your earnest deliberation in this matter.
Thank you, Ms. Girth.
Thank you.
Ms. Vinsel, is there anyone else that has signed up to provide public comment?
No, Chairman.
Okay. So at this time, we'll close the public comment session. Before we get to the presentation of evidence, we'll go to you first, Mr. Riggs, but I believe we'll take our first break at 10:30 and then plan to take a break today at 12 for lunch. That's the plan. I'm sure that's not what'll end up happening, but that's the plan. My understanding from the record is, of course, the company will get an opportunity to present its evidence today, and I think you'll start with Mr. Arbo.
Correct, Your Honor.
But I do understand that at least Mr. Barron has been requested to take Mr. Barron today. Do the companies have any objection to that?
No objection. We do have brief cross-examination from Mr. Barron.
Okay.
But it is our understanding as well that he's only available today, and we can, our proposed order of witnesses, Your Honor, is Mr. Arbo on the legal fees, and then we will turn to the net meter and QF portion of the case. Our first witness there will be Mr. Sinclair, followed by Mr. Wolf, Ms. McFarland. And my thought in general would be that at some point, at that point in the case, we could pivot and take Mr. Barron.
In between, sorry, going back, after Ms. McFarland, is that your?
If we could proceed that far, but certainly I would raise my hand after Mr. Wolf and suggest that we take Mr. Barron at that point.
Mr. Kurtz, do you have any concern with that?
No, no.
All right. And does anybody, can't promise it, but does anybody have a hard stop today? Okay. We'll plan to go at least till 5, and we'll see where we are at 5 o'clock. If we could finish up, maybe we'll go a little later, but we'll at least go till 5.
Mr. Chairman?
Yes, Mr. Fitzgerald?
Hi. The only hard stop, if we are going to stop around noon, I've got someone to pick up at the airport at around 12:15, so that'd be excellent if we'd stop around, noon for lunch.
That is
But in terms of end of the day, I have no hard stop at all.
all right, that's the plan, Mr. Fitzgerald. We'll do our best to stop by 12 o'clock.
Thanks, Ron.
All right, if there's nothing else, Mr. Riggs, you may call your first witness.
Please, Your Honor, I'd like to call Mr. Arbo.
Mr. Arbo, could you please raise your right hand? Do you swear or affirm the testimony that you are about to give is true and correct under penalty of perjury?
I do.
Okay. Please be seated. Please state your name and address for the record.
My name is Daniel K. Arbo. Work address is 220 West Main Street, Louisville, Kentucky, 40202.
Okay, thank you. Mr. Riggs, before you begin, this is something that I've asked to do, I think, at the hearing last week, and that we've done a couple of times throughout COVID, especially with certain witnesses providing testimony remotely. If you could, through your introduction of Mr. Arbo, could you just ask him what documents he's brought to the stand? And then separately, what documents he's aware of that maybe Mr. Lovecamp has to provide him throughout his time on the stand?
Forgive me, Your Honor, I should have made that announcement at the beginning of the hearing. With respect to Mr. Lovecamp, I have spoken with some of the parties before the hearing began, but Mr. Lovecamp has in his possession a laptop. There's a laptop at the witness stand, and Mr. Lovecamp has only on that laptop the record in this case, or the documents that have been provided to us by all the parties. And so Mr. Lovecamp will be assisting the witness to find the documents as they testify. And the parties and staff counsel are welcome to look at Mr. Lovecamp's laptop at any time. But we've used this convention, if you will, for many, many cases without a concern or an issue. So Mr. Lovecamp will be here through the hearing with the laptop to help the witnesses find the data responses or whatever is referred to in their examination.
And that's fine. I just
Yeah.
don't want to set a poor precedent as we move into more, as we change with technology, that it's aware, everybody's aware of what the witness has in front of them at their time of being cross-examined.
Your Honor, I think it's an outstanding practice. I commend you for asking the question. So,
Thank you, Mr. Riggs, but you may proceed.
okay. Mr. Arbo, would you identify what documents you have with you at the stand?
Yes, I have with me in a binder the items, a few of the items related to legal fees that I sponsored in data requests. I also have a copy of a part of a data response that Mr. Garrett provided in response to a data request. And I have the order that was issued on June 30th. I have a copy of the petition that was filed for rehearing, as well as my affidavit accompanied there too, as well as 3 documents that I believe Mr. Riggs had provided to parties yesterday that relate to testimony that I'll be giving today.
Mr. Arbo, do you also have access through a laptop to
I do.
what Mr. Lovecamp?
In addition to what I have in my binder, all of the electronic data responses that I had provided during the course of the case, I have access to on the laptop.
So, Your Honor, the 3 documents Mr. Arbo refers to that were distributed to the parties and staff counsel last night at about 8:30. The court reporter has a copy of those 3 documents. They are exhibits that I plan to introduce through Mr. Arbo in this direct examination.
Okay.
So, Mr. Arbo, would you state your job title?
I'm the treasurer for Lg&E and KU
How long have you been in that position?
for about 20 years now, since 2001.
Mr. Arbo, have you prepared and filed this proceeding written direct testimony and exhibits?
Yes, I have.
And did you also sponsor certain data requests by the companies in these cases, in particular relating to the issue of the forecasting of legal expense?
Yes, I have.
And have you had an opportunity to review the company's responses to PSC 1-6 and the attached documents, although you did not sponsor them?
I have.
And do those relate to legal expense?
In part, they do, yes.
Okay. What kind of information do they convey regarding historical legal expense?
There was a 12-month period. The question that was asked related to 12-month period immediately preceding the base year. And it shows the legal expenses that were incurred during that 12-month period, as well as a listing of the invoices that were paid, the attorneys, the law firms that were paid, the amounts associated with those invoices, as well as a listing of the fees that each of the attorneys charge on an hourly basis.
Did you also submit an affidavit and exhibits supporting Lg&E and KU's joint petition for partial rehearing and clarification of the Commission's June 30th, 21 final orders?
Yes, I did.
Do you adopt the contents of that affidavit and the attached exhibits as part of your testimony this morning?
Yes, I do.
Do you also adopt the data request responses you sponsored on the issue of the forecasted legal expense, including the responses to PSC 5-2 and the supporting schedules?
Yes, I do.
Mr. Arbo, who is ultimately responsible for budgeting forecast legal expense for the company?
No different than other items within the forecast. My group is responsible for that, and so ultimately I'm responsible for ensuring that the budget is properly prepared.
Would you please describe the process of how legal expense is budgeted?
Yes, it starts with the attorneys involved in specific legal matters. So they will meet with their internal clients as well as external counsel that's been hired to represent the company in those individual matters. They will go through and make an estimate of what they believe the cost will be for that particular case during the next 12 months. And this is typically done, the budget is typically prepared in the May-June timeframe. Given the timing of this case, the filing date, this was accelerated, so this would have been done in the March-April of 2020 timeframe. And so they have these conversations to determine what they believe the legal fees will be that they will incur during the next year. And then there are also a few generic areas that we regularly have cases that arise during the year, such as real estate and right-of-way type issues, fire incidents, a variety of small claims matters, motor vehicle incidents, and so there is a budget for each of those items as well that is generally fairly small in nature, but knowing that we have those types of expenses on a regular basis, we do forecast that as well. All of those projections are provided to the Associate General Counsel, who reviews them, evaluates them with respect to how much we've spent on those specific matters in the past period, how much we've spent in similar matters in the past, and evaluations are made as to whether the estimates provided by the individual attorneys are reasonable. The Associate General Counsel also looks to determine, compares the total budget to past spend that we've incurred at in prior years, and an evaluation is made as to whether or not the budget is reasonable at that point. And oftentimes there are adjustments made at that point in time, and then consolidated again and provided to General Counsel for review. Again, that same process occurs at the General Counsel level, and oftentimes adjustments are made at that level. The budget is then provided to my group, and we evaluate, again, past trends, past history to determine whether we think it's appropriate. If there are outliers, we'll follow up and inquire about why certain items might be higher than prior years. Rarely would we follow up on if there's a lower expense, but we do from time to time. And then ultimately, the budget is presented to the Chief Financial Officer and Chief Operating Officer for final internal approvals before being presented to the PPL Finance Committee for kind of a final approval.
Mr. Arbo, do the companies consider each individual matter that is then pending when the budgeting for the forecast legal expense?
Yes, we do. So each of the known cases at that point in time are evaluated independently and individually.
And how do the companies account for future or unknown matters?
Well, oftentimes we will have a case that is outstanding today, and it may be resolved before the budget period actually comes around, so that we may have put something in the budget for a case that ultimately is settled or dismissed, but we regularly have new cases arise, and we don't budget projected new cases individually, so oftentimes the ones that drop are replaced by new matters. And as I mentioned, we also have small areas where we do project small amounts of dollars that for regularly arising cases such as the real estate and encroachments, some of the initial fire investigation type claims, things like that.
Okay. How do the companies ensure they have arrived at a reasonable budget for the forecast legal expense?
Again, I think our process is been in place for many years, and we've looked at ways to improve it, made minor tweaks, but generally speaking, we believe that the numbers that we come up with, we end up with very reasonable estimates based on past history and based on our experience.
Okay. Have LG and KU used the same basic method of budgeting legal expenses for many years?
Yes, we have.
Okay. And is the forecast amount reasonably consistent with the company's historical legal expense?
Yes, it is. There's ups and downs from time to time, but it is generally in line with what we've experienced in the past. In fact, it's lower than what we saw during 2020 and the actual base period in this case.
Mr. Arbo, I'd like to hand you a document that was distributed last night to commission staff and to the parties. The court reporter has a copy of it. It is marked at the top, 5-year historic legal expense by company. In your honor, I would like to have this marked as Arbo rehearing exhibit 1.
Is there any objection? Stay. Please mark it as such, Candace. Thank you.
Mr. Arbo, is this?
Senator, do you have a copy for me, or? I want to make sure we're all on the, thank you.
We're almost to the full electronic world. Mr. Arbo, is this an updated version of the chart containing in the company's rehearing petition?
Yes, it is.
Okay. What is different?
There are two things. The amounts that were in the original filing for the periods labeled 2016 actual through 2020 actual, in the original filing, those were total company numbers instead of being jurisdictionalized. And so you can see the numbers in the first column should match what was in the original filing. In the column under KUA jurisdictional, those now have been jurisdictionalized. And so the numbers for the base period and the forecast test period remain the same, but the actual numbers for 16 through 20 have now been jurisdictionalized, and that's the only difference.
Do you adopt this chart and incorporate it as your testimony before the commission today?
Yes, I do.
Your Honor, I would ask that the chart be admitted into evidence.
Any objection? That's fine.
What does the chart tell you, Mr. Arbo, about the consistency of the forecasts in these cases with historical actual legal expense?
I think it shows there is some variation, but there is a base number that certainly is spent every year. We always have matters before us that are being defended, and the numbers certainly over the past couple of periods, the $8 million plus total number certainly leads me to believe that the 7.8 million in the test period for this case are reasonable.
Okay. Mr. Arbo, let me turn to exhibits B1 and B2 to your affidavit that were filed in support of the petition for rehearing and clarification. Do the schedules shown in exhibits B1 and B2 represent the legal matters the companies were managing or expected to manage in the future at the time the forecasted legal expense was budgeted?
Yes, they do.
And the forecasted expense for each category of legal matters?
Yes, that is correct.
And do the schedules reflect that some matters have been resolved by dismissal, settlement, or otherwise as of the time this was prepared?
Yes, they do. As I referenced earlier, that does happen.
Does that mean the companies will no longer incur legal expense for those matters?
Not necessarily. There may be situations where we're monitoring appeals, things like that, so there could be ongoing expense.
And have other legal matters arisen since the forecasted budget was prepared?
Yes, they have.
Can you describe in general terms the number of new matters and the nature of them?
Sure. We have a series of items that have been, we've been made aware that claimants have engaged counsel, but they have not filed suit yet. In those, there are 5 new KU fire incidents and 1 flood matter. For Lg&E, there are 10 cases, and those, for Lg&E, there are 3 new cases, 1 property damage, 1 contractor fatality, and there's 1 explosion case.
Based on your experience as the treasurer of the companies, do those number of cases seem to be high, low, or typical?
I would say they're typical. In addition to what I've mentioned, there are also cases where claimants have actually made filings, and so there are new claims, 6 new claims for KU, 5 fire and 1 flood, and then there are 10, or the cases that have actually been filed. There are 3 cases for KU. 1 property damage, 1 instance of line contact, and I believe the other one is related to personal injury. And then for Lg&E, there are 7 cases, 2 motor vehicle, 2 personal injury, 1 explosion, 1 subrogation, and 1 property damage case.
And I believe you said this, but are those cases, those new cases, is that a typical level of cases?
My understanding is that it is typical with what we've seen.
Do you have any additional evidence to present today reflecting on the matters contained in those schedules?
Yes, we do have updates to Schedules B1 and B2 that show actual base period spend.
All right. Mr. Arbo, I'm going to hand you the updated schedules to Exhibit B1 and B2 in paper medium. These were distributed to all the parties and council last night at about 8:30. I believe the commissioners, you have a version of these with you. The court reporter has a copy in paper of each. All the parties have at least electronic versions of these documents.
That's fine.
Your Honor, I would ask that these be marked as Arbo rehearing exhibit, direct exhibit 2, and Arbo rehearing exhibit direct 3.
2 and 3.
Yes, sir.
That's fine, Mr. Briggs, please continue.
Thank you. Mr. Arbo, can you describe the initial table showing the base period by category?
Yes, so the initial table has the same categories that were provided in the initial filing, and we're now showing the test year amounts in the right-hand column and the non-jurisdictionalized amount that was actually spent during 2020 in each of those categories. And so for KU, the non-jurisdictionalized base period spend was $5,332,767. And for LG&E, the base period spend was $3,020,309.
Are those base period figures jurisdictionalized?
They are not.
Okay. How does that impact the comparison?
Well, if we were to jurisdictionalize the KU numbers, they would be slightly lower. Roughly 90% of the KU expenditures would be assigned to Kentucky retail customers.
Why are the figures for certain base period amounts not available for certain matters or categories?
Well, again, this was during the base period, so it reflect expenses through February of '21. So there may not have been any activity on those particular matters during the 12-month period shown here. And so there would certainly be situations where there has been spend since that point in time. But again, for the period March 2020 through February 21, there would not have been any spend.
Okay. What does this additional evidence say in these exhibits that have been marked ARBO, direct, rehearing 2 and 3? What does that say about the reasonableness of the company's projected legal expense in the forecasted test period for these cases?
Again, I think it shows that the forecasts that have been made certainly are reasonable based on our past experience and what we've spent in cases during the base period.
Okay.
Mr. Riggs?
Yes, sir.
I'm sorry to interrupt, but I think we may be having some technical difficulties. So if we could, for a second, Candace, do you mind we'll go off the record for just a minute.
Yes.
Put us back on the record, please?
Yes, sir.
All right, we're back on the record. We had some technical difficulties, so I've asked Mr. Riggs to re-ask the last question that he asked and then to continue with this direct examination. Mr. Riggs?
Thank you, Your Honor. Mr. Arbo, what is the additional evidence presented in the exhibits Arbo, rehearing, direct 2 and 3? What does the additional evidence in those exhibits say about the reasonableness of the company's projected legal expense in the forecasted test period in these cases?
Again, I believe that it shows that the estimates that we've made for legal expenditures are reasonable in light of what we've spent during the base period that is presented here.
Do you still consider the forecasted expense presented by the companies in these cases as reasonable as you're testifying today?
Yes, I do.
Okay. Would you make any adjustments?
No, I would not. We're just 2 months into the test period, so I would not make any change.
Your affidavit stated that none of the matters listed on Schedules B1 and B2 to your affidavit involve any willful misconduct subject to KRS 278-990. Is that correct?
That is correct.
Is that still true today?
Yes, it is.
And do any of the new matters you referenced earlier in your testimony, which are not reflected in exhibits B1 or B2, or the updated versions of those, marked as rehearing ARBO Direct 2 and 3, involve any acts or omissions subject to KRS 278-990.
They do not.
The witness is available for any questions, Your Honor.
All right, thank you, Mr. Riggs. I'll just ask, I suspect there isn't any, but is there any cross-examination from the Attorney General's office on this issue?
No.
Okay.
No, Your Honor, no questions.
All right, thank you, Mr. Cook. KIUC?
No, Your Honor.
Mr. Spinard?
No questions, Mr. Chairman.
Mr. Miller?
None, thank you, Your Honor.
And Mr. Fitzgerald?
No questions, Your Honor, thank you.
Ms. Vincel, any questions?
Just a very few. Good morning, Mr. Arbaugh. I would like to follow up on Mr. Riggs' question, one of the last ones, regarding the forecasting, saying that none of the matters included in the forecasted legal fees involve actions or omissions subject to KRS 278.990. Could you expand upon what you mean by that?
Well, again, I believe that in the matters that were listed, we did, before signing the affidavit and before submitting the additional information today, confirm with counsel throughout the company that none of the matters here were in violation of that statute.
Okay, and I recognize that you're not an attorney, and I'm not asking for a legal opinion, but that particular statute establishes civil penalties in the case of violations of statutes and regulations the commission enforces in orders. So, in regard to something like a greater issue of negligence, would issues like that also have been omitted?
I do not believe so, no.
And I want to follow up on something I believe I may have misheard. In regards to filing invoices into this case for legal fees, did Lg&E KU file legal invoices for legal services?
We did not provide copies of invoices. We provided a listing with invoice numbers and the amount paid.
And recognizing that this was Mr. Garrett.
Yes, and that was for the 12 months prior to the base period.
Yes. I can read this into the record, but I think it might be most helpful if Mr. Lovecamp could bring up for you Lg&E's response to the Commission's first data request, question number 6.
Any particular company, Lg&E or KU?
Either one.
Okay.
I believe it's pretty much the same response.
Okay, I have access to it here.
Okay. Now, in this request, Lg&E and KU in each of the requests were asked to provide a detailed analysis of expenses for professional services for the 12 months preceding the base period. Moving forward, the sentence reads, if you see this in the question, at a minimum, the work paper should show the payee, dollar amount, reference such as voucher number, account charged, hourly rates, time charged to the company according to each invoice, and a description of the services provided. Would you agree that's what it says?
Yes.
Can I have Mr. Lovecamp scroll down to attachment 3 to the response to PSC 1-6?
Okay.
And I'm just going to look at the first page. Now, this is, I believe, the list that was provided, that was compiled from the invoice. Is that correct?
This is the list of attorneys and the rates that they charged.
Yes. So we've got, just for those who don't have this visible, this includes the name of the firm providing legal services, the attorney, paralegal staff providing the services, the rates, which are confidential, the timekeeper's title, and there's a final column that says 2020 rate increase date. Can I ask where, if you look on that very first page, some of the entities have the date October 1st, 2020, and others say 2020 rate increase was not requested. So is it the case that for the items that the rate increase was not requested, that those were omitted from computing a forecasted legal fee? Or can you explain what that means?
That just means that the attorney did not request an increase in the rate that they were charging during 2020.
Okay, I understand. Thank you. Thank you for that clarification. One of the items that Lg&E you were asked to include was a detailed analysis. Would you agree with me that there's no detailed analysis of the service provided on this list?
Again, there was a listing of the invoices paid. It's separate from this, but there's a listing of the invoice, the amount of the invoice, and this listing here, and all of that is consistent with what we've provided in prior cases to this same question.
And be that as it may, I'm asking, was it a detailed or description of the services actually provided in the data request?
No, it was not.
Okay, thank you. Staff has nothing further.
And Ms. Vinsel, we said in our petition for rehearing that we'll provide whatever information, subject to the claim of privilege, the commission needs. Now, the responses that were provided in December, when that data response was answered, is in the same format that we have answered that question for the last 3 rate cases. And in every one of those cases, we have never been advised that that answer was deficient or not acceptable. Now, if that answer today is something that the commission needs the company to supplement, the company will do that. The phrase detailed analysis is not giving us notice of what the commission wants. And if you will share with me today what information is missing from that response, if any, then we will do our very best to provide that to you forthwith. The disposition of this issue should not turn on a lack of communication between the company and the commission. The disposition of this issue should turn on the evidence and the issue itself. And so are you asking the company to provide the invoices? Are you asking the company to provide a description for each of the matter or the services rendered? What is the commission asking?
Let me ask this question, Mr. Riggs, if you mind.
Please.
Because I think you're asking me and Vice Chair Cubbage more than you are asking Ms. Vinsel. The question specifically said to provide a detailed analysis. And then part of it said at a minimum, to provide the work papers, or at a minimum, the work papers should show the payee, the dollar amount, reference, including i.e. the voucher number, the account charged, the hourly rates and time charged to the company according to each invoice, and a description of the services provided.
Okay.
The description that's provided in the response is merely professional services. By definition, the question references professional services provided pursuant to that schedule, Schedule B, which is professional services, right? Isn't that what that schedule details?
Your Honor, the companies are trying to cooperate fully.
I understand.
And we're trying to communicate with the commission about what it wants. Now, without re-arguing the petition for rehearing, that's been granted, and the hearing today is to consider this. If you're asking us to provide a more detailed description by each of those items of the services were provided, we will provide that to you. But we have to communicate, we are trying to understand what the information is that you want. And if that is what you're asking through this question, then we will provide a post-hearing data response with that information.
Okay.
Are you requesting that? We'll provide it.
We'll request it in writing if we're going to request it.
Well, I want to provide all the information that the commission needs to adjudicate this issue. I do not want to have any further differences with the commission, if they can be avoided, as to what the commission is seeking and what the company is providing. We have a long-established history of not having discovery disputes with this commission. That can't be questioned. We don't have discovery disputes with the parties. You rarely have a motion to compel in cases involving ours. We go as far as we can to provide information. And I'm certainly willing to provide that information to the commission.
Well, let's finish our examination of Mr. Arbo, and then we can have this conversation on the legal front. Is that fine?
That's fine.
Okay. Ms. Covens?
No questions.
Okay. So I do have a question to what we were just discussing. Item 1.6 specifically asked for the detailed analysis and then indicated what the detailed analysis at a minimum would include. Is that right?
Yes.
Okay. And then the companies were, that's for base period costs, correct?
The 12 months prior to base period.
12 months, 12 months prior to base period cost. And then in the staff's fifth set of questions, there was an interrogatory or request regarding the test year expenses, correct? For legal fees?
Yes.
Okay, and do you know what data request response that was?
It's the fifth request, question 2.
That's right. So, does Mr. Lovecamp have the fifth request?
Yes.
Item 2? And just let me know when you have it in front of you.
I have it.
Okay, great. And do you mind to read the question that was in that fifth request, item 2?
Refer to the application, tab 59, schedule F6, professional service expenses, page 8 of 10. Provide a detailed analysis of the budgeted legal fees for the forecasted test period.
Okay. And the company provided, and I think this is your response, is that correct?
Yes.
Okay. And you provided effectively the chart that is shown at the top of B1, correct? Or something similar to it that breaks it out amongst 5 or 6 different cost categories for the test year, correct?
That's correct. In addition, in each section, we provided a list of cases, individual matters that were included in the forecasted amount.
Right, so let's just start at the top.
Yep.
The top of it was, do you mind to read those categories that you listed at the top?
Sure. Litigation, regulatory, environmental, employment, real estate, corporate, and other.
Okay. And then below that, you listed within each one of those categories matters, or I think you described them earlier as generic categories. I think that's the term you used. Sorry, I want to be accurate. Generic areas, I think, is what you had noted. Things like fire, casualty issues, vehicle accidents, correct? You listed those individually, either specific matters or those general topics under those 5 or 6 categories, right?
There are specific cases, and then there are some areas that are general to your point, the generic areas that you mentioned.
Okay. Could you have provided any more information on that item?
I think the question that arose in our preparation was whether or not the items where there are individual matters provided, whether there was a privilege issue there.
Okay, and a privilege issue to all the information or a privilege issue to some of the information?
To the amount that was budgeted in each of those areas.
Okay, so did you all have any discussion that there was other information that could have been provided that was not other than the concern about the privilege regarding the amount of each matter?
I don't recall that we discussed providing other information until in the preparation of question 5 too.
Okay. So you walked me through, I just want to sort of summarize, because it was good testimony. I just want to make sure, it's clear that the way you calculate, the way the companies calculate the test year legal fees are that the attorneys on the ground effectively meet with clients, make an estimate of each case. That's for specific matters. And then for generic matters, you kind of have, you know what your past experiences has been. You have a reasonable anticipation of what the generic issues are going to be moving forward. But for specific matters, the attorneys meet with the clients and make an estimate of the case. Those estimates are then provided to the, I think you said, the Associate General Counsel, who compares those estimates to the amounts for past cases, kind of a reasonableness check in their own opinion based off their experience. Then those amounts are then provided, whether they're amended or agreed upon by the Associate General Counsel, provided to your division, who then reviews them again, same deal, for reasonableness based off previous expectations or future expectations. And then there's a CEO or CFO or both review again of that budget plan, which includes those legal fees. Is that accurate?
There is a step there where the general counsel is involved after the associate general counsel before they come to me, and then the final review that you mentioned is COO and CFO.
COO, okay,
Yes.
excuse me. So it's a C-level review, C-suite level review
Yes.
between the COO and the CFO. And you said that each known matter is taken into account in coming up with that budget, is that right?
That's correct.
Okay. So for cases in which the attorneys on the ground that are litigating the case expect the case will settle, is that amount included in the amounts that they pass, the estimates that they've made for those cases?
When you say that they assume the case will settle, are you referring to the legal fees or the settlement amount?
The settlement amount.
The settlement amount is not included.
Not included. And in the case that they expect it to settle, they will not include an estimate of legal fees that would be reflective of litigating the case. Is that accurate?
That is correct.
Okay. And so if the case settles, are those amounts included in any test year expenses for the companies?
We do not assume settlements in any of our forecasted test amounts, if you're talking about the actual payment of a settlement.
Okay. And so for, forecasting, for the most part, especially what you do, a lot of it is based off of, it's kind of like rate making, right? It's based off of a known period updated for future periods. Is that fair?
Yes.
Okay. And so are settlements that are paid in the past taken into account at a baseline level when setting rates or proposing rates in the future?
We have injuries and damages amount that if there were actuals paid in the past, that we do project those going forward. Again, that would be more on typically more minor type situations, slips and falls and things along those lines. So that would fall under injuries and damages.
Okay. And that is or isn't taken into account in the company's proposed test year?
That is.
Okay. And it's a past amount, just pulled forward?
It would be a projected amount primarily based on historical results.
Okay. Where is that amount located?
I believe it's in account 925. It's 925 or 926.
Okay. And then Ms. Vincel was asking questions about the KRS 278-990. Have you ever reviewed KRS 278-990?
I have not.
Okay. And so who made the assertion that, well, let's go back. You have your affidavit with you?
I do.
Okay. And you make an assertion regarding 278-990, is that right?
That's correct.
All right. And what is that assertion?
None of the matters shown on Exhibit B1 and B2 involve actions or omissions subject to KRS 278-990.
Okay. So how can you make the assertion that they don't relate to 278-990 when you've not yourself reviewed 278-990?
I surveyed the attorneys involved in the case to get their verification that there was nothing that involved those actions or omissions.
Okay, and I guess really the question is, are you making the assertion that you shouldn't be penalized under the penalties? Because 278-990 is titled penalties. So is it an assertion that there should be no penalties for any act, or is it an assertion that based off your discussion with company counsel or counsel for the company or whatever it may be, that it's your understanding that the company is unaware of or currently litigating or has forecasted no litigation expenses relating to a violation of a commission order or commission regulations or commission statute?
My understanding is that the cases that were listed in the exhibit and that were used to prepare the budget, that none of those cases involve an action or omission subject to the KRS statute.
Okay, so that is helpful. So if hypothetically, if there's a claim or a matter in the listing that you provided for the forecasted tax year, that somebody is claiming that in some tort claim that the company or its agents, acted willfully and led to some sort of injury, right? If the commission thought that any of those specific cases, that it's unreasonable for customers to pay the litigation or legal fees related to it, right, is unreasonable. That it's unreasonable for the company's customers to pay for the litigation related to that matter. How would the commission have made an adjustment for any of those specific matters?
Again, if you're asking if subject to KRS 278-990 or separate and apart?
Any of the list that you provided, I think in response to staff DR 5-2. Let's just say one of them was John Smith versus Lg&E or John Smith versus KU, right? And under the facts of the case, we thought it was unreasonable for the companies to recover their legal fees in defending that claim. With the information provided by the companies, how would the commission make that adjustment? What amount would that adjustment be for that specific claim based off the information provided by the companies?
I don't believe that you would have had the information available to do that for a single claim. I do think that disallowing all of them would penalize the company.
Okay. So, Mr. Riggs, these are the legal questions that I have, and I think the order reflected that we have some questions on the petition. Ultimately, the petition puts the commission in a catch-22. And I think the companies have asserted that, and I'm paraphrasing, that privilege on this issue and the determination of the reasonableness of costs are not mutually exclusive. And I don't know how that isn't the case. So I'm just curious, to the question that I just asked Mr. Arbo.
Sure.
I think the companies have asserted legally, using I think a New Mexico case, that it was arbitrary for the commission to deny the cost of all legal expenses in light of not knowing the individual amounts or not being able to make some smaller or lesser determination of what the company should or shouldn't recover in terms of legal expenses. So without the information provided, to the question I just asked Mr. Arbo, how are those two things not mutually exclusive in the confinement of KRS 278?
First, Your Honor, the commission has a complete record, a substantial record of evidence to judge the forecasted legal expense for each company. The question is whether that forecasted legal expense for each company under the commission's standard, under its regulations, is reasonable, reliable, and made in good faith. And the record shows that. To look at matters on an individual basis in a forecasted test period is not appropriate Because if you're looking at allegations, those are simply allegations. Those are not proven allegations. In your hypothetical, Mr. Chairman, where you said it was Smith versus Lg&E, and that there's some allegation that the commission finds to be problematic, that's all it is an allegation. It is not established until that case goes through the court process and is determined. Allegations are made in complaints all the time, but that's all that they are. That is not evidence in and of itself that provides any substantial evidence, any credible evidence that meets the legal residuum test for any type of disallowance. A mere allegation in a complaint does not rise to that level. It is simply notice pleading.
But I just want to make clear, you're arguing about the reasonableness of evidence or the presentation, that the company has met its burden of proof pursuant to it. That is a separate evidentiary issue as far as I'm concerned. My question is what the law requires, right? The assertion was that the commission's actions in denying the entirety of the amounts, right, in absence of individual amounts, or the ability to make a determination that some lesser amount based off additional evidence or evidence that's in the record was arbitrary. And my question is, if the assertion is that it's arbitrary because the two amounts are not mutually exclusive, under what Kentucky law is that decision arbitrary to make an adjustment of the entire amount without the benefit or opportunity or evidence to make a lesser adjustment?
The record provides the commission the opportunity to make a lesser adjustment. The commission can't look at the first test line for this, which is the base period update. That is the direction the General Assembly gave the commission when it provided the utilities the right to use this forecasted test period. And we provide a base period set of information at the time the application is filed, and that can be compared with the forecast to see what differences there are. And then we also provide a full base period update for the 12-month period, in this case, ending February of 21. And that base period can be compared to the forecast to see if the forecast is excessive, really high, or low compared to the actual. And based on that, the commission can make a judgment as to the legal expense. The commission can make a judgment based on the legal expense, based on the historic occurrence of legal expense compared to those forecasted legal budgets as well. And the commission can determine based on that the forecast is high or low or needs to be adjusted based on that kind of historical comparison. The commission could look at the matter descriptions to see whether any of these matter descriptions raise any issue of intentional violation of the commission's statutes. And in this case, the evidence is that they don't. The commission has the hourly rates and the firms for the services. If the commission would like to see the invoices that the company has for this, those will be provided. But the commission has all of that information. But your hypothetical, Your Honor, is trying to take an inappropriate analysis of a forecasted budget to look at it and say, well, if there's a piece of that that has an allegation of negligence and we want to remove it, then how do we do that? But the ultimate question is that estimate reasonable? And is that in violation of that statute?
Well, isn't the ultimate question if recovery of that expense is reasonable? That's the base question, correct?
The ultimate question, Your Honor, is whether that forecasted amount by company, under the commission's regulation, it says reasonable, reliable, and made in good faith. And the evidence in this case, the sworn testimony, is that it is. It supports all that. The details of how all of that have been provided. Is it a reasonable estimate? That is what the commission is to judge. And it cannot be that the company's burden of proof is, has to be carried by waiving privileged information. That's arbitrary.
So other question, Mr. Riggs, is under what obligation is the commission under, this is your question about communication, I think is what you called it earlier. What obligation is the company under to provide full and complete responses in a timely manner? And the basis for the question is the comparison between the question in the staff's first DR and the staff's fifth data request. In that in DR 1.6, the commission asked for a detailed analysis of those, I think Mr. Arbo correctly said, the 12 months preceding the base period for professional services, including legal expenses. And it detailed, explained, at a minimum, this detailed analysis will include, and then listed, I think, the items that Ms. Vinsel named earlier. In the fifth response, the commission staff side, question 5.2, I believe, a detailed analysis of those legal fees in the forecasted period. And the information provided was a breakout by category and an individual listing of each matter. None of the other information that was included at a minimum in the first data request earlier, and that doesn't include our questions about the professional services description for a detail of the description of each matter, right, or of each cost. We were talking about earlier that it's column D or E where it just said professional services for item staff 1.6, right? Forget that for a minute.
I'm not trying to argue with Mr. Chairman. You're losing me.
Under what obligation is the company under to provide? Commission staff asked for a detailed analysis, right? The company chose to respond in the way that it did. The company could have responded with more or less detailed analysis than they did.
But
Under what obligation is the company, with the party with the burden of proof, what obligation are they under to provide the amount of information necessary to base the reasonableness of the rates?
The company, Your Honor, has provided the detailed analysis. Now, there seems to be a difference of opinion in your hypothetical as to the degree of the detailed analysis. Now, it has been the practice before this commission that if the response to a data request is not sufficient or did not provide the information, it has been the practice of this commission, consistent with due process, to, in a subsequent data request, to say, you provided a response and in it this is omitted, or you provided this and this is not what we sought.
Can I ask a question?
Please.
How many chances does due process require? And what I mean by that, and I'm not talking about this instance, but let's say the commission's come back 5 times or the staff has come back 5 times and asks, I need additional clarification. At what point is due process discharged?
In your hypothetical, Vice Chairman, where the staff has asked 5 times and repeatedly been refused, I agree that that illustrates the due process. There's a stonewalling to going on with that situation. But in this case, there's no stonewalling. The company has tried to answer what is, not a very precise question, a detailed analysis. What does that phrase mean? Now, we can all have a good faith disagreement or a good faith interpretation that's different than what that phrase means. And if that question is asked, we want to answer that question, subject to our claim of privilege. And if it's not sufficient, then due process does require the commission to tell us that's not what we need. We need this additional information. Now, if the company repeatedly refuses that, the applicant repeatedly refuses that, then there's a stonewalling effect for no reason. Now, in this instance, when the question was asked to us at the hearing and I made the objection, I took the then chairman's position to be accepting of the objection as long as I provided support for that, which is a fair position. If you object, you can't just say I object on privilege. It has to be supportable. And we provided that authority in the post-hearing data request. which was identical to the question that was asked to us. At no time was the question posed to us that your answer to this is not sufficient. This is what what the commission wants. And that is what due process requires. Due process does not create a game of gotcha. Due process creates a fair notice in exchange. And as we said in the petition, we were not aware that the commission wanted the information that it identified in its order until we had received that order.
No, let me be clear. Your petition didn't say that. Your petition said that there was a portion of the items mentioned in the order that the commission had not previously requested. But with regards to the items that, the costs that you've asserted privilege, you're not arguing that the companies weren't on notice that the commission sought that information. Correct?
Wait a minute, Mr. Chairman. Now, if you're going to ask me questions respectfully, you got to do it in a way that's not argumentative and that I understand.
I'm not. But the petition identified two types of information, right? The costs, the amounts that were requested in the post-hearing data request, and I think what you're referring to now, the other types, like the type of matter it is, the
qualitative description.
the greater description of the individual matters. And what I'm trying to be clear about what you just said, you're not speaking about the cost side, you're speaking about that second category of expenses. Is that fair?
The order for the first time told us that the commission was seeking that qualitative information. We were not aware of that until we received the order. That's what we said in our petition. And once we received that in our petition, we filed that information with the commission. We have every incentive to do that if we have the burden of proof in this case. If it's not privileged, we want to provide that information.
The other question about due process
But let's come back to this phrase, this detailed analysis is not a phrase, it is a phrase that can be subject to interpretation.
That's fair.
Reasonable minds can disagree, or reasonable minds can just interpret it differently.
That's fair. That's why I asked Mr. Arbo about it. I think that's an evidentiary issue. It's not a legal argument. My last question on due process as to what due process requires, and I think this goes to what Vice Chair Cubbage was asking, and I think your response. I think the 5 times I think is a extreme enough of example, right, on one end. But the companies were asked a question at the hearing, and you asserted orally the privilege argument, and the chairman at the time asked you to put that into writing, right? The companies had any opportunity for the next, 10 or 14 days to assert that privilege. And the final day that the data requests were due, in the afternoon, the company finally, in written form, made their objection to the data request response. So what position does it put the commission in to afford a company due process on the due process front? Because
when did the commission change and tell us the question and put greater clarity to it? The commission continued to ask the same question without telling the company what information it meant by this detailed analysis.
Mr. Ricks, I'm not asking about the detailed analysis. I'm asking about the post-hearing data request that sought the costs for
And the
each individual
post-hearing
matter.
data request, Your Honor, was identical to the question that was asked to us in the hearing.
That's right.
And we did not see a difference between the question that was asked in the hearing, the objection that we made. We saw the post-hearing data request as simply asking us to confirm our authority for the objection.
But I think you argued in your petition that due process required at the time that the company filed their privilege claim in response to the post-hearing data request, that the commission should have ruled on the objection request and then recite the information that it needed in order to make its determination. And my question, please let me finish. And my question is, under due process under Kentucky law, what obligation is the commission under if the companies waited until the final day of evidence to assert that privilege in writing?
The Argument that was made in the petition was broader than that, Your Honor. The argument in the petition suggested a number of ways the commission could have avoided this. The commission, after the fifth set and receiving that response, if that was not adequate, the commission had and did issue a sixth set. No mention was made in the sixth set of the data requests about any of the response in the fifth or to the first being inadequate. And the commission could have addressed it that way. The commission could have asked its counsel to discuss that with us. If we're not providing this information, this conflict was avoidable. We have a right to that privilege. I don't think there's any dispute about that work product privilege. And we can certainly cooperate with the commission through a variety of appropriate means to resolve that discovery dispute. And due process does require that. The use of the phrase detailed analysis, as we've discussed, is a phrase that can be interpreted differently by different people. It's an ambiguous phrase. Now, our record before this commission is not one of non-cooperation. Our record before the commission in this case and for years has been a company that has come forward with information and provided it. We have provided more than our share of information that's hardly relevant. We have provided thousands and thousands of documents in this case. Cooperation and discovery with this company is not a valid issue. And there was a resolution to this that the company and the commission could achieve through other means than the means that the June 30th order took. Now, the answers to the commission's two data requests, which seem just to repeat without changing the phrase, were not the information the commission needed. The commission should have told the company that. Do we have a right to understand if the commission is pursuing an issue? We have a due process right to understand that issue. And the issue is being raised by the commission. And if what the commission is providing to us is not sufficient notice of that issue, then that's where we have a due process right.
I agree that the law says what it does about notice and opportunity in regards to due process. I'm just simply seeking clarification on the company's position regarding due process at the time it chose not to waive its privilege, much less unartful than I'd like to be sometimes. When it chose not to waive its privilege and asserted its privilege at the end of evidence and in response to the post-hearing data request. And my question is, from the company's perspective, with regards to that instance, what is the company's perspective? What's the legal obligation of the commission with regards to due process? How would you have sought the commission to act upon that response of privilege on the final day of evidence in order to, in your argument, ensure that the companies have due process on this issue?
Certainly the commission could have rephrased the question in the post-hearing data request to be clear about the information that it was seeking. The commission knew from the exchange that I had with the then chairman, the company had an objection to the specific information that was being provided. And the company and the commission both knew that the company was going to provide the authority for that assertion of the privilege, which it did. Now, if the commission still had a concern with the legal expense or the lack of information, it had a duty to notify us of that. We had provided information consistent with all of our previous cases to the commission on this information. And not once were we told that the information we provided was somehow deficient or not what the commission wanted in the discovery responses.
So you say the commission should have notified you. So what is the company saying that the commission had to do upon receipt of that formal assertion of privilege on the final day of evidence in the case.
The commission knew of our assertion of the privilege. That was reasonably expected when we were to answer the same request made at the hearing. So it seems to me the commission could have asked us in a second data request, provide us a qualitative description of all of these matters. Provide us all the information you can about these individual matters that is not privileged.
When?
The commission could have done that when it issued its post-hearing data requests.
Take it a step back, Mr. Riggs.
You knew the objection was there.
You asserted privilege, and the chairman at the time specifically asked for support for that assertion, right? There's nothing to say that you don't go back and do a Westlaw or a Lexis, I don't mean to choose a brand here, that you go back and do the legal research and determine that there is not a privilege assertion, and that the information is not privileged, right?
Work product is privileged, Mr. Chairman. This is basic form of law.
Work product may be privileged, but what I'm saying is, in specific instances, you may go look at the law and say, well, the Supreme Court has ruled previously that this is not considered to be work product, or it is not privileged. The law dictates whether something is privileged, not the assertion of privilege, right? So you stated that you were asserting as an objection privilege. And then when the data request was filed at the end of evidence, you provided support for that assertion of privilege, right? You provided legal support for that
That's
objection.
correct.
That's right. On the final day of it, so are you saying that when the commission finally received support for your objection, the commission should have then entered an additional data request seeking other information to make its determination?
That is one of several options the commission had. The commission could have asked for this information after receiving our response to the 5th. The commission could have pursued the question with us on the record at the hearing. The commission, through its staff counsel, could have had a discussion with the company off the record appropriately with the parties. It's a discovery question. The commission could have asked another data request in that post-hearing data request set that said, notwithstanding your privilege, provide us all information that's not privilege, that supports your legal expense in the case.
And
Those all options were available to the commission.
And my question is, the commission would have had to take any of those avenues in order to provide the company, it's your assertion, due process under state law.
To provide the company notice that the commission expected more from this phrase detailed analysis than was discussed at the hearing.
Not that its legal fees were at issue in the case.
I'm sorry, I don't understand your question,
You're
Chairman.
saying specific to that information, but you're being very specific about what the company has to be or doesn't have to be on notice of with regards to the commission's inquiry. The commission's inquiry into the company's legal fees. You're being very specific as to this detailed analysis or as to those costs in which privilege was asserted. But the broader item that the company was on notice of following the first data request from staff was that its legal fees were at issue. If not, the company was on notice the fact that legal fees and professional services are required to be broken out by schedule in the minimum filing requirements.
And the company did comply with those minimum filing requirements, and the commission found that the company had complied with those minimum filing requirements. And the commission asked that question in the first set of the data request, as it typically does in our rate cases, and the company's provided its answer that it typically does to those data requests. It's been acceptable in the last, 3 forecasted test period cases, and probably historical cases as well, cases supported by a historical test period. And the company has tried to answer the commission's questions. But yes, I come back to that phrase, this detailed analysis. It's an ambiguous phrase. And if it's subject to interpretation, and if that's not providing us notice as to the specific information that the commission now has said in its June 30th order it wanted. And there was any number of opportunities for that to be resolved.
Ms. Covey, did you have any more questions?
Chairman,
1 second, Mr. Kurtz.
So I have one comment before your comment, Mr. Kurtz.
If we could all just hold on 1 second.
Yep, I'm on.
My last question, Mr. Riggs, is maybe it's a factual question, maybe it's a legal question, and feel free to say you're uncomfortable asking. But from the company's perspective, does it make a distinction, or is there no distinction between the commission putting the companies on notice through some formal order or through a question from the 3 commissioners at a hearing versus questions from commission staff? Is a question from commission staff, let's say the detailed analysis, let's say it was more specific than that. For purposes of due process, the questions from commission staffs, can they, I'm not saying in this instance, but can they, from the company's perspective, satisfy that due process issue of notice?
If staff requests information from the company at a hearing, the commission's practice has been to confirm those requests in the post-hearing data requests. In this instance, the post-hearing data request was identical to the question the commission staff counsel asked at the hearing. So the notice provided by that question at the hearing was identical to the question provided in the post-hearing data request, leading the company only to believe that it was to provide its authority for the objection based on the exchange it had with the chairman, and that was a sufficient response. And had the commission communicated that was not, we certainly would have provided the information. We will provide the information you asked for today, notwithstanding our privilege, to the further exchange I had with your staff counsel. If there is further information the commission would like the company to provide, we will provide it as long as it doesn't violate our claim of privilege.
And Mr. Riggs, I'm asking a broader question. I'm asking if in the most detailed way, commission staff asks a question about a generic expense in the test year, does the fact that commission staff asked that question, sought that information, they can seek 5 questions about it subsequently to seek additional information. Does that satisfy from a due process, from the company's perspective, the due process notice requirement on behalf of the commission staff inquiring on those issues?
Depends on how the question is asked, Your Honor.
I'm saying there's no argument that that there's notice that somebody's wanting information on that issue, right? And they're very detailed about how they're asking it. I want to know, is it the company's perspective that the commission themselves, through an order or from the stand, has to provide some additional notice of an issue, or is adequate discovery by commission staff enough to satisfy the due process requirements under law?
Your hypothetical, the assumption to your hypothetical is that original question is detailed enough that it's reasonably calculated to inform the person receiving the question of the purpose or of the issue. And that is the fundamental difference in this case. To say that we want a detailed analysis is not reasonably calculated to inform the company of exactly what the commission is looking for. And so the company provides what it considers to be that detailed analysis. And if that is not sufficient, there is a way, in accordance with due process, to correct that, to carry forward with that. But due process and the exercise of commission power should not be kind of a gotcha experience. We're asked to provide a tremendous amount of information, and the companies do in this case. The record on this is just voluminous. And you have not had one discovery dispute before that you've had to adjudicate in this case. The motions to compel in our cases before this commission over years, you could count on one hand and have fingers left over.
I appreciate that. And I appreciate that you've made the distinction between the question and what you perceive to be in this case. But my question stands, from the company's perspective, can Objective. No argument that you were provided adequate notice from a staff data request. Does that satisfy, from the commission's perspective, as an adjudicatory body, that you were on notice of an issue for purposes of due process in a case before the commission? That's what I'm asking.
And only if that question is reasonably calculated to inform the recipient of exactly what is being requested.
That's fair.
And if the question uses phrases like detailed analysis that we've discussed that are subject to interpretation and ambiguous, that is not due process.
Just want to get to the point though. I just want to make sure we're all on the same page about this very specific issue. From a legal perspective, I'm not quibbling about the words used. I'm saying the question unambiguously, just objectively put a party on notice, right? A staff question. Does that satisfy notice from the commission's perspective for an applicant in front of the commission, from the company's perspective?
Your Honor, I have seen the process unfold here well enough to know that unless I'm specific, my answers to broad questions can be deemed admissions by the commission when it adjudicates. Now, notice that's reasonably calculated to inform provides and satisfies due process. In this instance, the phrase detailed analysis was not reasonably calculated to inform, clearly because of the difference of opinion that we're having into what was the commission seeking.
My question is actually broader, and what I'm trying to get to is, I'm speaking for myself. This is not a leading question. I'm making a statement. I read in your petition, I'm paraphrasing here, but the commission needed to put the company on notice that this is an issue, right? And what I'm seeking is for due process, is the company arguing that due process obligates the actual commission to put the company on notice of a particular issue in which the company, I think, again, paraphrasing, but runs the risk of having a cost disallowed. Are the companies arguing that something explicitly has to come from the commission to put the applicant on notice?
Due process requires that the company be put on notice what is at issue and have the opportunity to present evidence on that issue. In this instance, the phrase detailed analysis, the company tried to provide the evidence the commission asked, and is certainly willing to provide the evidence that the commission is requesting. Now,
At this point, all the questions that have been asked have been from commission staff. Even if asked exactly the way you would have sought them to be requested, I'm asking, are there additional actions that a regulatory body has to take itself, not through, its staff propounding discovery or data requests, to put a company on notice that certain rates are at risk of being disallowed?
yes, all right. And if the response to a data request is a fair response, but doesn't fully meet that data request in the eyes of the person the commission that propounded that data request, then the commission has a duty to look at that data request and say, did that data request reasonably calculated tell the person that this is the information I sought? Now, if the person responding to that has a record of fully, fairly, and consistently answering discovery without dispute and cooperates fully, that should be taken into account in measuring that response. And that is the established reputation of these two companies in its discovery. And if the discovery response was not meeting the intent of what the language was in that data request, then yes, the commission is not notifying the company as to exactly what it's seeking in the data request and what the issue is. And there were a number of opportunities to remedy that. And the commission has used those in previous cases.
I appreciate it, Mr. Riggs. You said you wanted to add something additional before Mr. Kurtz spoke?
To the earlier exchange at the beginning about the request for additional information with respect to PSC 1-6, I'm asking now, is there additional information the commission would request?
I think we will request additional information. And in terms of process, I'll just speak for myself for a minute. As I see it, the commission has a statutory deadline to rule upon the proposed tariffs in this case for NMS2, and we'll get in later into LQF and SQF. That's my understanding, that the 10-month deadline applies. We'll maybe talk later about whether the company is proposing to amend the LQF and SQF, but let's just, NMS2, there's a statutory deadline of 10 months, right?
Correct.
As for rehearing, as I understand it, for rehearing, that September 24th date is not necessarily, it's not a statutory date for those items in which the commission has granted rehearing.
Correct.
And so I don't think that we are under the same time crunch, for instance, in order to propound additional discovery post-hearing and have immediate responses in order to get an order out on those issues. So I can make an assertion that there will be post-hearing discovery on this issue, and that there will be a reasonable amount of time for the companies to respond, and there will be adequate time, there will be no arbitrary dates in which evidence ends in this case, and there will be all the discovery that is needed in order to get the information, with plenty of times for the companies to respond, and an opportunity most likely to brief it following the conclusion of discovery. So, yes, we have questions, and we will ask them, and they will be informed, it will be written, you'll have plenty of time to respond, and there will likely be follow-up discovery, to your point, if we don't get all the information that we're seeking, and there will be plenty of opportunities for the companies to explain their responses or provide color for those responses, and to brief the issue after the conclusion of evidence.
All right.
Okay.
And as we close this, I want to be clear that we're here to provide, if there is a difference, I want to know it.
Thank you, Mr. Riggs. Mr. Kurtz?
Chairman, thank you for allowing me to be heard. On this rehearing on legal fees, if the company's position is granted, it will raise the rates of my clients, but I believe the company is correct on this. There's a 4-year, rate case stay out as part of the order, and it is an absolute certainty that the company's legal expenses each year of those 4 years is going to be a lot closer to $7 million than 0. I think the punishment doesn't fit the crime here. It's whatever dispute there is on discovery. I think 0 is not the correct answer. Thank you.
Ms. Vinsel, do you have anything else for Mr. Arbo?
No, Chairman.
Ms. Copeland, anything else?
No.
All right. I appreciate your indulgence, Mr. Riggs, and your preparation for being able to discuss this today. I think our order went on Thursday, so you had just a very little time to prepare. We'll take a break. We'll probably take a short break. Does anybody need anything more than 10 minutes?
No, I don't think so, Your Honor.
Okay. So we will meet back at 11:15. We'll go for 45 minutes for your next witness. Mr. Arbo, can Mr. Arbo be excused?
Yes, he may.
Mr. Arbo, thank you very much. You may be excused. Thank you. You can even leave if you would like. We'll come back at 11:15 and we'll try to promptly do 45 minutes so that Mr. Fitzgerald can pick up his guest from the airport.
Okay. I may have a
Thank you, Your Honor.
redirect of Mr. Arbo. I need
I
to check my
apologize.
notes.
Would you like to take Mr. Arbo now?
No, I'd like
think
to
I
have a
missed
break
it.
and look at my notes.
That'd be fine.
and
So, Mr. Arbo,
To see
you
if I
can't go-
actually need to ask.
You can't go anywhere yet. Be prepared to come back. All right, thank you very much. We'll take a 10-minute adjournment.
Thank you.
you did, I wanted to call him back. But.
You're all good.
Wait for us to get over here. Okay, Mr. Riggs, did you have any redirect for Mr. Arbo?
Your Honor, I do not. I do accept the commission's statement shortly before the close of the hearing that there'll be further discovery and we'll have a full opportunity to provide additional evidence that the commission needs to adjudicate this issue.
Okay, all right, thank you. Thank you very much, Mr. Arbo. You may be excused. Before we get started in earnest, I want to make sure that everybody who has their camera off, that counsel that's remote. So, Mr. Fitzgerald, Mr. Miller, are you all present?
Yes, Your Honor, thank you.
Mr. Fitzgerald? Mr. Cook? Next witness, I understand, Mr. Riggs, is going to be Mr. Sinclair. I have a sneaking suspicion that Mr. Fitzgerald will have questions for Mr. Sinclair, so I'd like to make sure that Mr. Fitzgerald is present. Mr. Fitzgerald, can you hear us?
Oh, I can, Your Honor. Thank you very much.
Okay, great. And we didn't hear back from Mr. Cook, but thankfully Mr. Horn's here, and we'll have somebody in the room. So, Mr. Riggs, you may call your next witness.
Thank you, Your Honor. I call Mr. David Sinclair.
Mr. Sinclair, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. Please state your name and address for the record.
David S. Sinclair, 220 West Main Street, Louisville, Kentucky, 40202.
Thank you. Mr. Riggs, may I?
Thank you, Your Honor. Mr. Sinclair, would you please state your full title for the record?
It's Vice President, Energy Supply and Analysis,
How long have you held that position?
since 2008.
Mr. Sinclair, did you testify in the hearing in May in this case, or April?
Yes, I did.
Since that time, the commission has issued an order on June 30th, 2021, adjudicating a number of issues, but not the net metering or the QF issues. Did you cause to be prepared then on July 13th, 2021, supplemental direct testimony?
Yes, I did.
And in accordance with the commission's procedural schedule for this portion of the case, did you cause to be prepared and file with the commission on August 5th, 2021, supplemental rebuttal testimony?
Yes, I did.
Finally, Mr. Sinclair, did you also file supplemental rebuttal on August 13th, 2021?
Yes, I did.
If I were to ask you the questions contained in those three pieces of pre-filed testimony today, would your answers be the same?
Yes, they would.
Do you adopt and affirm all three pieces of testimony as your testimony today?
Yes, I do.
Thank you, Mr. Sinclair. The witness is now available for an examination.
And Mr. Riggs, had you had a chance, I may have missed it, to ask Mr. Sinclair what documents he may have in front of him?
I apologize, Your Honor. I did not understand that to be a standing request. I think that is a very good practice, and I will do that.
Okay. And it is, just for everybody else's benefit, for all the witnesses, both in person and remotely, if we could do that in preparation for the cross-examination.
I think that's a very good practice, and I appreciate the chair's observation of it. Mr. Sinclair, could you state for the record what documents or you have before you or have access to?
Yes, I have physical copies of the three pieces of testimony that you just asked me about, and that's all I have.
And do you also have access to the record on your screen through Mr. Lovekamp sitting next to you?
Yes, I do.
Thank you, Mr. Chair.
Riggs. I guess we'll start. Mr. Horn, Mr. Cook, you have any questions? Mr. Sinclair?
I think he responded, Your Honor.
No questions?
yes.
Okay. All right. I guess Mr. Kurtz?
I do, Your Honor. Thank you. Mr. Sinclair, I want to ask you questions about the testimony you filed last Friday, about 5 days ago. Can you turn to your exhibit DSS 3?
Okay?
So these are the active solar and solar battery projects. Explain what all these projects are, I guess.
Okay. I will do my best. I'm not in the transmission side of things, so I just get to use the information that's publicly available. But basically, when a power plant is interested in interconnecting to the transmission system, you have to make what's called an interconnection request. There's a study that has to happen. And so these are projects that have submitted requests to the transmission system, and we engage, I believe, an independent party to do those studies. Ms. McFarland, I think, will be around later in this case, who runs transmission, can better answer the details on this than I can. But these are projects that have requested a study of what it would take to interconnect to our transmission system.
Okay, this is approximately 20 projects are in the transmission queue.
In that neighborhood, yes.
Okay. Now, I added these up as 3,697.5 megawatts. You don't expect all those to be built, do you?
No, I'm not saying they will. In fact, that's a lot of folks, projects make interconnection requests, and depending upon other things that happen, they may or may not proceed with the project.
But these could be built as well as additional ones in the future.
But these are certainly projects that the developer has decided to spend a little bit of money on to make the effort to make a transmission service or a interconnection study request.
Okay. Your Exhibit 1, DSS 1. Okay. So these, Table 2 of DSS 1, is this where you took Mr. Barnes's proposed on-peak capacity rates that the companies would be required to pay for QFs and translated it into this energy and capacity pricing on Table 2?
Yes, as I described in my testimony, his proposed capacity rates only applied to 791 hours during summer periods. And so to get the all-in year-round price, we had to take the profile of a particular technology, in this case a single-axis tracking solar project, and look at what energy they would generate in those particular on-peak hours, and then add to that the energy price they would also receive. So this is that weighting of those all those hours throughout the course of the year.
Okay, so Table 2, Tranche 1, the PJM energy pricing in 2026, the all-in energy and capacity price to be paid to a qualifying facility would be $63.55?
Yes, and again, with my caveat, that would be for a single-axis tracking qualifying facility.
Okay. What is a good capacity factor for that technology? In other words, I want to ask you, how much, at that price, how much would an 80 megawatt single tracking solar cost consumers? In other words, 63.55 times 80 times 8,760 hours times point something. What is it?
We've suggested in here in a number of places about 0.27.
0.27. So that would be, and then we would multiply that by the 6. Okay, so that would be, I already had it, that would be $12 million a year. Do you have a calculator?
Yeah, I can. So you want an 80 megawatt project?
The maximum allowed under the PURPA statute.
assuming I didn't hit the wrong button, it's about $12 million.
Right. And if it was a 20-year contract, that would be a nominal $240 million power purchase agreement?
Yes.
Okay. How would this work? Would you sign a contract with a developer like that and bring it to the commission for approval? Or would you just, if it was in your tariff, just say, up $240 million contract, we'll just go ahead and do that without any commission involvement?
Since we've not had a project like this, I think Mr. Conroy, I don't want to kick the can down the road, but he's in charge of sort of the tariffs. But basically, we would try to negotiate the contract, but the rates that we, assuming these were the rates that were approved, all we would be really, I think, be doing in the contract is negotiating probably some certain performance obligations. So, for example, just like we do in a market-based contract, we expect the solar developer to properly maintain their facilities, to deliver when the sun is out or the clouds are out of the way. So we would try to bring those same parameters to bear, but I don't know exactly what is required once we've negotiated that. But the rates, my understanding, would be what they are, because those would be determined our avoided cost.
Well, that seems like an awfully big contract to not have the commission review. Would you agree? $240 million obligation?
I would agree with that. I just don't know what the standard of review is in this situation. Again, if when we had a market contract like the Roots Creek, we brought it to the commission under initially the indebtedness statute, but because there was no obligation to pay unless they performed, ultimately my recollection of the order was that they didn't need to approve that because there was no obligation to pay unless there actually was energy produced.
What other, would you look at counterparty strength when negotiating a contract like this? I mean, if it was NextEra Energy versus, fly-by-night power company with no capitalization, would that make a difference?
We do look at those kind of performance standards, and so again, I don't remember the details off the top of my head, but certainly in the Roots Creek project, there was certain credit parameters required up front to, again, try to drive performance. Because again, in that case in particular, Dow and Toyota were counting on that energy to meet their own renewable obligations they had, and so we wanted to ensure that the party would perform.
Would sanctions for non-compliance also be a term or condition that you would negotiate?
I'm not sure what you mean by sanctions for non-compliance.
Well, if you sign a 20-year deal and in year 13, the panels need to be replaced, or they're not performing properly, or gets hit by a hailstorm or tornado, or I don't know what happens over 20 years, but if they don't perform, wouldn't there be something in the contract that deals with non-performance?
That would certainly be our desire. Again, I go back to what your first question was, what would this contract look like? In my mind, it should have, as much as possible, the same performance parameters that we would have for a market-based contract, because again, customers would be paying for capacity and energy on a forward basis here. And so you're exactly right. We have, again, in the Roots Creek agreement, I keep going back to that one because it's freshest in my mind. Again, there are requirements for them to use good utility practice, for example, to maintain the facilities. We have light meters that measure what the potential output could be, and we look at deviations from that, and there's a certain cure period. There's another provision that if, again, down the road, if they were to try, say power prices went up, and they say, this 2782 we're selling to Lg&E for, it's not working out, we can get 63.55. Then there's a prohibition on them being able to sell the power to other folks. And so there's some things we did to ensure exactly what try to protect exactly against the things you're talking about.
Well, that would be an issue on counterparty strength. If they were not capitalized, they could go bankrupt, get out of this contract and sell it for more elsewhere, like a coal company might do in certain situations.
I don't want to cast aspersions on other entities.
But that would be something you would want to guard against, wouldn't it?
And that's exactly the provision that we're talking about here, because again, these are special purpose entities, and as you know, special purpose entities are in part designed sometimes to be bankruptable. And so you're exactly right. We want to perhaps, there's some language in the agreement which tries to protect against that kind of circumstance.
Okay. You talked about this, what's called Rudd's Creek?
Rudes.
Creek. Was that put out the competitive bid before you signed that contract?
Yes, and I want to say it was February of 2019, we issued a request for renewable resources. And I forget off the top of my head how many respondents we had. It's in my testimony here somewhere. But we had quite a few respondents, and through a process of negotiations, et cetera, the Rudes Creek project was the one that was the best priced for the consumer.
Is it the company's practice to go through competitive solicitations for new generation?
Yes, I've been involved personally in every single major resource we've done since at least the Trumbull County 2 project, and every single one of them we go to the market to identify market opportunities, because again, to demonstrate to this commission that we're looking at the least cost resource, there has to be options, and so that's why we go to the market. And you may recall from your long experience in dealing with this, we've sometimes actually tried to purchase assets. We tried one time to purchase the Bluegrass CT project. There were some FERC issues that caused that to fall apart. We done some other things through time, but you're exactly right. We always go to the marketplace as part of the process.
East Kentucky ended up with a Bluegrass, didn't they?
Yes, they did.
Okay. Is that the company's expectation in the future to continue with competitive solicitations for new generation?
Yes, in fact, we have one that's open right now that Mr. Riggs referred to in the beginning, that the commissioners have access to the responses to that RFP. So that is an active live RFP that we're working right now that was issued back in January. And that was for all resources, not just renewables.
Small point, this Rudd's Creek, does LG&E and KU have the RECs, renewable energy certificates, associated with that generation?
As part of the agreement that we worked with them, yes, the price includes the receipt of those RECs.
So it's $27.82 a megawatt hour, levelized, fixed for 20 years, plus you get the RECs?
Yes, and that's an important feature because as you may recall, 75% of that project goes to a combination of Dow and Toyota, and they're doing that project because they want that renewability, so we transfer those RECs to them at no additional cost. And then we've said that the other RECs that we receive, we will attempt to sell them much like we do the Brown Solar RECs today and return that value to customers.
In your testimony, you indicated that the price for these RECs, these solar RECs, is approximately $7.80, or it has been historically, per megawatt hour.
Yes, the year-to-date, the RECs that we've sold related to Brown, the average price was $7.80 per REC, yes.
So the net cost of this Rudd's Creek is $27.82 per megawatt hour minus $7.80 a megawatt hour, or approximately $20 a megawatt hour?
Well, that's assuming RECs, when this project comes online, are still $7.80, but that's the math, and that was the financial analysis that I presented in my testimony to this commission as the financial support for why that transaction would be good also for the 25% that would go to all customers.
Assuming that the developer performs, this $27.82 is fixed, the RECs could be higher or lower than $7.80 over time, correct?
Yes, and they certainly have been. They fluctuate. Our market that we primarily sell into, because of what Kentucky qualifies for, is the Ohio REC market, and they've had changes over time and what's going on in Ohio with respect to their renewable obligations, but yes, it could go up, it could go down. Or if Kentucky in the future had a RPS, a renewable portfolio standard, we would most likely keep the RECs to help comply with the RPS obligation.
Could be a national renewable energy standard.
Could be as well, yes.
Okay. Last couple questions. DSS 2. What is it? These exhibits are very busy. What does this exhibit purport to show?
Okay, again, the focus is just on this one example of the single axis tracking QF project, but in my supplemental direct testimony where I first laid out our company's perspective on avoided energy and capacity cost, one of the key questions there is need, and so tranche 1 and tranche 2 really comes from that particular potential need for capacity. So you see the table 1 just describing, and reminding folks of what that tranche 1 and tranche 2 looks like. Is a minor point. The need is about 100 megawatts. A single axis tracking solar project based on the data that we've looked at you could have a nameplate rating of about 127 megawatts to get about 100 megawatts at time of summer peak. I also recommended in my supplemental direct testimony that we sort of wade slowly into the solar QF world, and so based on our next need in 2034, potentially of about 1,000 megawatts, we've kind of capped that as my recommendation for now. We can always look to change it later. But so you see the 127, if that's what we get, we need 873 to meet that cap, so it kind of caps you at the 1,000 megawatts. And so what this table 2A and 2B then do is look at the comparison of Mr. Barnes's recommended pricing that you were just talking about on the other page a moment ago. We priced that out for tranche 1, so assuming 127 megawatts at the tranche 1 price. The remaining 873 at the tranche 2 price gives you a total cost. Then you compare that to in this case, the Roots Creek pricing, and you get a price delta of $36 million annually. Then the total extra cost over that 20-year period, about $719 million, and we present valued that.
Hold on. Say that. I don't see 719.
So you see total extra cost under Roots Creek.
Oh, I see. You're in table 2.
Yeah, I'm sorry. I moved
Okay.
ahead quickly. I apologize. So I moved into 2A. So what 2A is doing is then comparing, like I said, the energy pricing that is my understanding Mr. Barnes' methodology to the Roots Creek methodology that or at least the Roots Creek market price. And this analysis also excludes any rec value from Roots Creek as well. So that's just saying that this difference between these pricing would result in, assuming the Roots Creek method was $36 million annually.
Okay, so in your opinion, using the Roots Creek as the proxy, the market price, the consumers would pay over 20 years $719.3 million above avoided costs?
Yes.
If the commission went with Mr. Barnes's approach?
Yes, and that's also assuming zero value for any RECs in the market price alternative.
Okay, and if we added $7.80 a megawatt hour for the RECs, we would multiply that by 2,273,676.
Well, times 20.
Times 20, what would that be?
Well, I have to turn back to my testimony. I kind of used that math somewhere. Let me find it real quick. Yeah, so on page 7 of the testimony we're referring to, lines 10 through 12, again, you got 2.3 million megawatt hours annually from 1,000 megawatts of solar, and so every dollar is $2.3 million a year. So at current prices, that would be $17.94 million annually, so making the math easy, it's called $18 million times 20 would be, what, $360 million?
So that would be an additional nominal amount above avoided costs. So it would be $360 million plus $719.3 million?
Yes, if assuming rec prices stayed at $7.80 for the next 20 years.
Okay. And you did the same analysis in Table 2B using Mr. Barnes's PJM avoided energy cost instead of the LKE adjusted energy cost?
Yes, it's unclear to me what exactly his recommendation is on energy, so I used the math both ways, just for completeness.
And so this is where you get total extra cost over 20 years, the amount above avoided cost of $1,093,000,000
Yes,
plus the $360 million for RECs.
again, assuming that recs were constant over 20 years, yes.
Are you aware, well, you are aware that under federal law, consumers are not required to pay above avoided cost?
I've certainly read the regulation, and it seems very clear that you're not, that's the intent is to pay actual avoided cost, not more than avoided cost.
Are you referring to the FERC regulation or the state regulation?
As well, I've read both of them and to some degree, and that seems to be the intent of both. The customer should be indifferent whether you're buying from a QF or a market alternative.
Okay, because otherwise the QF would be subsidized?
That would be certainly an interpretation of that, yes.
Or how about this way, otherwise consumers would pay more than they otherwise would have paid and be worse off with a QF versus a utility-owned or utility-purchased resource?
Yes.
Okay. Thank you, Mrs. Sinclair. Thank you, Chairman.
Mr. Fitzgerald, let me hold off 1 second, Mr. Fitzgerald. Let me ask Mr. Miller if he'll go first. I put him before you. Apologize. Mr. Miller, does Sierra Club have any cross-examination?
No, Your Honor, thank you.
Okay.
Thank you.
All right. Mr. Fitzgerald?
Your Honor, since much of the testimony speaks to the testimony and the exhibits from Mr. Barnes, I thought I'd defer to Mr. Spinard to see if he has any questions before I start, if that's acceptable to you.
For the sake of efficiency, I think that would be best.
No questions, Mr. Chairman.
No questions for Mr. Sinclair?
That's correct.
Okay. So
Well,
it's
that
back
takes,
to you,
that
Mr.
takes care of that,
Fitzgerald.
doesn't it? Mr. Sinclair, can you hear me okay?
Yes, I can.
Okay, if you would, do you have your supplemental rebuttal testimony in front of you?
Yes, I do.
Okay, would you turn to page 5 of your supplemental rebuttal testimony and look at lines 9 through 13? Let me know when you've had a chance to review it.
I am there.
Okay. In that testimony, you indicated that when a customer installs rooftop solar, the neighbors are involuntarily being forced to, or being obligated to, quote, pay for part of the project, period, end quote. You see that there?
Yes, I do.
I'd like to spend a little time unpacking what payment you're referring to there, if we could. What costs does the company incur when a customer puts solar on their roof?
Cost to the company incur? Make sure I heard your question correctly.
Yeah. Let me ask this more specifically. Does the company have any new technical costs, actual measured costs associated with voltage regulation, harmonics, or other technical costs when somebody puts solar on their rooftop and takes service under a net metering tariff?
Again, Mr. Wolf might be, who's in charge of distribution, might be better able to answer that question, but at a minimum, we'd have to have metering, I believe. But I would leave the details of the engineering stuff to Mr. Wolf.
I'm sorry, I did not mean to speak over you. Go ahead. You said at a minimum we have metering?
I was just saying, you know, at a minimum, we would need metering, but I would leave it to Mr. Wolf, who's in charge of distribution, to identify what, if any, incremental distribution costs would be required.
Okay, well, I'm just, see, it was your testimony that the addition of rooftop solar means the neighbors have to pay for part of that project. I'm just trying to get to your understanding, and I'll ask Mr. Wolf, of what payment is being required of the other neighbors. Do the companies have new administrative costs associated with billing and collections that wouldn't otherwise be incurred?
Well, I don't know about that per se, but I think the sentence 12 through 13 answers your question, which is the issue around avoided energy and capacity costs. So if, for example, the solar project owner wanted to just let the energy go onto the grid for no cost, we wouldn't have to have this discussion. But since the solar owners seem to want to have their neighbors pay for the energy that is pushed onto the grid, that's the point of this discussion here, around why the neighbor needs to be involved.
Okay, so your underlying assumption then is that the neighbors are subsidizing the participating customer by paying them more than the value of the solar?
This part of the testimony doesn't say anything about the price. It simply says that because the person who puts a solar panel on the roof pushes power back onto the grid, and at this case expects those customers to pay something for that energy, that involves the neighbors in their decision to put a solar panel on their roof. If they were to disconnect from the grid, they obviously would not be involving their neighbors, or if they voluntarily just donated the energy to their neighbors, we wouldn't have this discussion. So it's the fact that the solar installer on the roof, as a homeowner, wants to get their neighbors to pay something for the energy they push back, that therefore involves the neighbors in that decision. I'm not saying what they are paying or not paying.
But you're assuming that there is a payment going from the non-participating customer to the participating customer.
This testimony says their economics, which means the homeowners that are installing solar, in part depends on their neighbor's willingness to pay for part of the project. So all I'm saying is I'm stating a truism here, that because the person who installs solar on their roof pushes it back onto the grid at some point in time, then the economics to the person installing that solar panel on their roof will in part depend upon what, if anything, their neighbors pay for that energy that's pushed back on the grid.
Okay, I'm still not understanding, Mr. Sinclair, so I'm sorry if I need to break this down a little further, but are you saying that if I install a solar panel, I get to go over to my neighbors and ask them to pay part of the installation cost?
Okay, let's break it down, make it simpler, I guess. I'm
That'd
going
be
to
great.
spend a fixed amount of money for this solar project. So let's say that's $20,000. And so if, let's say that this solar project, my electrical usage was only at night, and I never ever used electricity during the daytime. The decision by that homeowner to spend $20,000 to put the solar panels on the roof is going to be extremely dependent upon what the neighbors end up having to pay for the energy that's pushed back on the grid. So if they say, I don't want to pay anything for it, then I don't know why the customer would spend, or a homeowner would spend $20,000 to put a solar panel on the roof for the heck of it. So if there's, so that's what I'm saying. The energy, you have to look at the total energy that's generated by this machine and look at who's paying what for it. So it's just describing there's a fixed investment, it produces electricity, and where's the revenue stream from? Because if you look at the prior page, I lay that out on the bottom of page 4, that the economics of rooftop solar to the homeowner depends on 3 things. The usage pattern of the homeowner in relationship to the solar radiance, the rate charged by the utility for the homeowner, so basically the savings for serving their own load, and then the energy rate paid by the utility for excess energy pushed onto the grid, which is used to serve their neighbors. So those are the 3 factors, those are the 3 things that have to be considered in looking at the economics of residential solar.
Okay, well, we're still not quite there, Mr. Sinclair, and I don't mean to belabor the point, but your testimony is that the neighbors are paying for part of that project. First of all, can we agree that the person who generates solar rooftop energy and feeds it into the grid is not being paid, but rather is being credited?
I think that's a difference without a distinction. You're talking about if I have a $100 bill and I get a check back in the mail, a rebate for $5, or I get instead of a $100 bill, I get a credit on my bill for $5. The net value back to the customer in this case is the same. So I don't see the distinction you're trying to make here.
Well, I'm just trying to actually be a little more precise about our discussion because the statute doesn't provide for a payment, it provides for a credit which cannot be cashed out. Is that not correct? Or don't you know?
It can be accumulated, is my understanding.
Okay, but can it be cashed out?
My understanding is at the very end, it cannot be. So in other words,
Okay.
if a customer builds up a large amount, then they would not get paid for that piece.
Okay, so in my understanding, your suggestion is that the neighbors are paying the solar customer something. Are you meaning to refer there to costs that are approved by the commission for recovery by the utility, or are you suggesting that there's this automatic payment that neighbors have or get assessed when somebody, like a neighborhood association, where somebody installs solar?
I'm not sure I quite follow your question.
Well, I'm not sure I quite followed the testimony because you're saying the neighbors are being involuntarily forced to, quote, pay for part of the project. And my question is, if I install solar, does that automatically change my neighbor's rates?
I think that's what this case is about, right? Is what should their neighbors' rates be in order to support the solar installation economics or decisions of the homeowner?
Or conversely, if the value of that energy exceeds the rate that they're being credited, would it not be the case that that supposed subsidy would go the other way?
I've said nothing about a subsidy. I've simply said what the dollars paid by consumers that are receiving the energy that's being pushed back on the grid and are going to the people who push the power back on the grid, no different than the dollars that I collect from customers to pay to the coal companies that Mr. Kurtz referred to. So I collect money from customers for providing them service and I give it to suppliers. In this case, the homeowner of a solar panel wants to get paid for the energy they push back on the grid. And so the question, all I'm saying is the decision to whether or not install that solar panel to begin with is going to be influenced by that rate, which is paid for by their neighbors.
Assuming that there is something that they are not paying that someone else has to pay for?
I guess I'm lost because the energy system has to balance. So if there's a kilowatt coming from the solar panel producer to their neighbor across the street, that's one less kilowatt hour that's produced somewhere else. So the bill is to the customers for the cost of the supply. And so no different than we have different power plants in our grid already. This is just one more power plant. And they want some price to get paid for generating power to the grid to supply load. And so that's what, like I said, that's why my line is pretty clear on 12 and 13. That's what this case is about, is what are those rates that these suppliers want to get paid.
Okay, well, maybe we could wrap this up because it's, I don't know that we're any closer to a mutual understanding here. Can we agree that if I install rooftop solar, my neighbors don't come over and hand me money, but instead, if you assume that there's a cost to serving that exceeds the value of the solar, that it's the commission that decides whether to approve or not approve that rate or that charge?
Well, I think we can agree that the neighbor's not paying his power bill to his neighbor. I think what we can agree on is that when LG&KU send the bill to the neighbor that includes the cost of the power from the solar project provider, that then we send that check on to the homeowner. That's no different than we don't ask the homeowner to go pay the coal company or the natural gas company directly either. So we're the intermediary for procuring the generation resources necessary to serve load. Like I said, net metering customers are just another generating resource to serve that load.
Okay. Have you calculated the quote-unquote payment that you believe non-participating customers are paying for rooftop solar customers on an annual basis?
I have no testimony on that subject.
But you're assuming that they're paying for part of that project. What's your basis for assuming that they pay for part of that project?
My testimony is about what the rate should be in the future, not how net metering works today. That is the issue in this case. As you know, net metering 1 is not at all what's at issue in this case, which is NMS 2 is at issue in this case. And so NMS 1 is a totally different mechanism based on the volume of energy, not the price of energy.
Let me try it one more time. You've indicated in your testimony that the neighbors of a rooftop solar customer are being involuntarily obligated to, quote, pay for part of the project, end quote.
Mm-hmm.
I asked you whether you've calculated what that payment is on an annual basis, and I think you just said you didn't have any testimony on that.
You heard me correctly.
What is the basis for your assertion that the neighbors are being forced to pay anything for the solar customers' participation in the grid?
Okay, well, again, as I said before, is energy has to balance. So if you're asking me to explain why NMS 1 works the way it does, is that energy is being pushed. I got a whole discussion in here about storage, but energy being going on the grid. We back down other generation to balance load, pay other suppliers. In this case, the way NMS 1 works is we say, okay, let's keep track of the energy that was pushed on the grid. And instead of giving you dollars for it, we're going to turn around and give you a energy credit for it and act like we banked it for you when we in fact didn't bank it for you. So you're going to look at energy cost differentials between the energy at the time it was backed down versus the time it was provided back to the homeowner in the middle of the night or something. So I've not done that particular mathematics, but there's clearly involving neighbors, because otherwise where is this energy going? It has to go somewhere. So I'm a little confused as to why you're insisting it's not going somewhere, and particularly to the neighbors.
Oh, I don't think I said anything about where the energy is going. I'm asking you about your testimony that the neighbors are involuntarily having to pay for part of the project. Now, let's follow the electrons for a minute. If I'm generating a kilowatt hour of solar energy, I would assume it's being used by my neighbors, and it's offsetting a kilowatt hour that you otherwise would have to provide as a utility. Is that not correct?
I said that 10 minutes ago.
Okay, well, I think we share an understanding then, but I'm trying to understand what you're referring to when you say the neighbors are paying for the project. Now, you're still billing the neighbor for the kilowatt hour that they consumed, even though it wasn't you that generated it, was the neighbor who's a rooftop customer, right?
I'm sorry, I kind of lost your
Okay, the neighbor who's getting that kilowatt that is generated by the rooftop solar customer, they're not paying the neighbor more than they would otherwise, right? You're not charging them a premium for that kilowatt that the neighbor has generated.
Well, first of all, you're confusing retail rates with the components of retail rates. As I'm sure you're very much aware, one of those components is fuel. And so the difference is this is a purchase power in effect. So the amount being paid to the rooftop solar guy versus the alternative fuel costs that otherwise would go to a gas or coal company or another solar company, that difference is where the economics matter to the end-use consumer.
Well, I think you finally have explained. You are analogizing the relationship of generation for use by a rooftop customer with generation for sale in the wholesale market by a power purchase agreement. Is that correct?
I'm saying that they're a producer of electricity. And so, like any producer of electricity, they seem to want to get paid for producing that electricity and providing it to others. Just like coal companies want to get paid for their fuel, and gas companies want to get paid for their fuel, and other solar companies want to get paid for their contracts, or a hydro guy wants to get paid for his resources. So I'm just saying is that if we take down one resource in order to take this across the street, that difference is what's going to show up in the retail customer's bill. That's the mechanics of the FAC process.
So, rooftop customer exports energy, goes to the neighbor next door. When it serves that neighbor, it passes through their meter, is that right?
The electricity that the customer consumes always passes through their meter.
Right, and when it does, you charge for that, don't you?
Yes,
And the neighbor's paying the retail rate, are they not?
yes, and as I pointed out, that retail rate contains a number of components. It contains a base energy charge, a fuel charge, an ECR charge, franchise fees, and other things.
Okay, okay. So, do you agree, Mr. Sinclair, that, and this is a quote, an evaluation consisting only of the costs incurred would be deficient if the evaluation failed to consider known or reasonably expected measurable positive benefits or effects that accrue from fed-in solar?
I have to apologize, the audio wasn't great. Could you just repeat that again, please?
I tell you what, let's wrap it there. I appreciate your time, Mr. Sinclair. Mr. Chairman, I'm done. It's 12:04, and I think we've explored this point about as much as we can. Thank you very much, Mr. Sinclair. Thank you. I pass the witness, Your Honor.
Okay. So we'll take up, I guess, Ms. Vinsel will ask some questions of Mr. Sinclair when we come back. Before we go on the record, or before we go off the record, excuse me, thankfully we've been on the record this whole time. You noted and marked for the record, I believe, Mr. Arbo's, you had a reference, but items number 2 and 3, but I don't remember you moving for their introduction. Would you like to do so now?
Yes, sir. Please, I conclude the introduction of Arbo rehearing direct exhibits 2 and 3.
Okay, is there any objection? Okay, that's fine. We'll enter those into the record as, have you marked them exactly that way?
I have not, I will, when we adjourn. The court reporter does have those exhibits in paper medium.
Okay, and they'll be so marked. We will recess, adjourn for lunch until, we have 55 minutes. We'll come back right at 1 o'clock. Thank you. See if Mr. Fitzgerald has been able to join us or not. All right. Thank you. We're back on the record in case numbers 2020-349 and 2020-350. The hearing on LG&E and KU's net metering and QF rates in addition to items granted rehearing. Mr. Fitzgerald, are you back with us?
I am, Your Honor, thank you.
Thank you. Mr. Cook? You with us?
Yes, I am, sir, right here.
All right, and Mr. Miller?
Yes, Your Honor, thank you.
All right, we have everyone else, I believe, that's supposed to be here in the hearing room. And Mr. Fitzgerald, you said you were done with your cross-examination and you passed the witness, is that correct?
Yes, Your Honor, thank you very much for checking.
All right. Mr. Sinclair, you're still under oath. Ms. Vincent, do you have any questions for Mr. Sinclair?
Yes, I do, Chairman. Good afternoon, Mr. Sinclair.
Good afternoon.
In your supplemental direct testimony, I believe it was filed July 13th, did you calculate new SQF and LQF rates?
Yes.
And is LG&E and KU, or are LG&E and KU proposing that those rates be approved to be in effect in this case?
I guess I think it's a kind of a Mr. Conroy kind of question. I do the math and provide the information to the people and then take care of the rate issues. But I calculate values that I thought should be appropriate for SQF and LQF customers.
That's fair enough. I will ask Mr. Conroy. Thank you. In both your supplemental direct testimony, your supplemental rebuttal testimony, you referenced using the, I believe it's 2021 business plan for LG&E KU to develop avoided costs, correct?
Yes.
Can you tell me what the 2021 business plan consists of?
Okay, well, basically it's all the information that was really filed as part of this whole entire rate case. Every year, the company does a business plan, so it's everything that was required to produce the forecasted financial statements, et cetera. So it's a comprehensive view of the financial projections of the company.
And was the 2021 business plan filed with the commission?
It's my understanding that was the basis for the forward test year that was in this rate case.
But was the document itself, is what I'm asking, was that filed into the rate case, to the best of your knowledge?
Yeah, I know we filed certain things that come from my area that support the business planning process. I don't know off the top of my head. I know there's lots of documents get filed in these cases. I just don't know off the top of my head what all was filed related to the business plan.
Okay. Can you tell me, to the best of your knowledge, are the 2021, any business plans reviewed expressly, reviewed by the commission?
Not as part of the planning process, I wouldn't think so. I mean, when we do a forward test year, as long as we've been doing forward test years, we've used the business plan for that applicable forward test period as the basis for the filing of rate requests. But to my knowledge, for example, this year we're working on the 2022 business plan. To my knowledge, unless there's something I don't know about from a rate perspective, there will be no reason to file that, although there'll be certain pieces of it that get filed through time. For example, the commission request information about our load for the next 5 years and resources. So there's various pieces throughout the year that we file that comes from the business planning process. So for example, the IRP coming up is going to be an output. In October of this year, we will file the IRP for the companies. That will be an output from the planning process that we do every year.
And I'm not trying to belabor this point. I'm trying to understand more clearly. It sounds to me like the business plan is sort of this underlying document from which other data is compiled and determined and filed.
Well, let me say it this way, I think maybe I see the disconnect. When I think of a business plan, to me, it's a process, it's an activity, set of activities that from my group's perspective, we produce the load forecasts, we produce generation forecasts, fuel forecasts, inventory targets, and a host of metrics that we use to manage the business. When Mr. Arbo was here, he referred, I think, if I heard his testimony correctly, as part of the legal budgeting, they talked about a process. So it's a process. There's a series of presentations, et cetera, that is part of that. I'll be honest, I don't know that there's one big binder, it's called the plan. I may be wrong on that, but I don't personally see that document. I guess I'm a little lost. I'm not trying to evade your point, but it's a building up process. It's not a figure out and top down type of process.
I want to make sure we're not talking past
Sure.
each other here.
Right.
I guess my thought is when Lg&E or KU file an integrated resource plan, an IRP,
Mhm.
the commission doesn't approve it. We accept it. However, we open a case, we investigate, interveners may join, we test out the theories. We try to determine the reasonableness of it. What I'm asking is, would a business plan go through the same process?
I'm not aware that the commission has any process to review our business planning. Maybe, I don't know, punt this issue to somebody, but I've never, in my entire time here, I'm not aware of a PSC review of just the plan unto itself.
I think, and again, I'm not trying to make you
Right.
puzzle what I'm thinking out.
Sure.
It's that so much of this is based on a business plan, and it sounds as if there's some separate document somewhere that's offered only by way of explanation. I think you've answered my questions.
Okay.
Ms. Menzel, I think you are talking, the two of you are talking past each other, and I would ask you to ask these questions to Mr. Conroy. The test period reflects the 2021 business plan.
Moving on.
Okay.
You mentioned in the business plan that for calculating avoided cost, I believe you have two methodologies, the current market price and the levelized cost of a simple cycle combustion turbine, CT. Can we talk about the current market price? Can you explain how you calculate the current market price?
Sure. As I tried to describe in my testimony, I'm trying to mimic as much as possible the approach we use for procuring resources generally, which is going to the market to get options and figure out what's the least cost alternative. In this case, since, as I understand the QF regulations, we have an obligation to purchase, I was trying to attempt to come up with a methodology that would mirror as much as possible and mimic as much as possible that market process. So the market price process we went with was, I came with two alternatives. One is the recent transaction we just did with Roots Creek. And as I've indicated in some other testimony, that's very consistent with some contracts you've seen reviewed by this PSC by Big Rivers. You look at the RFP that resulted from in the Roots Creek agreement, there were other competitors very close to that number. So to me, that's a pretty good indicator of roughly where the market is for large-scale solar. The alternative we came up with was, trying to find a market index, which is, again, is a common tool in the energy business, is to track natural gas. You'll hear about the Henry Hub Index, right? So it's a place where there's some discovery on prices. That doesn't mean you pay that. We usually pay a discount to Henry Hub based on where we're located. But the point is you try to find some other indicator where there's some liquidity or indication of what prices are. So we took that and we said there's really two issues here. One is, we have to look at energy. And so that's where we calculate the avoided energy price. And so then, as I made the point, why would we ever pay more than energy? It must be have some other reason you want this resource. And for purposes of this, kind of the postulate is that you must have some future resource need. And could this resource meet that resource need? And so basically took that residual, and in particular, based on the discussion I had with Mr. Kurtz this morning, because we're not talking about RECs or anything like that, if you think about the Roods Creek case itself, it was all about avoided energy plus the value of RECs. In this case, we've said, well, we don't have the RECs at hand, so it must be about avoided energy plus is there some resource capacity value associated with it. So that residual is what we've assigned to be the extra price the customer might be willing to pay on top of avoided energy to meet some reliability need. And so then we calculate those numbers, and that then adjusts as well then for the fact that we don't have a need currently in 2020. There's a table in, I think it's supplemental DSS 2 that says, here's our potential capacity needs based on whether we retire Mill Creek 2 and Brown 3 in 2028 or not. And so, and then down the road, we've got some other retirements that could occur in 2034 time period. So we said there's uncertainty about that. So we said we don't want customers paying today for something we don't need. So we discounted that capacity component to reflect the fact they would pay nothing, during this time period, to basically, in part, send the message to folks that if you want to come now, that's fine, but we should get a discount for it. But ideally, you would wait till later. And I think the good analogy for that is a number of years ago, I was involved in a case where we sought to purchase, I mentioned this earlier, the Bluegrass combustion turbine facility. That case, we didn't have exact need at that point in time. It was really excess of our need. But the price per kW was like $200 a kW. To put that in reference, a brand new CT might cost $800, $600 to $800 a kW. So the point we made to the commission was, even though we don't really need it right now, it was such a discount, you couldn't hardly say no because you don't know if it's going to be back on the market later. So that's kind of the same philosophy here with setting it at zero. Is it's going to be slightly lower than the full retail, or the full, price you might see from Roods Creek. But again, Roods Creek wasn't justified based on some capacity, it's based on selling RECs. And in this case, because we don't have that, you want to send a signal, we really don't want it, but if it's a great deal, we'll take it sooner than we otherwise would. So that's the discounting that occurs to reflect the need timing. So hopefully that was clear, but all the data is in it. It'd be easier to walk through the exact numbers if you want to do that, but that's the overall philosophy, is to take what we otherwise would procure through the market process and come up with a method that would, since we have to buy it under the QF rules, it approximates that so we don't end up paying more than we otherwise would for the same exact resource.
No, your explanation was very helpful, thank you.
Okay.
And I very well remember the Roods Creek matter. Is it fair to say that the current market price methodology is not used outside of perhaps Lg&E, KU, or some other PPL entity?
I know there was a data request along those lines, and I don't have a survey of other states, but I guess I would say this is, given the avoided cost obligation, that customers shouldn't pay more than other alternatives, I think it's entirely consistent with the regulations. I'm not sure other methods, how they would arrive at something that doesn't violate that the requirements of the QF to not pay more than they otherwise would pay for the same type of resources.
I would like to move on. What I'm going to move to is something that you can look at it digitally. I've made a paper copy for all the parties here in case they don't have access to this. I would like to refer to the Excel file that was filed in response to staff's seventh data request, item 34. This is an Excel spreadsheet. As I recall, the name is, references resource availability or available resource. And just for the commissioners and those in the room, this is in tab 3 and tab 4 are the two documents that I'll be referring to, or the two parts of this spreadsheet. And if you'll just let me know when you have that up, Mr. Sinclair.
I think Rick's got what you're referring to, so we'll find out. Go ahead, ask your questions. We'll see if it matches what's on my screen here.
I would like to go first to the tab that's called Profiles. And for
Okay.
everyone in the room, this is the paper document that's basically the third document in your pile that's after supplemental testimony. So I want to confirm, make sure I have the correct understanding, that the profiles that we're looking at in this tab for solar and wind are all based on an 80 megawatt nameplate capacity.
Yes, because the maximum allowed under QF law is 80 megawatts, so we did all the math at 80 megawatts.
Mr. Riggs, would you like me to wait a minute before I proceed?
May I have just a moment, because I am having trouble finding this.
I'm good.
Please proceed.
Do you need that back? Do you need that?
While we proceed
Okay.
again, I would like to offer up as staff exhibits 1 and 2, the documents. They have a table at the top, case numbers 2020-00349 and 350, attachment in response to PSC 7, question number 34.
With that item marked as item number 1.
Item 1, thank you.
Okay.
And as item 2, it's table 8, availability of QF resources during peak hours, percentage of nameplate capacity.
And that was previously supplemental exhibit DSS 2, page 9 of 16.
Yes.
Okay.
So 1 and 2, Chairman?
That's correct.
Can I just ask a clarifying question? The actual spreadsheet has 271,753 rows, and the paper copy you handed out only has
Yes, thank you.
a fraction of that number. Are they meant to be, I mean, it ties to the very first numbers, but I just want to make sure that I'm looking at the whole thing here.
You jumped way ahead of me,
Oh, I'm
thank
sorry.
you. No. It gets us to the job faster. Yes, what I was going to say is, that for those in the room, the paper copy represents only the first roughly page of this document because it is so large. So going back to this, for the solar fixed tilt resources, is the 80 megawatt capacity based on PV module capacity or on the inverter capacity?
This would be based on 80 megawatts that would be delivered to the grid, so it'd be 80 megawatts AC, let's put it that way.
And again, recognizing I'm not an engineer, I believe there's a difference between the module capacity and the inverter capacity. Am I incorrect?
That's correct, and I'm also not an engineer, so we'll wade through this together. But you're exactly right that the inverter is what converts the DC power from the solar panels into AC on the grid, and so you can size the inverters in ways that change a bit the load, the generator shape. For example, Brown Solar is a good example. We have, I think, close to 11 or 12 megawatts of panels that would be eventually converted or eventually could be made into AC power, but there's only inverter capacity to produce 10 megawatts.
Okay.
And so what that does is it flattens out the generation shape when the day is higher and the sun is higher in the sky. So it gets less spiky, it gets flatter across the top of the day.
So using Brown as a good example then, going back to this, the 80 megawatts then, are we talking about the panel capacity or the inverter capacity?
That would be the inverter capacity,
Okay,
yeah.
thank you. Again, not trying to belabor a point, but I
Sure.
wanted to make sure I understood which we were speaking of.
That's a good point.
And probably also for the solar single axis tracking, also that 80 megawatts is for the inverter capacity, correct?
Yes, because again, all the analysis we're doing is for energy delivered to the bulk electric system, so I'm interested in what goes on to the transmission system.
Perfect, we're on the same page. And you talked about the inverter size and having an impact. So then can a PV system be designed so that it produces a maximum capacity at certain times of the day?
Well, sort of. Again, the light hits the panels convert the photons of light into electric current. That electric current is in DC, and then given that the grid's in AC, it has to be converted that way. So one way to, again, depending on how the contract is structured and other things, a party might like to, depending on the cost of panels versus the cost of inverters, squeezing that last little bit of AC out of those panels by putting in more inverter capacity may not be worth it. So you end up with a clipping of the generation from an AC perspective.
No, thank you. I would like to move to what I've introduced as PSC Staff Exhibit 2. This is also the tab named Tables in that same spreadsheet. And again, this document contains the entirety of the table, but it is a printed replication of what is in an Excel spreadsheet.
Correct.
So can you explain how the generation profiles for PV were created for this table?
Sure. And the reason that prior tab we were talking about is so long is because hourly data for 30 years, right? So we produce an hourly load forecast. And one of the things that, the way we prepare that hourly load forecast is that we are recognizing that throughout the course of the year, we have different weather patterns during the course of days and stuff. So we look at some of those historical days and we basically create a forecast hourly that's chronologically correct. So in other words, Januaries have different, depending on when the year starts, have different weekends fall in different periods, et cetera. And so then we want to line up the weather patterns that underlie that load forecast, because weather is a huge driver of load, to the generation capabilities of renewable generation. This is a huge issue from a planning perspective, is that we know that certain weather patterns are associated with certain temperature patterns, certain cloud patterns, certain wind patterns. So a lot of the work we've been doing in recent years is around trying to understand this. So Mr. Kurtz asked me about the RFPs recently, and that renewable RFP, one of the things we asked for respondents is, what are they showing as their patterns, for example? So what we do is we have to develop a profile of generation that corresponds to the weather pattern that's in our load forecast. Otherwise, we get very strange results, right? So we want to be able to reflect days like today that are kind of hot, but kind of cloudy. And then next week, we're going to have hot days, but maybe they're clear. And so we just kind of have to line up the generation profile with the temperature kind of profiles. So what this data does is it took, for example, let's take January, since that was what was shown in your first part of your printout there. Our system peak historically occurs at hour beginning 7 Eastern time in the wintertime. That's what table on the screen or in your exhibit shows. We know in looking at data in that forecast that at hour beginning 7, there is no evidence that single axis tracking solar or fixed tilt solar will produce anything at that time, given where the sun is, et cetera, in the sky. So, but wind, on the other hand, if you look at those different wind profiles for the month of January, we have, obviously every month we have 31 days in the month of January, so we got 31 hour 7s, and we got 30 years of forecast. So we have, whatever that is, 930 observations. So
I'm going to trust your math.
Huh?
I'm going to trust your math.
Okay, so the average output of wind at 7 o'clock in the morning in that time period was at about an 80% megawatt wind project was 35.7. So I think, to illustrate this point, the handout you gave me at hour 7 for wind, you would see it was at 16.69, I think, the right hour here?
Yes.
Okay. You didn't give me this piece of paper, but the next day, that same wind was at 75.46. at exactly 7 o'clock in the morning. So what we did is, like I said, that this 35.7% represents the average of all of those 7 o'clock in the morning in the month of January over our forecasted period. Because again, January at 7 o'clock is not exactly the same every single day in January for 30 years. So it's got cold January days and milder January days, right? So that's what's reflected there. So when you go further on down, for May, for example, we see that our peak typically occurs hour beginning 15. And so when we look at the output of solar projects, the same kind of math over 30 years, they would produce roughly 72.5% for a single axis tracking machine. And then the average of fixed tilt was 57.7%. So it's using the profiles we would use to kind of evaluate resources, looking at what they contribute throughout that 30-year period at the time of the peak in that month. So that's the basis for that. Hopefully that's clear.
Yes, I'm able to follow your explanation very well.
Okay.
Thank you. You may have already answered this question. I want to make sure this is one thing I want to make sure that I have. Is it possible for the simulation of a solar powers plant capacity factor could change depending on the weather year chosen?
Sure, because we know that some years are cloudier than others, right? If we talk in a perfect world where there are no clouds, then they'd be exactly the same every year because the sun angle to the earth would always be the same and every year throughout the course of the year. So it's the clouds that are random, and there's certainly cloudier years than other years, which is one reason why we took this 30-year approach, because again, our method, not every year is the same clouds or the same wind, for example.
And I recognize I had you, the last set of questions, I was still on the profiles tab.
Okay.
Thank you for staying with it. I would like to move to the table tab, which is Exhibit 2 for those in the room. So the facility called Other Technologies, that last column, is that assumed to have 100% availability for all hours of the year?
Yes, for purposes of analysis, what would fit in there would be, you have certain types of cogen facilities that have steam hosts and, so that's a broader catch-all type of category that it would assume to have some potential to generate on a more dispatchable basis.
So that, as you spoke about the steam hosts, that they can be assumed to have 100% availability?
Again, it's going to depend on the specifics of the particular application. In my past life long ago, when I worked at an independent power business, I worked briefly on a project that was a big cogen project down in Texas, and so that had some certain dispatchability associated to it, yes.
I have one last question for you. This comes from a response to staff's 8th request, item 21, but I'm just going to read the statement to you, and if you need to look at it, let me know. In this response, you state, quote, "The CO2 emissions forecast reflects the emissions from the company's existing and potential replacement units." So to expand upon this, what type of replacement units were you referring to, or what assumptions did you use?
Right. So in the analysis, we're talking about the 2021 business plan here. We know that we assume that units will reach the end of their economic life based on their book depreciable life. And so what we have to assume is what replaces them. And for the simple cycle CTs, we assume they're replaced in kind. So if, say, Trimble County Unit 5, which is a gas turbine, when that reaches the end of its life, it gets replaced by a new version of Trimble County Unit 5. For the coal units, we're not likely to replace them with new coal units based on what we know today. So what we've assumed for this purpose of our analysis, just as a benchmark to start with, is that since those coal units generate a fair amount of energy, what we do is we assume every coal unit that retires, we replace with a combined cycle plant to maintain a minimum of the reserve margin range. Because we know that's going to meet reliability. What we've not done, what we don't do is try to optimize for energy costs or other things like that. So it's a kind of a like I said, it's an energy generating machine retires, so we replace it with an energy generating machine. So that's why you see in the attachment of that the emissions decline over time, because a combined cycle plant produces like 0.4 tons of CO2 per megawatt hour compared to a coal plant at 1 ton of CO2 per megawatt hour roughly.
And I don't want to put words in your mouth.
Sure.
It sounds like renewables were not included in that assumption. It was all combined cycle.
Yeah, again, what I said is that we're not trying to optimize the energy mix or even the capital cost per se, because we're not making decisions today on 2039 machines, right? So there's a long time between now and, unless something changes, when Mill Creek 3 and 4 might retire or Trimble 1 might retire. So we got to have something that kind of sets the table, because we do a lot of analysis during the year. And so we certainly do the things you're talking about, where we're saying, let's try to, in the nearer term, optimize resource mix, whether it's renewables, simple cycle, combined cycle, those kind of things. But for a base, just getting a set of numbers out there, we replace in-kind energy machines with energy machines to maintain minimum reserve margin.
Thank you. And I want to explain to the room that because the rest of the team that is on this case are elsewhere in the building, I'm checking my phone for texts. I promise you I'm not doing anything untoward. So I don't have anything from the team. I believe that's all of my questions. I would like to move PSC Exhibit 1 and PSC Exhibit 2 into evidence in the record.
Is there any objection?
No objection.
I'd like to sustain. Please enter PSC Exhibit 1 and 2, which are previously in the record as hearing exhibits. Vice Chair Covey, did you have any questions, Mr. Sinclair?
No question.
Mr. Sinclair, the PSC Exhibit 2, which is we have this many hearings and this many sets of testimony. It's Supplemental Exhibit DSS2, the page 9 of 16, Table 8.
Correct.
Do you consider these to be capacity factors or availability factors?
No, it just says, what this is at that particular time of day, again, let's pick a month where they're all available. July value, for example. At the time of system peak, at the hour beginning 1400 Standard Time, Eastern Standard Time, we would expect, based on all the analysis we've done, looking at different cloud patterns, et cetera, that a single axis tracking solar plant would be at 81.4% of its nameplate capacity. So again, if this is Brown, let's use Brown as a simple example, it's 10 megawatts. That's not a single axis tracking machine, so that's a bad example. But if it were, we would expect it to be producing 8.14 megawatts at 1400 hours in July.
Okay, and so this chart is also, at the note is wrong, but at the interconnection, this is the amount of capacity provided, right? Or the percentage of nameplate that the inverter can provide at that exact hour.
Yes, interconnected to the transmission system, right. On average. I'm not saying that some days, some months or some years isn't super clear on that day, and other days it could be very cloudy. Like today is probably going to be a good example in August. I don't know that we're going to be that high of a capacity factor based on the clouds today.
Or other technologies, so let me get this right. This corresponds to PSC Staff Exhibit 1, is that right?
Yes.
Yeah, okay. PSC Staff Exhibit 1 feeds into this table, is that fair?
Yeah, this Steph, the one that's the 217,000 rows that's used to calculate the data you see in table 8 here.
Okay, and that's what I was gonna, so it's every hour of every year for the next 30 years.
Yes.
Okay. Is the column for other technologies capacity factor 100% for all of those 200,000 plus hours?
Yes, because it's assumed to not be weather dependent. It's assumed to be a technology that's not weather dependent.
So is that, and I appreciate that it's not weather dependent, but I guess the question is, does this only take into account the factor of weather?
It's assuming that the machine is properly maintained. So, for example, we don't assume inverters are broken or panels are not working or wind turbines have issues with blades or whatever. So all of these values assume the machine is properly maintained. And if it's properly maintained, what would it be able to produce at this particular time of day?
Okay. And is that realistic to assume for technologies that depend on some sort of thermal process to create electricity?
Well, again, I think we have to be careful to reflect. If you're saying this machine will never break or require maintenance, that's not true. No machine is that way. What we are saying, though, is just like our own system, you know, if we properly maintain the units, we expect them to be able to produce a certain amount. We start some gas turbines this afternoon, when they push the button, we expect it to start. We properly maintain it, et cetera. Is there some probability it will fail? Sure. But our experience tells us that that's unlikely. So this assumes, for purpose of this analysis, that these machines are properly maintained and that at the time these particular hours are occurring, that these machines will work at the 100% of their rated output.
Yeah, and I didn't mean to infer that it was a presumption or a question about whether they've been maintained or whether the question is, doesn't ambient temperature have an impact on the capacity of a resource that uses a thermal process to create electricity?
It certainly can, but again, all these are limited to 80 megawatts, so we would expect it to be able to produce 80 megawatts at a time.
Well, but taking a step back, you're saying you would expect them to build an 80 megawatt facility or to produce 80 megawatts of electricity?
Again, what we've assumed in this analysis here for just purposes figuring out what a resource might be able to contribute at time of peak, we've assumed that they're able to generate 80 megawatts at time of peak. So however they get to that point, so back to the discussion we had about solar panels, they could build, back to Brown, 12 megawatts of nameplate capacity, but if they only build 10 megawatts of inverters, that's all we're going to get at time of peak.
But if you only are worried about how much they're producing, well, taking a step back, you mentioned earlier that you limited it to 80 megawatts because that's the maximum allowable under PURPA. Is that right?
Yes.
Okay. And so are you aware of any instances under PURPA where there has been issue about how large the actual, what capacity the actual generator is and whether or not it actually qualifies under PURPA as an 80 megawatt unit?
Okay. We can certainly look at issues around that. All I'm getting at is this is just saying a given technology, what is it assumed to be able to produce at time of these monthly peaks? So it doesn't, with a machine, in some ways for this particular technology, it doesn't really matter how big it is. It could be 2, it could be 2,000. It's assumed to be available at time of monthly peak. That because it's not dependent upon the clouds, and it's not dependent upon the sun, and it's not dependent upon the wind. So that's what, the only reason we have to do this math is because these other technologies are dependent upon things that are outside the operator's control.
Right, but if, let's just say, a other technology unit is an 80 megawatt unit that uses some sort of thermal process to create electricity, would you agree that on any given peak, whether it's January or July or August, the ability for that unit to output 80 megawatts changes based off of weather?
Again, I guess I would say it this way. If they designed it for, usually it's the case that if it's 80 megawatts in the summer, you get more in the wintertime. But I'm still back to, for purposes of analysis, you could make it 110% in the wintertime, I guess, if you wanted to do it that way. So it's just not clear to me. I'm not following your point, I guess, as it relates to, this is just something saying, I'm just telling what the math is. You may want to do it a different way, but I'm just telling what we did, is we assumed that this was a technology that could be dispatchable and controllable to be 100% available at the time of these monthly peaks.
And my question is, I'm not trying to make a point. My question is, are you aware of a resource that can both do that and comply with PURPA under your understanding?
I believe there are certain cogen facilities that can be bigger than 80 megawatts, yes.
And still comply with PURPA?
Yes.
All right. So, I want to ask, and I can't narrow down which testimony, so if you need a follow-up or you need to look at it, we may need to take a second. But, I took from your supplemental testimony, that taking into account these two factors, that the companies have adequate generating, or let's just go back to 2017. It's a perfect example of this. That the companies said that they had adequate generation and no expected significant retirements. I think the Zorn simple cycles, but nothing over 50 megawatts of retirements in individual systems. So adequate generation, no retirements, no capacity additions for 15 years. Is that your understanding of where the companies were in about 2017?
I mean, I guess I'd have to go back and look. We do a lot of forecasts, so I don't know off the top of my head.
Okay. So if the companies were in that position, adequate generation, no retirements, no significant retirements, no generation additions for the next 15 years, is it your position then that the companies avoided generation capacity cost is $0?
We have no need for capacity. I don't know why we would be out soliciting to add capacity. So certainly in that 15-year period, we would not have any capacity costs that we would need to avoid.
Okay. So trying to think of the best way to ask this. Are you aware of fixed O&M and stay open capital costs generally as expenses?
I'm familiar with the concepts, yes.
Okay. And are you aware of any analysis that the companies do or have done where it is compared resource decisions, whether to retire or replace current generation based off of whether or not the replacement capacity is more expensive or less expensive than those stay open costs, which are, going forward, stay open capital costs and fixed O&M?
We've done that kind of analysis, yes.
Okay. And the company, and Mr. Wilson, I think, maybe did something similar to that in the environmental surcharge case. Is that your understanding?
We've done cases like that in almost every environmental case I've been involved with, going all the way back to like the 2011 ECR case. So that's a pretty common thing to think about in ECR cases, right? Do I spend more money to keep this plant alive, or do I shut it down and do something else instead?
And I think it's that, which is, do you continue to spend the cost you know you're going to incur every year to keep the plant open, or do something different? That's effectively the analysis, right?
Yeah, so you're looking at, okay, we need a machine to be able to generate electricity, so, or whatever the time period of analysis is, I got to spend money to keep that machine available. And you can compare that to not spending that money and putting in a new machine or buying power from somebody else, et cetera.
And so it's that second part, not spending that money, right? By not making those, spending those stay open costs, you can avoid incurring those stay open costs. Is that correct?
Sure, because all financial analysis is based on what costs can be avoided or changed.
And if two units are similarly situated, right, they're able to produce the same electricity, let's say they'd even have the same remaining life, and one of them exists and the other one doesn't, and the stay open costs, let's say the stay open capital costs are $10 million a year for the current, let's call it a CT, the current CT. I know that this is ridiculous for a CT, but $10 million a year capital costs and $10 million a year for fixed O&M, right? So $20 million a year is the stay open cost for this CT. But you find out that there is a CT available that's going to last just as long, and the going forward fixed cost of it is $15 million a year rather than the 20 of the one you currently have, right? And you could go out and procure this additional capacity unit for less than the stay open costs of the current unit. Wouldn't you then, well, if you assumed that there were no costs avoided by going out and getting the new capacity, you would never buy that new CT, right?
Right, but that would be flawed financial analysis, so I don't know why we would do that.
Why would you do what?
Why we would not properly account for the avoided costs. I mean, I'll make it simple for you. If there was a magic machine that was created today that generated power for $1 a megawatt hour, we'd shut everything down tomorrow and install this new machine for $1 a megawatt hour. I mean, that's our obligation to provide the least cost resources. We know that dollar is far cheaper than any other stay open costs we have going forward.
But that's kind of my question then. This is what I'm getting back to. Is it, even if you have adequate generation, if the cost of replacement capacity is less than the stay open cost of your current generation, 9 times out of 10, you're going to go and procure that replacement capacity, right?
I mean, again, you're going to procure whatever's the least cost resource. I mean, the dilemma generally you have, and I go back to the Bluegrass as a great example of this when we tried to buy that asset. I mentioned that earlier. You know, that was a used plant. We don't have much in the way of used plants available in our balancing area. So it was available to sale for $200 a kW, significantly less than you could build a new CT for. And so that was, we made the case that was kind of a no-brainer to buy that, even though we didn't have a physical need for a requirement. So we're always looking for opportunities to lower costs. So the dilemma is usually you're dealing with new build costs, and new build costs are generally a lot more expensive than the continued operating costs. It's like a car. New cars tend to cost more than just changing the oil and the tires in your existing car. There will reach a point, though, where a major event will occur in your car, and you're going to say it doesn't make sense to fix it any longer, and so we're going to look for a new car instead, or a used car. So,
why then, if the company has adequate generating capacity and doesn't expect any retirements or additions over a time horizon, is the avoided cost not the stay open cost of the marginal generating unit?
because I would assume that the replacement is free. Now, if you can find a resource that's free, then that would be the avoided cost, because I could shut it down and not have to replace it. I mean, a good example of that was Brown 1 and 2. We shut it down and didn't have to replace it.
Are you saying that the marginal unit stay open cost is $0?
No. In your hypothetical, you said the marginal cost should be the stay open cost. I'm saying the marginal costs are whatever the alternative is. in your hypothetical, there was no alternative. So if the alternative costs exactly the same as the stay open costs, then it's the same. So there's, again, unless you're assuming that this alternative is free, it wouldn't be the stay open cost. It'd be the difference between the stay open cost and whatever the cost of the alternative is.
I think you misunderstood my question. I apologize for
Okay,
that.
well, maybe I did.
If the company has adequate generating capacity and has no planned additions or retirements over the planning horizon, let's say 15 years, why is the company's avoided generation capacity cost not the stay open cost of the company's marginal generating unit?
Because you've said, I'm going to retire. The only ways I can say that if I can retire it and not replace it. If that's the case, like Brown 1 and 2, we retired it and did not replace it. It didn't cost the customers anything to replace it, right? Because we didn't replace it or to retire it. So if you're telling me I have adequate and then I still have adequate after retire it, that's the Brown example. If you're saying I have adequate but I retire it and then I have to replace it, then the avoided cost is whatever the stay open costs are versus the replacement costs. You always have to compare the alternatives. It's not.
I think you answered my question with your last statement there then. And I think you're right, you have to assume you're not extra long on capacity. That's fair. But the presumption is if you're going to require generation upon the retirement of the marginal unit, the avoided generation capacity cost is the stay open cost of that most expensive unit. Is that fair?
No, because you're assuming that in your answer that you're not looking at the cost I have to replace it with. I mean, let's assume that there's some very expensive regulations that would, the next cost is much higher than the stay open costs. The customer's not saving the stay open costs, they're trying to avoid this higher cost of this new machine.
Mr. Sinclair, nothing in my question presumes what the cost of the replacement generation is.
That's my concern.
My question is, what is the company's avoided generation capacity cost?
Avoided cost is compared to what they otherwise would pay. And so I'm back to balancing the system. When you're hypothetical, you've told me, one, it's not about having excess capacity, so you're telling me I'm retiring something. Okay, then what's the alternative if I retire? Because again, my retirement decision, your analysis is an economic decision. So why would I retire something that I can keep open and replace it with something that's higher cost? That would not be prudent in my opinion. I mean, that's the analysis we do in ECR cases all the time. So that's the thing I'm struggling with in your hypothetical is you seem to be assuming that the replacement is zero, otherwise it can't be the avoided cost of the stay open cost. It's something else.
The alternative to the replacement capacity is the stay open cost of the most expensive unit, correct?
The alternative to say that one more time?
The alternative to the replacement capacity, what you're comparing it to, are the stay open, the going forward capital costs and the fixed O&M of the company's marginal generating unit.
You said you usually introduce the word marginal generating unit in that hypothetical. I guess I'd have to understand what you mean by that, but.
The most expensive, the next one to retire, the one that is most expensive, right?
Not necessarily, because machines have different capabilities. I mean, our next 3 units that have retired have been our these secondary CTs that don't cost anything, but they don't work very well sometimes. So I guess I'm still at a loss to understand. Again, I have a machine that costs $100 to keep operating. If I remove that machine from the system, the lights may not stay on. So I got to replace it with something. And so then what's that something? Is that more or less than $100? And if it's more than that, then I should probably keep trying to find a way to keep this thing running. If it's less than that, I should try to get rid of that machine and go to this new machine because I can save the difference.
Is that $100 the amount of money that you might be able to avoid if the replacement is less than that $100? The net difference between that $100 and the cost of the replacement?
I'm sorry, say that one more time. I'm trying to.
You compared it to $100.
Right.
That's the bird in the hand. right? The capacity you have.
That's alternative one, whatever it is, yeah.
That's alternative one. Is that your stay open capital cost?
Okay,
I'm asking in your scenario, is that what
Sure,
that is? Okay.
sure.
The cost to continue to run it. That is what you're comparing the replacement cost to, is that right?
The alternatives, yes.
Okay. And if the alternative, the replacement cost is $60 instead of 100, right? That you're effectively saving, you're exchanging for a like kind, assuming that the product is the same, and you're saving $40, is that correct?
Yes.
Okay.
Mr. Chairman, excuse me. May we please have a break? A short break? If you're at a point where you.
I think that would be fine. Yeah, I have a couple more questions, but they're very short. But that would be fine if you'd like to take a break right now. It's
I would, please.
fair enough time for us to take a recess.
Okay, thank you.
We'll take a 10-minute break.
Fine, thank you.
How about a 2:10?
Thank you.
All right, we're back on the record in case number 20, case numbers, the hearing for case numbers 00349 and 00350. We took a break at 1, which is a little earlier than anticipated. Given it's 2:15, I expect we'll probably take our next recess at 4, if no one has an objection, unless something comes up in the interim or we have an IT problem. Before we get started, Mr. Riggs, do you have anything? I know you're the one that asked for the recess. Or
No, I do
may
not.
I continue?
Yes, sir.
Okay. All right, so we were talking, Mr. Sinclair, about the, I guess I was asking about the, you made a differentiation between if that marginal unit, whatever it is, the most expensive, whatever it may be, to retire, the most likely to retire, right, or the one with maybe the most, the highest stay open costs. There's a difference, I think you were saying, between retiring that if even after retiring it you don't have a capacity need, right, versus if you retired it and then there needed to be some sort of replacement capacity because there, you know, demand would be in excess of capacity. Is that correct? That's a different calculus?
Well, yes and no. I mean, it's the same overall problem we're trying to solve, which is minimizing the cost to customers and while providing reliable service. So if we can minimize that cost by retiring something and not replacing it, that's the same activity as reducing costs by retiring something and replacing with something that's cheaper. So it's the same objective function that we're trying to solve for.
But it's a different calculation, right? Or there's an implied cost that is different. Is that fair?
Well, it's simpler in the first case because you're saying, in both cases, you have this continued stay open cost of the existing machine, and then we would say in the alternative, if we don't need to replace it, the alternative is 0, or in the case if we think we do have to replace it, the alternative is something greater than 0.
Right.
But the mathematics is exactly, the objective function, the calculus is exactly the same.
It's that the alternative to 1 is no replacement, which is a $0 cost effectively, and alternative 2 is whatever the replacement cost is. Is that right?
Well, again, I think maybe we're talking past each other. I'm just saying the overall mathematical objective function we're trying to solve is minimizing the cost of serving customers subject to reliability constraints and some other things. So that mathematical formula doesn't change. So it's just what are the alternatives required to evaluate that formula. So in the case where we think we can provide reliability and retire the unit, again, that's already in that constrained optimization function I just talked about, then the math is still as follows, what we just talked about. If in fact we got to replace it with something to maintain reliability, then that extra cost has to be factored in to see what's the minimum cost alternative.
Okay. Is it the company's next, let's call it anything other, ignore the simple cycle CTs for a minute. The company's next retirement for a generating unit, is that Mill Creek 1?
That's the current view, because we did not install the necessary tankage to continue to allow it to operate beyond 2024 for ELG compliance purposes.
And then there's 2 more that are slated for retirement in, is it late 2030, is that right? Or late 2020?
It would be in 2028, as we've said, I think throughout this case, that we believe that NAAQS requirements in Jefferson County are likely to require some additional NOx controls at the Mill Creek Station. Mill Creek Unit 2 does not have an SCR which controls NOx. So based on what we know today, it would likely not make sense to install those controls. And then Brown 3 has some major overhaul costs in the 2026-ish time period we'd have to commit to. And so based on what we know today as well, we think that it would not make sense to make those overhaul investments and to retire that unit as well in the 2028 time period.
Okay. Going back, I think you talked about I'm going to say this wrong. You didn't say mythical. I think you said magical unit with $1 megawatt hour cost, right? You didn't say what the overnight capacity cost would be, but I suspect if it's magical, let's just say it's $100 a kW, something low.
Let's assume it's really magical and it's $1 all in.
Okay, dollar all in. So it doesn't matter really at that point, as long as you can get an endless supply of that magical unit, and that magical unit has the same contribution to reliability. The calculation is effectively that cost compared to both the going forward stay open cost and the marginal cost, the variable cost of the company's generation. Effectively, forget the stuff you currently have. Let's just go with the magical unit because it's $1 in, right? That's cheaper than all the other alternatives. Is that fair?
That's my assumption is hypothetical. That,
Yeah.
that would seem to be pretty straightforward.
So, regretfully, we don't have the magical unit. But my question would be, whatever that unit is, that magical alternative unit, even if the company has an adequate generating, within its target reserve margin, somewhere between 17 and 25 megawatts, and no expected retirements or generation additions over a planning horizon, what is the calculation that the company would do for some sort of whether replacement generation is cheaper? At a very high level, what is that internal calculation to determine with whether or not to go with replacement capacity or continue on the current path with the current fleet?
Well, we typically, look at things over multi-years. So we're going to look at all-in costs, which would include not just only the stay open, sort of fixed costs you're talking about in CapEx, but also the energy contribution that that unit makes and its energy cost, and you're going to compare that to the alternatives. And so the question then is, how long, do you think these units might last under certain circumstances? That's often a case we look at in ECR cases. How long will the unit have to last to pay for this investment? So we want to make a good decision for the long term. I think that served the customers well over time. And usually most capital decisions like this are long-term investment decisions, so it usually makes sense to look at them over multi-years.
And specifically, what are you looking at? Are you looking at whether or not, from a capital and a variable perspective, replacing that generation, replacing some current unit with a replacement unit is cheaper? Is that in a nutshell effectively what you're doing?
Again, you're looking at the total revenue requirements to the system, so you're going to look at, what's the availability of the alternative units, what's their dispatch costs, they're going to be, are they similar, different fuel technologies, what are the various risks associated with load and other things. So that's typically why when we file something at the commission, there's a lot of different cases that we present, and we're trying to find a set of resources that are, what I like to tell my guys, kind of robust under a broad set of possible futures, because we don't know the future with certainty, and we're trying to avoid kind of the cost of being wrong about picking a particular resource that's not going to be robust under a broad set of possible futures.
Ignoring again the simple cycle CTs, when you're comparing that replacement generation to the current fleet, is the avoided cost of keeping the current fleet open for any of those specific units $0 in each year? The avoided generation cost, the avoided variable cost of keeping open the current units as compared to replacing it, are you ever comparing that to $0? Or is that amount ever $0? Excuse me.
Well, again, we use tools that we use to dispatch and simulate meeting load in the future. So, virtually all of our existing generating fleet has some type of fuel cost. So you're going to look at that cost of fuel and other variable O&M, et cetera, compared to the alternative technologies. And so you're going to look at, does generation shift from that unit to other units? So for example, you mentioned the retirement of Mill Creek 1. That unit generates energy today. Some of that energy is going to, just by definition, so we're not adding anything, it's going to shift to other units. we could reach the point where we retire certain units and we replace them with different types of technology, where we're having to run the units in different ways than they run today. So if we added more solar, that never works at night, so the existing coal fleet or gas fleet is going to have to operate more in nighttime than it does today. So we're looking at the 8760 hours cost. It's not just kind of fixed cost or capital cost, et cetera. It's the total cost, total revenue requirements.
When Mill Creek 1 retires, are there going to be fixed expenses that the companies would have expected to occur had it stayed open that the companies will not incur upon its retirement?
Well, sure, there's people that work at that plant, there's maintenance costs, there's a whole host of costs that will no longer exist when you retire a unit.
All right, I really appreciate it, Mr. Sinclair. Mr. Riggs, do you have any redirect?
I do not, Your Honor.
Okay. Are there any other questions for Mr. Sinclair? Mr. Fitzgerald, Ms. Vinsel,
None, thank you.
Mr. Miller?
None, thank you.
Mr. Fitzgerald, were you waving down a
No,
taxi or saying no?
No, Your Honor, I was just saying no questions for Mr.
All right.
Thank you.
Ms. Coverage? All right. Thank you, Mr. Sinclair. Thank you. Can this witness be excused?
Yes, you may.
Mr. Riggs, do you have another witness?
I do, Your Honor. I would call Mr. Wolf.
Mr. Wolf, you mind to stand and please raise your right hand? Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please take a seat. Please state your name and address for the record.
John Wolf, 220 West Main Street, Louisville, Kentucky, 40202.
Mr. Riggs, you may ask.
Thank you, Your Honor. Mr. Wolf, would you please state your full business title?
Vice President, Electric Distribution Operations.
Mr. Wolf, how long have you been with the companies and how long have you served as Vice President of Electric Distribution?
I celebrated my 30th anniversary about 2 weeks ago with the company and have been in my VP role since 2016, I'm sorry. I'll get that, lost a decade there.
Mr. Wolf, did you cause to be prepared, file with the commission in this part of the proceeding, your supplemental direct testimony?
Yes, I did.
Did you also cause to be prepared to file with the commission in this portion of the proceeding, your supplemental rebuttal testimony?
Yes.
If I were to ask you the questions contained in your supplemental direct testimony and your supplemental rebuttal testimony, would your answers be the same today?
Yes, sir.
Did you adopt and affirm those written testimonies as your testimony this afternoon?
I do.
Thank you, Mr. Wolf. Mr. Wolf's now available for an examination.
I will also acknowledge that the testimony I have in front of me represents that I've provided in testimony before, and I don't know if that's what that.
Yes.
Okay.
Thank you, Mr. Wolf. I appreciate the prompt. Do you also have access to the computer screen that's being run by Mr. Lovecamp?
Yes, that is on the record related to this issue.
Does that constitute the entire amount of material you have with you at the witness stand?
The only other information I have is that was sent to us yesterday by the commission regarding the Minnesota interconnection guideline that they expressed a desire to talk about today.
Okay.
Thank you, Mr. Riggs. Mr. Cook, Mr. Horn, any questions?
No questions from the AG, sir.
Mr. Kurtz?
No questions.
Okay. I forget what order I was going in, but I think it was you next, Mr. Spinard. Do you have any questions for Mr. Wolf?
No questions.
Okay. Mr. Miller,
No questions, Your Honor. Thank you.
Mr. Fitzgerald,
Just a couple, Your Honor, thank you. Mr. Wolf, can you hear me okay?
Yes, sir.
Great, great. And did you know whether the companies have ever evaluated the installation of distributed generation or other distributed resources as an alternative to conventional infrastructure deployment?
Yeah, yes, we have.
Okay, could you describe what those evaluations consisted of?
Certainly, and I think a lot of that has been presented as testimony in this case. Throughout the last, I would say, decade at least, the companies have been participating in distributed energy resource working groups in the industry. We have tried to learn from state utilities that are well advanced respective to the amount of distributed generation that's on their systems. We tried to learn from them opportunities that exist to leverage non-wire solutions, renewables for conventional distribution asset investment decisions. And through those efforts, we've learned that there have been some advances, albeit it's been nascent. It's been really a struggle for the industry to tie the cost and reliability benefits of those alternatives to solutions on their grid. And through that, we've also performed some individual studies ourselves. I think the Highland study that's part of our testimony is one example where we tried to look at a situation where it was all in, what would be required through batteries and solar to feed our Highland circuit in Louisville. The cost requirements of that were substantial. The land requirements just to accommodate the resources was almost the same size as the Highlands area itself that would be required. And again, so we've done a lot of research on this and haven't found anything plausible in the near term to make it sensible to do something different on our system. And I think there's some good data again in some of the things that are included part of testimony. One being EPRI looked at that issue back in 2018. There were only 100 non-wire solutions documented in the U.S. Woods McKenzie also, I believe, has some testimony in my material that states how many non-wire solutions were in effect in 2020. It was around 321, and that's specific to what I would call the use of renewables, generation resources that are different than the traditional resources. And there were only 321 of those different types of solutions in some process in the country, and 72% of those were in California and New York. All in, again, the industry is continuing to investigate alternatives, but cost and reliability are preventing those from occurring. And the last thing I'll say on that is non-wire solutions are not unique and are not new. It's a catchphrase today, but the companies have been practicing in energy efficiency measures, demand response, demand side management, energy efficiency, customer communications efforts. Our conservation voltage reduction effort that's part of our AMI project will reduce energy needs of customers and reduce capacity needs on the system. So all of those things are what we would in the industry call non-wire solutions to traditional capital investments. Sorry that was a long-winded response, but we have been doing quite a bit of work in that area.
No, that was absolutely a perfect response, Mr. Wolf, because one of the things I wanted to unpack was the new buzz phrase of non-wire solutions. And let me go through what you just said and see if I captured them all. Demand response is one.
Yes.
Distributed generation could be another.
Yes, sir.
Energy efficiency.
I'm sorry?
Energy efficiency.
Yes, and in fact, I think the industry will cite that that's likely the most prevalent DER, distributed energy resource, that's currently on the grid today due to the advancements in energy efficiency.
And that includes energy efficiency on the other side of the meter, right?
Yes, sir.
Okay. Microgrids, would you consider that a non-wire solution?
Yes, sir.
Okay, let's ask this. In looking at non-wire solutions analyses, do you do a cost-benefit assessment?
I'm sorry, again, I'm struggling with hearing you.
Oh, I'm sorry. Do you do a cost-benefit analysis when you're considering so-called non-wire solutions?
Again, we leave it to our electrical engineers when there has to be a purpose for evaluating a non-wire solution. So if we have some problem on the grid that can be resolved by a non-wire solution, our engineers would look at that solution to determine if it's a viable alternative to what we're doing today. And if the engineers deem that is a viable project, something that has the reliability and is in the ballpark from a cost perspective, they would include some type of cost-benefit analysis on that. Again, from what our engineering staff has seen to date, is they haven't realized the opportunity from a cost and reliability perspective to implement a non-wire alternative to a problem that we have on our grid.
Okay, just so I understand that, Mr. Wolf, because I'm trying to follow it. Did I hear you say that it's only if the engineers think something looks like it's in the ballpark that you would then do a cost-benefit analysis?
Anytime we look at projects, there's a multitude of various solutions that can be considered. And we rely upon the expertise of our engineers who are well-trained, extensive education and experience to determine if the alternatives that are available in the industry are a viable solution to a problem. And what they have deemed to this point, particularly as it relates to solutions involving solar and storage, it's cost prohibitive and the reliability is not where it needs to be to resolve the issue that they're reviewing, and that might be adding a substation capacity project as an example. So at this point in time, there has not been a project that the team has identified that would warrant the level of detailed study and cost-benefit analysis to look at that. And a lot of the data, again, that we've shown in testimony highlights the cost of storage, particularly as it relates to alternatives that could be considered, that we've gleaned from other utilities across the country.
Okay. Do you know whether the engineers that you relied on, have they done cost-benefit assessments?
Yes, all of our projects go through an extensive review, both technically and from a financial perspective. We do cost-benefit analysis on any capital projects that of certain sizes. Obviously, there's small projects that we have different approval processes for, but projects of various magnitudes in accordance with our hierarchy, authority, responsibilities, would go through a very exhaustive financial review, including going through our asset investment system, where we look at prioritization of the project for safety, for customer needs, et cetera, and then it would go through a capital review process. And that again, as part of testimony has been submitted as part of this case, but there's an PVRR, present value revenue requirement assessment that's done on every single project to look at what is the least cost option for our customers.
Okay. In considering the least cost option for the customers, do you know what horizon you're looking at in terms of your planning period?
The most of the projects that are, and I think I've referenced planning horizon in a lot of my testimony, but most of our projects that we look at on the distribution side is within our 5-year planning horizon, which is, so for the data that's part of this case, it's 2021 through 2025. So we would look at those projects and identify the cost savings for that project.
Okay, so you're looking just at the distribution horizon. So if I were to look at the generation horizon, it might be different?
I would have to leave that to the generation team, and that would be, since Mr. Sinclair has already been on the stand, we could ask Robert maybe to answer that.
Okay. And do you know, is there a standardized cost-benefit analysis that the company applies to various ways when it is doing, for example, integrated resource planning, or it's looking at maintenance or repair or replacement of the distribution system, do you have a standardized cost-benefit assessment methodology that you employ?
Again, subject to check, my understanding is that there is a standard model used for capital investment projects, and that model does take into consideration current costs, and then investment costs, and identifying the the present value, RR, revenue requirements.
Okay. Last question, or maybe the last couple of questions I had, Mr. Wolf, and if this is not in your wheelhouse, please send me in the right direction,
Yes,
okay?
sir.
Because I don't want you to answer something that's out of your comfort zone. But there's been some suggestion by other witnesses for the company that the rooftop generation and the value of rooftop generation that is done incidental to the retail customer consuming the energy that they produce, that excess that is fed into the grid at retail should be compared with the utility scale solar array cost of production. You familiar with some of that testimony?
I remember the testimony. Yes, sir.
Okay, and I guess my question is are you aware, as a distribution matter, of any point at which the company has incurred new expenses for the related to the addition of a rooftop solar customer to the system, new expenses in terms of additional heavier gauge lines or transformers or other equipment that is needed to be installed to serve that customer?
We have testimony, I believe it's in PSC 7-37, that talks through the incremental costs that the companies have incurred for various things associated with interconnecting distributed generation customers, net metering customers. And then we also, I believe in testimony, PSC 6-22, subject to check, that describe what additional costs we think we might incur in the future when we start seeing greater proliferation of DG resources on the system. And those costs were gleaned again from our interaction with other utilities. And we have a tremendous benefit in our company that we had a relationship with Western Power Distribution in the UK, who is an affiliate of PPL. And we also have our other affiliate company with PPL, EU in Pennsylvania. And both of those companies have experience with distributed generation resources and have been able to highlight some of these issues they've experienced on their system as they started seeing greater penetration of resources. And so that's where a lot of that data came from. And then also our involvement in the Distributed Energy Resource Working Group, that's an industry organization. And through that arrangement and talking with utilities on the West Coast, utilities in the Midwest, what expenses they were incurring on their systems, a lot of that data, particularly in 622, is based upon their input.
Okay, and the data that you described, the two references that you gave, are they discussing the incremental costs of serving just net metering customers, or are you talking about all distributed generation?
I think in response to 737, it was specific to net metering costs incurred,
okay.
and that would be from the aspect of taking the applications, modeling to accommodate, ensure that that resource would not create constraints on the system, to the change out of the meter that would be required for two-way flow. So yes, the response to 7-37, PSC 7-37, does reflect specifically net metering results. But
okay, and the net metering customer pays a fee, do they not, to cover those costs?
No, not in these cases that I'm aware of.
I'm sorry, you're saying that there is no fee for a net metering customer under the current interconnection and net metering guidelines?
Subject to check, that's my understanding. However, I will say that if there are costs associated with upgrading a transformer to accommodate that interconnection, because through the modeling effort we identified power flow issues, we would then pass that cost on to the cost causer for the upsize of the transformer, unless the company deemed that the transformer needed to be upgraded for other reasons, then we would bear the cost for that upgrade.
Okay, so if there were a requirement to upgrade the system to accommodate that customer would pay for that. Is that what you said?
Yes, and I think, again, in testimony, we have documented on several occasions interconnections that required an upgrade of the transformer that fed that service, and the customer that caused that need for upgrade did incur the cost for that.
Okay, so none of that cost then is paid by other ratepayers?
In that specific situation. And the other issues that are highlighted in 7-37, PSC 7-37, do try to highlight some of the incremental costs the company incurs.
Okay. Mr. Wolf, thank you very much. I appreciate your time, appreciate your testimony. I appreciate your getting on the record what the non-wire solutions actually means.
Thank you, sir.
No further questions, Mr. Chairman.
Ms. Denslow, do you have questions for Mr. Wolf?
Yes, I do. Thank you, Chairman. Good afternoon, Mr. Wolf.
Good afternoon.
I'm going to be referring to several responses to data requests. For those in the room, I've got some of these in your packets. Whether it's easy to use or not, I leave it up to you. I'm going to start with an explanation of one of the items in the packet is Mr. Seeley's rebuttal testimony that was filed in April 12th, 2020. And for those in the room, this is the very first document in your packets. I'd like to read you something Mr. Seeley said, and again, recognizing this was Mr. Seeley's statement.
Yes, ma'am.
From page 25 of his rebuttal testimony. I'll make sure that you're looking at it.
I'm trying.
Where it says the paragraph numbered 5.
Okay.
Distributed energy resources are more likely to add costs than avoid capacity costs on KU and Lg&E's transmission and distribution system.
Mm-hmm.
Distributed energy can create congestion on the transmission system, requiring the investment in distributed energy management system, DERMS, to manage distributed generation resources on the system. Would you say in general, do you agree with what Mr. Seeley said there?
I think generally what we're seeing, again, in our current planning horizon, is that cost associated with interconnection of DG resources, and I apologize, I always refer to it as DG, but net metering resources is what I'm referring to. But costs associated with accommodating DG resources on our system, some of which we've already talked about in 7-37, coupled with what we see in the future for managing voltage. One of the key issues that we've learned from other utilities is this issue of managing voltage. So the distribution grid, as many in this room likely have read in recent months or know, it's a one-way system where generation is at the bulk, and it moves through the transmission grid to the distribution substations. And I'm going to talk specifically about distribution in my response. But at the distribution substation level, we have a lot of equipment that helps us to control voltage. And we set equipment at certain readings, and then out on the lines we have a few pieces of equipment that react to what they see on the system to adjust voltage. Mm-hmm. And that is one-way flow, and we have an obligation to serve. We've talked about that safely, reliability, but the other issue is power quality. And behind that meter, our customers' in-use devices are changing every day, and I would say the sensibility of that equipment is growing over time. And so power quality is a tremendous issue in the industry. And what DG is doing is today, on our system, those DG resources out there, we have no sight into them, we have no control over them. And in a lot of respects, we're dependent upon those customers to manage that resource such that it's not causing voltage issues on the system. And what we've done in this whole rate case is to try to prepare our grid to be able to manage those resources that are now going to be meshed into our grid, that be dispersed and distributed throughout our grid. And we want to be able to ensure that we know what the voltage is at the point of delivery. That's with our AMI case. We've also proposed a volt var optimization, because now in one-way flow, we know the outcomes because we can model it. When you don't know what the inputs are, where all the DG is, now we have to be able to control all the line devices to adjust that voltage where we need to, again, to meet our regulatory obligation to serve customers at the point of delivery within that plus or minus 5% of nominal voltage. And so when we say we think that we're going to incur costs, we know we're going to incur costs to accommodate all that. In the short, what I would call in our planning horizon, our financial planning horizon, 5 years, our distribution planning horizon of 10 years, we do not currently see value in those resources on our system today because of essentially the limited amount of it that's on our grid related to the capacity of the substation transformers and the circuitry. However, when you start looking at the local issues that can be created by it because of that meshed approach to injecting energy onto our grid, we feel like we have to be able to monitor and control it. And so that's what's adding cost in that horizon, and that's what and also what we think is not contributing to adding value during that horizon, back to the capacity-based issues.
And I want to circle back to a couple things you
Yes,
said
ma'am.
there. Are you having problems on your system right now from DG?
No, and I think we've attested to that in our testimony. Again, I've said this before, our relationship with Western Power Distribution and with PPL and with the Distributed Energy Resource Group out, and particularly utilities in the West, what we've learned more than anything is they said, don't wait until you see the exponential growth because it's too late. If you don't make the investments now in intelligence and control, what those utilities have experienced is the need to add capacity because they had no control, no monitoring capabilities of those resources. We have been very lucky to have our relationships such that we can add this technology in advance, be able to monitor, control, and know locationally and at what time these resources are being added to the grid so that we can control and monitor it and not have to make the decision of just adding capacity. And so I hope I answered your question there, but okay.
No, you did.
Okay.
When you say these resources, you're talking about DERMS?
The resources I was talking about was the distributed generation resources on the grid.
Okay.
But for us to actually control the resource would require a DERM system. And at this point in time, we have it as a placeholder. It's not something that we've checked off and said we're going to get. I think largely as we're monitoring our capabilities and the penetration of DG resources on our grid, at some point in the future, when we see that the value proposition is there, when it meets the PVRR requirements, we will look to bring that system on board. Obviously, that will require some work with us and the commission to understand how we manage that relationship with the customer, how we interact, what incentives the customer may need to have to influence them to have the behaviors we need to control the that generation on the grid and make sure we again can reliably and safely serve our customers. Okay.
Okay. When you say you got advice from out west, are you talking about someplace in particular?
I'm a member, our company is a member of American Edison Illuminating Companies, and we have IOUs, investor-owned utilities from across the country that participate on this committee. Companies like Arizona Public Service would be one. All the California companies obviously are there. We have, I've personally been up in New York at Con Edison and talked to them about the REV. program that's up there, Revitalizing Energy Vision, where their state is really pushing non-wire solution and integration of these resources on the grids. And the commonality between a lot of those companies is the level of DG that's on their grid. But we also have relationships with other utilities that are somewhere between where we are and where those companies are. And to a company, one thing they said is don't wait until it's here or you're going to have to make the wrong decisions. And it's adding value or adding cost to all ratepayers.
And I don't want to put words in your mouth. I think that you said that comparing the DG penetration in Lg&E and KU service territory is not comparable to, say, an Arizona or a California.
Yes, ma'am.
And subject to check, if I gave you some numbers about the peak DG capacity. Sir, I'm so used to calling it DER, it's going to make me stumble over it, but I'd rather use a terminology you're familiar with.
Sure. And I'm comfortable with DER too, so.
Then we'll be doing okay.
Yes.
So for KU, the peak DER capacity is, I believe, 0.19% of system peak load.
Yes, ma'am.
And for Lg&E, it's 0.26% of system peak load.
That sounds reasonable, yes.
And to be clear for the record, it being peak DER DG capacity.
Correct.
Can I have you turn to, it's your response to PSC Staff 6 request, item 22. It's going to take me a moment to bring it up.
Yes, I am there, so.
Okay. You know what? I skipped ahead. We've already covered this.
Okay, thank you.
Let's go to staff's 7th request, item 36. And so that you don't have to read it out loud, I will read it.
Okay, thank you.
This is the answer to 36B. Smart inverters can provide the capability to support the electric grid during grid disturbances and during normal operation, whereas traditional inverter-based resources typically shut off or disconnect from the grid during those disturbances, therefore resulting in negative reliability impacts to the grid where higher DG penetrations exist. Many smart inverter functions were developed in response to widespread grid disturbances where inverter capacity was lost. But none of these capabilities are available to the companies without a DERMS, Distributed Energy Resource Management System, DERMS, and legal authority to control customer smart inverters. Simply having DERMS without having the right to control customer smart inverters would not provide the capability described above.
Yes.
So are you saying that Lg&E KU need DERMS for smart inverters in order to support the electric grid during grid disturbances and normal operations?
I think what we're saying here is that at some time in the future, when the penetration of DG resources necessitates more control and operation of those devices, we believe that it will be required to safely and effectively manage the distribution system, and again, to ensure that we, at the point of delivery, can meet our regulatory obligation on voltage. And those resources, basically DERMS and the communications system and the smart inverter, it enables the operability of that DG resource. It enables more efficient integration of that resource onto our grid.
Are you familiar with the IEEE 1547 2018 standard?
Vaguely, only through my electric engineering staff. But
Okay.
yes.
Well, let me ask you, are you generally aware that the IEEE 1547-2018 standard discusses, or requires, or recommends that DG be capable of autonomously adjusting reference voltage?
Yes, and I think that's one of the recommendations came out of California, I believe, that adjusted the controls. And one of the reasons, I believe there was not smart inverters on initial inverters, and they were having operability issues, and so they wanted to add the intelligence to the inverter to enable what would have happened with what I'll call a dumb inverter, customer would have called in and said, hey, I have a voltage issue. We would have sent a trouble technician out to try to figure out what's going on. And if it was the neighbor, so say for the example that the customer next door had solar and was pushing energy over to the other customer, the trouble technician may or may not know what is causing that voltage issue. And what we have learned and understand is that the intelligence is required so that autonomously we can talk to the customer about setting their power factor at 1 as an example, and that would help control the voltage so that both customers don't experience high voltage issues. And I believe that's where they were going with that. It was the intelligence is needed in the inverter to enable that. I think, again, what the DERM system will facilitate, and as we've put in testimony, we won't deploy it unless we see the value is there. And we are part of a company that's demonstrating a project up in Pennsylvania now. Mm-hmm. But when we deem that the DERM system is a viable solution for ancillary services, for, again, operationalizing those resources behind the meter, that's when we think we would pull the trigger to implement a DERMS. The problem with all of that is it doesn't happen overnight. It's going to take time for us to pilot it, to work through all the regulatory requirements of working with our customers. And so we feel like in our planning horizon, 4 to 5 years out, if we think we're going to need a DERMS, that would be when we'd want to deploy it. Before, but we would see that exponential growth going out in that 9-10 year period where we might need a DERMS locationally to resolve some grid issues on the system. Okay.
Are you aware of any other state that allows DG to operate with autonomous smart inverters rather than DERMS?
My understanding is that it's a requirement in California and that many other states are now also requiring it. And one of the reasons that we made it a requirement in our standards is guidelines, is because most other states and utilities that we were dealing with through our DER working group that I referenced earlier are requiring that same standard.
Mm-hmm. And you had mentioned earlier what Commission staff had sent out yesterday in regard to the Minnesota interconnection, or it's a 1547-28 implementation process.
Okay.
Are you familiar with that at all?
I spent some time reading it last night.
Oh.
My wife loved me for that.
Well, I hope she won't hold it against me. At this time, staff would like to introduce 2 exhibits I'm going to refer to here.
Okay.
The first is taken directly from the Minnesota Public Utilities Commission e-docket system. It's a January 22nd, 2020 order in dockets number E99CI16521 and docket number E99CI011023. And these were establishing updated technical interconnection and interoperability requirements. I'm going to go ahead and describe the second one also.
Okay.
This is from the State of Minnesota Technical Interconnection and Interoperability Retirements. So,
Ms. Missel, I have it looks like an order for the Minnesota Public.
the procedural history, yes. And that would be, I would refer to it as PSC Exhibit 3. Do you have a copy?
Yes.
And then separately, a document. It says
Yes.
State of Minnesota.
Correct.
I'm going to call that Exhibit 4.
Okay.
Or tier. And in this order, one of the pieces of the order is recommending, the Minnesota Public Utility Commission recommend that this tier work group discuss voltage regulation. So then we have PSC Exhibit 4. Can I have you turn to page 21 of this exhibit? And tell me when you're there.
I am there, thank you.
So, under paragraph 5.4, voltage and active power control, volt watt. The first sentence after the comma says, the DER shall operate with the voltage active power function enabled with the following default settings. And then provides the various settings for this. Would you agree that this table then sets out the autonomous voltage regulation?
Yes, this does.
So we're seeing here in Minnesota that they've established these requirements, regulations, standards for the smart inverters.
Right.
Okay. So given what's happening with, I'm going to call them smart inverters, if I may. Has LG&E KU looked at developing standards for these inverters rather than looking into DERMS programs?
Yes, that's something actually that our electric engineering group that's underneath the distribution planning group looks at. At this point in time, not all of our DG customers have smart inverters. And so we are going through this transition, this transformation as an industry. And I believe California just started requiring this recently. So it's relatively new in the maturity curve of this overall process. And that is something that we are discussing internally, the need to set a voltage at that smart inverter. The thing that a DERM system does, in addition to managing voltage, is all of those things and being able to, as an example, if you wanted to have some type of ancillary service where you can negotiate with the customer to curtail at certain times, to reduce load, produce generation, to monitor output, all of those things. So the DERM system is a little more than just a managing of the voltage. There's other aspects of that application that would be beneficial to the utility operations and our customers.
And I know that you said that to some degree, LG&E KU have studied this.
We're evaluating the feasibility.
It would, being careful with my words, is there any sort of a formal evaluation that's gone on?
Most of the evaluation that's going on today is taking advantage of monitoring the demonstration projects that we're aware of in the country, and again, specifically our former affiliate where they were at, and then PPLEU, who has worked with their commission to implement a pilot, a really slick communication system that's low cost, and then how they interact with that customer. So we're monitoring all of that. We're trying to understand the cycle time of how long that all would take, and setting up the pilot, working with customers and the regulator on how all that would work. Yes.
And one moment, I need to check with my team.
Okay.
I think we're good. Staff has no further questions.
Thank you.
I would like to move PSC Exhibits 3 and 4 into the hearing record.
Just a clarification before I ask you that objection. Exhibit 3 is just the order that set forth the case that introduced Exhibit 4, is that?
Yes.
Okay. Are there any objections to the introduction of staff 3 and 4?
No objection.
Okay. Stand the motion to move to introduce it. And just please make get those staff exhibit 3 for us. Questions, coverage?
Just a few very short questions. In your supplemental rebuttal testimony filed on August 5th, on page 7, or starting on page 7 where you're talking about the congestion on the distribution system along the grid, and you opined basically, and I'm summarizing here, that net, and at the end, net metering will have no measurable impact on congestion either way. You think it net, at least as far as what you know right now, it nets out to zero.
Horizon.
And that's contrary to what Mr. Seeley opined in his April 12, 2020 rebuttal testimony that you had in tab 1. Is that right?
I'm not familiar with Mr.
It was in the package that was given to you by PSC staff. It was the first tab. I think Ms. Bensel just went through that with you. And on page 25 of that, which is right after the cover sheet, it had that distributed energy resources are more likely to add costs than avoid capacity costs on transmission and distribution systems. So do you disagree with that, I take it?
No, and I think what the conversation was earlier about what we know today with respect to voltage issues on the grid, at least in the current planning horizon, I always try to frame it around that, we anticipate more cost than benefit in the current planning horizon.
But you're
Okay.
proposing zero, though, for purposes of,
I think that was related to capacity, avoided capacity costs. We are proposing zero avoided capacity costs.
okay.
Yeah.
That's it?
Okay, thank you.
Mr. Wolf, what costs are you talking about that are being driven by voltage issues today with distributed energy resources?
Again, I wanted to refer back to 7-37 are the costs that were incremental today. And then those costs that we anticipate going forward would be those that were, I think I stated earlier, 6-22. And those were the issues that would be born out of congestion issues, voltage issues, as we started seeing greater penetrations of DG resources on our grid. We are forecasting exponential growth through the planning horizon. And I think the important thing is, hopefully we stated it well enough in the testimony, is that on the distribution system, due to the granularity of the system, locational issues and value is different than looking at it system-wide. And when we look at delivering energy to our end customers, we have to be sensitive to the locational issues that resources provide. And the discussion that I talked through earlier around voltage and the meshing of generation being produced out on the grid in a different way than the system was originally designed, we have to adjust how we manage the system and how it's constructed to accommodate that, so that we assure that we continue to provide reliable service to our customers.
Well, and I get that that's a worst-case scenario, but today,
I don't think it's worst-case scenario, but it is reality. What we see, not only through our experience with other utilities, but just our engineers in evaluating and modeling the system, they think that, that these would be costs that we should expect in the future and are planning for.
and I just want to be clear, that's not what I asked. This is
I'm sorry.
Today,
Okay.
today, what costs? Today, what problems are you incurring? Not what you reasonably expect.
Yes,
not
sir.
what, let me finish, sorry. Not what other utilities that you're talking to are experiencing, but what issues are you having today that are driving costs from, forget DERs generally, from net metering customers?
Yeah, and I think we've answered that in a submittal. I'm sorry, I can't remember the number, but today we are not experiencing any costs that we're aware of from a technical perspective of operating the grid. I think the only incremental cost that I referred to previously would be more the administrative cost of accommodating interconnections and modeling the system and all those things that occur.
Okay. And so we're not getting really any incremental costs from a technical perspective. That's what I take from your response there. So let me ask then, Mr. Wolf, you think that those interconnection costs ought to be taken up in the interconnection docket?
They are a cost causer, and I would probably need to defer that to Mr. Conroy.
That's fine.
Because that's a regulatory matter that is out of my lane a little bit there.
That's fine. Current net metering customers, which I think I took from, and I'm not great at math, I took from Ms. Vincel's question of you earlier, that you're about 20%, you have about 1/5 of the current, at least by capacity terms, of the cap of net metering customers. Is that right?
That would be an accurate statement, I
Like
believe.
KU's a little under 20%, LG&E is a little over 20% of
Yes,
peak.
a peak load, yes, sir.
Okay, so 1/5 of the way there. And I guess I want to go back to what Vice Chair Cubbage was asking. I don't see the I think maybe Mr. Seeley's is looking into the future, but today, are net metering customers creating congestion on the distribution system that add to costs
Today.
today?
My understanding is the answer is no.
Okay, all right.
Yeah.
And then with voltage, is it your understanding that the company's tariffs on file with the commission approved tariffs for LG and KU, require net metering customers to provide electricity onto the company's grid at the voltage that the company uses?
I'm sorry, I'm not aware of that requirement. I'd have to,
Okay.
subject to check, get back with you.
Yeah, can I ask, Mr. Riggs, would you object to ask if I asked Mr. Lovecamp to just provide a copy of the company's current net metering tariff, or the proposed net metering tariff, or any proposed or current of the tariffs that are in this record?
Do you have that accessible, Mr. Lefty?
And specifically, Mr. Riggs, just the net metering service interconnection guidelines that are in the company's tariff. I'm looking at KU's, Mr. Wolf.
Okay.
And it's PSC number 19, original sheet 57.1.
I apologize, Mr. Chairman. When you're looking at the KU current rate sheet 57.1, are you looking at the one that's currently on file with the commission? I apologize.
That's what I have in front of me.
Thank you.
The standard rate rider, PSC number 19, original sheet 57.1. That is effective with service rendered on and after July 1st, 2015.
Okay.
And actually, I've made all this far more complicated, Mr. Riggs. I apologize. What I should have done. All right, do you have a copy for Mr. Wolf to look at?
Yes.
Okay, let me see if this works. There we go. Let's see if... Try this one more time. Mr. Wolf, what is what's on the screen here the same as what's on your screen up on the wall here?
I believe so, yes.
Okay, great.
57.1, yes.
So, do you see for the net metering service interconnection guidelines for KU here, that it starts off, do you see general hyphen customer?
Yes.
All right, and tell me if what you're reading is, what you see is different than what I'm about to read. General, customers shall operate the generating facility in parallel with company's system under the following conditions and any other conditions required by the company where unusual circumstances arise not covered herein. 1, customer to own, operate, and maintain all generating facilities on their premises. Such facilities shall include, but not be limited to, necessary control equipment to synchronize frequency, voltage, etc. between customers and company's system, as well as adequate protective equipment between the two systems. Customer's voltage at the point of interconnection will be the same as company's system voltage. Do you see that?
Yes.
And so, is it your take that is it your understanding, and this is from the perspective of being in charge of the distribution system for Lg&E, that net metering customers are under a legal obligation to comply with their tariffs to ensure, and that's, let me withdraw that before I get an objection from Mr. Riggs. Is it your understanding from your position that you expect, running the distribution system, based off the rules and regulations that are in place, that customer generators are supposed to provide the voltage that the companies use on their own distribution system?
Based upon the wording in the tariff.
Okay.
Yes.
And has that been your experience? Have you all had any instances that you're aware of where a rogue or, you know, a customer wasn't keeping their system up, wasn't running it well, that you had issues with voltage coming from a particular net metering customer?
Again, I can only base this on what my electrical engineers said to me, which was at times our trouble techs go out and have to make a recommendation on the inverter setting being at power factor 1 to ensure that we don't have voltage issues on the system. So that tells me that we've faced that problem in the past and they had identified a solution, and that's, so my answer is I think there are situations that perhaps the customer can't control due to various issues on congestion and how electricity flows that may result in issues on the grid related to that distributed generation resource.
Yeah, and so let me just ask on that. So what you're saying is based off the company's feedback as to what the voltage ought to have been on the inverter, the customer was, the net metering customer was able to, the settings on the inverter were changed, and that helped the companies, that helped the issue.
The recommendation was made to the customer on how to set the inverter to prevent them from having high voltage issues. And again, we learned that from talking with other utilities who were experiencing similar issues on their grid. And that's the whole reason why the smart inverter recommendation was made by California utilities and their commission, I believe.
And that's similar to the conversation you were having with Ms. Vinsel earlier, isn't it? That's what Minnesota's done. They've said, tune in to these settings. Have your settings at this level as a default. Is that right?
Correct.
Okay. All right, do you have a copy of your supplemental testimony?
Yes, I do.
Okay. Do you mind to just look at page 1 of your supplemental testimony and let me know when you have it there in front of you?
I am there.
Okay. I had down that, well, let me take a step back. You say, I think on line 19, and I've written this down, I don't have a chance to have it in front of me here, but on line 19,
I apologize, Chairman. What page are you on, please?
page 1.
Okay.
Page 1. Line 19, and I have this written down, so correct me if I'm wrong about what it says. You're talking about, a determination of what the appropriate compensation, not compensation, but credit rate ought to be for NMS2, I believe.
Sir.
You state, I have written, it must consider future investments, not embedded costs. There is no amount of net metering that can change investments already made. Therefore, an accurate framework will consider only future investment. Is that right?
Yes, that's in my testimony.
Okay. And are you aware of the application for CPCN in these cases, or I guess applications for CPCN in these cases, where the companies proposed and the commission approved AMI?
Yes, sir.
Okay. And at a high level, I think Mr. Bellar was the one that supported that business case for that CPCN, correct?
Correct.
And at a high level, do you remember roughly, I mean, not the numbers specifically, but what at a high level, what the cost categories and proposals in the business case looked like that Mr. Bellar presented?
Generally, I recall that case, yes.
Okay, and just at a high level, what was the business case? That the company was proposing AMI, and it was net beneficial or net the benefits exceeded the costs, how?
Due to various savings that would be realized by the company for meter reading, for operational efficiency gains, ability from a quantitative perspective to reduce truck rolls, things of that nature. And then I think it also would enable us to implement the conservation voltage reduction program.
Okay, and it would help you implement the conservation voltage program because AMI coupled with volt VAR would give you more insight and the ability to reduce voltages to the minimal levels. Is that right?
Correct.
Or closer to the minimal levels?
To optimize voltage across the distribution grid.
Okay. Absent, let's say the net metering stays at the exact current level, companies still intend to move forward with AMI and volt VAR, correct?
At this time, yes. Yes, sir.
So the investments in volt VAR that are anticipated at this time are not being driven at all by any of the current issues you're having with voltage with net metering, because as we just discussed, not necessarily having that many issues with voltage or none at all with net metering. Is that right?
As I think, as I tried to state earlier, what we've been told is you need to have insight into what's going on the grid from a DG perspective, and you need to have the ability to control voltage control devices on the lines to accommodate those resources on your system and ensure that you have the voltages, the supply, the power flows that you need, again, to reliably operate the grid.
And this is primarily from California, the PPL Distribution Transmission Company in Pennsylvania, and WPD. Is that right?
This is from our leveraging knowledge and experience from other utilities on not waiting until the resources are extended across your system such that you don't have the means to see them and control them.
Okay.
And we are we are forecasting exponential growth through our planning horizon that warrants placement of these facilities on the grid.
Okay, so exponential growth. So you can only get 5 times more at this current level of the current number of net metering customers that you have, or not customers, but net metering load. Is that right?
I believe you're referring to the KRS statute on the cap, and I believe that statute allows the company the option of accepting that resource or accommodating that resource or not allowing it due to constraints on the system, et cetera.
Well, and I don't mean to ask you to tell me what the regulate or the statute says the company's legal authority is, because I'll get in trouble asking that question. But you understand that as a general matter, there's just a 1% cap on that meter.
I understand that, and we are forecasting to be at that rate at 2027 and well beyond that rate by the end of our 10-year planning horizon.
Well, if there's a 1% cap and an obligation ends at a 1% cap, assume, arguendo, it ends at a 1% cap. What's going to drive, what's in the company's forecast or business plan that drives exponential growth of distributed generation in which there's, I would assume at that point, the only ability to get additional compensation for those DERs is as a QF. What's driving that exponential growth in the company's business plan where it assumes exponential growth of DERs?
We have forecasted exponential growth based upon our current growth rate of NMS1 customers.
Well, but the NMS1 customers have significantly increased in the last 2 to 3 years, right?
Yes.
Exactly the same time that net metering was being considered to be changed, right?
Correct.
And so you all have taken the last 2 to 3 years of growth and assumed that to be the baseline level of growth for DERs out to 2037.
I apologize. I don't know the specifics of how that growth curve was developed. I believe it was in unison with talking with our Gen Planning group who looks at forecast in a variety of ways. And so I don't know specifically how that completely was developed, but my understanding is they're showing exponential growth over planning horizon, right.
Okay, and is that the type of document that will be in the 2020, be reflected in the 2021 business plan?
The DER growth rate, I'm sorry?
That's right.
I'm not aware of what is in other organizations' DER growth rate calculation, but I would assume that it would be in there.
Have you been asked, to the best of your memory, it's a big record, have you been asked to provide that in a data request response in this case?
I cannot recall that, but
Okay.
I'm not saying that it has not been asked.
Can we ask that as a post-hearing discovery request? The companies assume growth rate in DERs. Going back to what you were saying, focusing only on the forward-looking, ignoring the embedded cost, would you agree that the company's current customer meters are embedded costs?
Yes, I would agree.
Okay, and is it your understanding that like meter reading expense and replacement of meters over time, those are all costs that are forecast, but also costs that are reflected in an embedded class cost of service study for allocating expenses to customers?
Your Honor, this is well beyond the scope of this testimony, with all due respect.
How is it beyond the scope of his testimony?
You're asking him about the AMI study and a cost of service study?
Yes.
He hasn't testified to this.
He testified specifically that studies to look at avoided costs must consider future investments, not embedded costs. That there's no amount of net metering that can change investments already made. Therefore, an accurate framework will consider only future investment. And I'm asking him about a different study in which this exact framework was looked at. Please let me finish. Specifically looking at the exclusion or inclusion of embedded costs when determining what costs can be avoided by future investments.
And he is not responsible for those studies that you're examining on. He is responsible for the studies that he has put forth in his testimony. You're asking him to testify and compare and contrast his position with other studies that other people have done. He's not responsible for those studies.
He's arguing for a framework, and I'm asking him why the company is proposing a framework that is contrary to a study that he's aware of that was presented in this case. Mr. Bellar was not presented as a witness in this further case, nor is Mr. Bellar saying that these rates that the commission is approving or considering must consider a very specific type of framework in considering or ignoring embedded costs. Who would you prefer that I ask this exact question to determine the veracity of the framework that Mr. Wolf himself is proposing?
Mr. Wolf will testify to the framework he's proposing. To the extent that he understands and has knowledge of those other questions, I'll certainly withdraw my objection.
So, Mr. Wolf, the company's proposal for AMI, right, was to make a new investment to move away from the meters that are an embedded cost, right? Because moving into the new meters, right, purchasing the new meters, the cost of doing that was below the avoided costs of continuing on with the old meters. Is that at a very high level at all what you remember from the AMI CPCN business case that Mr. Bellar proposed?
I think there's a lot more detail in there that likely needs to be gone through for me to straight out say that's representative of that case, but generally there were operational benefits that result from deploying an AMI technology.
Yeah, so there was real savings, right, that were, to your point, something that's certainly in your wheelhouse. The voltage conservation?
Reduction, yes, sir.
Thank you. Voltage conservation reduction, right, that is not necessarily created by AMI, but couldn't exist without AMI, is that fair?
It could exist, but would require incremental costs that we borne out was the least cost option to do it the way that we proposed through AMI.
And that would just be like voltage monitoring some other way
Yeah,
other
bell
than
meter.
at the meter.
I'm sorry for interrupting. Bellwether meters placed throughout the system to identify voltage fluctuations, et cetera.
Okay. And then meter reading expense, right? The meter reading expense, AMI, you don't have to have meter readers generally. You certainly don't have to have it at the level as you do with meters that require a self-read, right?
Correct.
Okay. And going forward, avoiding those costs, right? And avoiding, the replacement, the ongoing replacement of, we'll call them dumb meters because I don't know what else to call them, analog, electromechanical meters, I think is what they are. You don't have to continue to replace those with the other electromechanical meters as they fail if you move on to AMI. Is that another thing that you remember from the AMI CPC and business case?
That is my understanding.
Okay. So, can there be some consideration of embedded costs or past costs instead of ignoring embedded costs or past costs in determining these types of business plans?
As it relates to my knowledge of that particular case related to this case, I would have to defer a question like that to Mr. Seeley, who performs those calculations for the company.
Okay, and so then I just want to make sure that I'm clear, with your testimony, what is it specific about the framework with regards to the distribution system then, whereas the commission must consider future investments, not embedded costs?
My understanding and my belief is, through every financial class that I've ever been involved in, is that sunk costs are not a component of investment decisions, particularly respective in this case to what we can avoid. And when we performed our evaluation of what can be avoided, what we knew was to add capacity would require investment. That's the only cost that we could avoid moving forward as it related to that investment. And I think we've proven in our testimony in 8-14 attachment that there are no opportunities we see in our 10-year planning horizon to avoid that capital investment. And that's how we came up with our cost, avoided capital cost of being zero for distribution, is we cannot see any opportunity to leverage a DG resource on our system to avoid capacity costs.
And this is great, Mr. Wolf, because I think I've found maybe the distinction. Are you using embedded as merely a synonym for a sunk cost? A cost that was incurred, and there is no fact pattern in the world in which will cause the company not to continue or to finish out incurring that cost?
Again, I'm not a financial person. That's not my area of expertise, but my embedded cost to me would be the cost that we've incurred already for investments in equipment that's on the system that we can no longer, that we have no opportunity to avoid moving forward.
Okay, no opportunity to avoid moving forward. So are the company's electromechanical meters in your framework you're proposing here an embedded cost?
And let me clarify that was around avoided capacity costs, not other aspects.
Right, but we're talking about a framework for avoided costs generally. That's what I took your testimony to be about. Am I incorrect?
For me, it was about distribution. I think avoided distribution capacity costs was the opening statement.
Okay, so meters not technically distribution capacity costs?
Not typically, no.
Okay, and what's the distinction between an avoided distribution cost and an avoided distribution capacity cost?
I think we've provided the framework around how we decide what's avoided distribution capacity cost, and is in response to 8-15, I apologize if I'm forgetting, but in testimony, we have a pretty lengthy document that, I'm sorry, that's not the right number.
It's okay, and let me just ask, for what you're saying, I think I've seen it before. Did you all propose what isn't and isn't a capacity-related avoided distribution cost, or what is or isn't actually avoidable?
what was included in the information request was to establish the framework by which capacity projects were identified, and that was in the response, the attachment to that response. And then 8-14 actually shows what we would call potential capacity projects, where we were adding capacity, and that study proves out that during the next 10-year planning horizon, there's no opportunity to leverage a net metering resource to avoid capacity costs.
Yeah, and I appreciate the clarification, because that was your growth, your what you could avoid for the company's growth, right? Certain areas in which you may be expanding and expanding capacity or expanding demand in certain areas. Is that right?
Yes, sir. That would represent, and I think what we've tried to clarify is through our distribution system planning process, we identify capacity constraints on the system where incremental capacity is needed to accommodate load. And that's what we categorize as capacity-based investment decisions and projects.
Okay. So skipping back for just a second, your testimony earlier about the distinction between maybe what Mr. Seeley was saying, which maybe his testimony might have been about congestion, may have been looking outward, a might or could.
Yes,
but we were talking earlier, the question I was asking you is about today, whether there are issues of congestion, issues of voltage related to net metering customers. So on page 3, and I'll give you the time to get there, on your supplemental testimony, when you're talking about this exponential growth, you also discussed that something along the lines of that the rules were created, and that's a paraphrase, but the quote I have is, to ensure net metering would have no appreciable impact on the distribution system. And I think that's on line 3 to 5. Do you see that?
Yes, sir. I'm familiar with that.
If you simultaneously think that the rules were created to where net metering would have no appreciable impact on the distribution system, yet you're discussing trying to get ahead of this exponential growth where there is an impact on the distribution system, how do you square those two things?
My intent in that comment related again back to what we've seen with other utilities who have seen exponential growth and who could not accommodate interconnection by customers because they had to add capacity to the grid to accommodate the DG resource. And so when I think what we were trying to articulate here is that the statute that's in place, the commission limits and the interconnection guidelines on the 15% were done to protect utilities from too quickly adding resources on the grid that would not allow the utility to keep up and do the things necessary to, again, safely and reliably serve load for customers.
And you said 15%. You're referring to the interconnection guideline for 15% on a single circuit. Is that right?
Yes, sir.
Okay.
Yes, sir.
And not just protect the companies, but protect other customers, including the net metering customers, right?
Yes, and I apologize. I should have said that. Yeah,
No, that's
absolutely right.
That's the follow-on impact, right? Well, we may have gotten lucky here. I had one other question that, for something that you had said to Ms. Vinsel, and now I can't find it. That's all I have. Mr. Riggs, do you have any redirect for?
I do not, Your Honor.
Mr. Wolf? Are there any other questions for Mr. Wolf? Ms. Vinsel, nothing? Vice Chair?
Mr. Chairman?
Mr. Fitzgerald?
It's Tom. Yeah, Tom Fitzgerald. I have just a couple of questions if that's not out of order.
Please, go ahead.
Thank you. Mr. Wolf, can you hear me okay?
Yes, sir.
Great. Okay, I'd like to get back to just a couple of things that you've talked about. And the first is in response to Ms. Vincel's question, I think I understood that you said that it currently, with both utilities having net metering customers about 20% of the 1% cap, that you are not seeing capacity constraints or congestion issues. Is that correct?
Could you repeat the questions? I thought you said there's a cap, and I want to make sure that's not what you said on the.
Yeah, well, you are aware that while formally under the net metering statutes, the company could petition to be relieved from having to offer net metering when the aggregate amount of net metering generation was 1% of the supplier's single-hour peak load annually. You aware of that?
Yes.
Okay, and you're aware that under the change in the law, there's no longer a requirement that you petition to be relieved, but there is a hard cap that says once you reach that 1%, you have no further obligation to offer net metering?
Yes.
Okay, and is it your understanding that the company intends to offer net metering once that 1% cap is reached?
I today cannot commit to what the company's position will be respective to that 1%. I believe that requires the input of officers at all levels of the company to understand.
Okay, but your understanding right now is there's not been an announced decision that the company will or won't provide it when you reach the 1%?
Correct.
Okay, great. So did I understand your testimony, your interaction with commission staff to be that currently you're not seeing congestion on the system or capacity constraints that have to be addressed because of net metering customers at the current level of penetration?
That would be an accurate statement. Largely, also, I need to add some flavor there, but
Sure.
We do not currently have the ability to measure the locational and temporal value of distribution value or constraints caused by resources on the grid. Based upon our modeling of this system, when we forecasted potential problems, that would be when we would add a transformer upstream of the customer. But I think the example given to me where we foresee some, and this would be an extreme, and I apologize for that, but on an Easter Sunday, beautiful April day, low temperatures, sunny day, everyone's at church or at grandmother's house, and solar is clustered together on a few homes, that would be a situation where you would see reverse flow and potentially voltage issues on the service lines and at the power transformers. And what our modeling, again, I think it's in exhibit JKW1 in my supplemental rebuttal testimony. I think what we highlight in that study is that when we aggregate several customers at a power transformer, there's potential for power flow exceeding what the typical peak load of that of the customers behind that transformer would be, and that would be when we could have some issues on the grid.
Okay, are you aware of any circumstances where that modeling has actually occurred? Where that scenario has actually played out?
Not in real time. Again, when our trouble techs respond to problems on the system, which may be a fuse blowing, they would not have the records, the data needed to ascertain why that voltage situation occurred. Because we're not metering that resource at this time. That's one of the reasons why AMI, it's a side benefit of AMI that we now have that ability to understand the temporal and locational value of that resource, to the distribution grid.
Okay. Based on the real world current pattern of distribution of your net metering customers, do you expect to see congestion or other technical grid issues at 40 or 60 or 80 or 100% of the cap?
I've talked to my engineers about this a lot, and that's all locationally dependent. I would assume that as we have lower volumes of DG on the system, it would approach zero issues, and as we grow to congestion, when I say congestion, clustering of resources around a common delivery point, such as a couple of neighbors decide to get solar and place them on their meter, that would be when we would start seeing issues out on the grid, and that would potentially occur before the 15% threshold or the 1% system capacity threshold.
Have you seen a circumstance where, given the fact that you do have a 15% cap on the aggregate generation on a circuit relative to that section's most recent annual 1 hour peak load, have you seen a situation where even having multiple net metering customers has caused that sort of problem? Because as you had previously indicated in testimony, my assumption was the reason that we all agreed to the 15% is because that protected against that happening.
We do not, to my knowledge, have any circuits approaching that 15% threshold. That's subject to check. And as I stated earlier, we don't have the ability today to actually measure that. Everything that I'm basing this on is information, again, obtained through our peer utilities, affiliates of the company.
Okay, and do you know whether they have a 1% cap in their in their net metering obligations?
I'm not aware of the cap, but I am aware of what my engineers, again, have shared with me, is that they are seeing issues, locational issues, not system-wide issues, locational issues, sometimes before the, well before the 15% rate is experienced.
Okay, would it be possible for you to produce those circumstances where your engineers have identified those problems in other utilities that are in the PPL system? Or the ones that you're referring to? I know the point has been raised by the companies at several occasions about data, and I'm just wondering, is it possible to produce that information that your engineers have anecdotally provided to you?
That, again, I would have to check with them, subject to check. My guess is this is informal conversations held in conference meetings, industry settings. But I would, subject to check, I would be willing to get that to you if we have documented proof of that.
That'd be wonderful. Okay, Mr. Chairman, I have no further questions. Mr. Wolf, again, thanks very much.
Thank you.
Mr. Riggs, do you have anything else?
No, Your Honor, I do not.
Mr. Wolf, thank you for your time.
Thanks, sir.
You may be excused. Can Mr. Wolf be excused unless you have additional questions?
No,
Mr. Kurtz?
no.
Okay. You can be excused, Mr. Wolf. Thank you.
Thank you.
We're going to take a break here in a minute, but what I'd like to do, if nobody has an objection, is as soon as we come back from the break, take Mr. Barron before we move on to Ms. McFarland. Okay. Everybody fine with that? Okay. I'm way ahead. I've got it. I've got my list here. I promise. Thank you. So, all right, we will take a quick recess. How about 13 minutes? Can we do 4:05? Okay. All right, we'll take a recess till 4:05.
Mr. Chairman, this is Matt Miller with Sierra Club. Unrelated, I just wanted to flag that Joe Childers will be taking over for me after the break. So thanks for your indulgence.
Thank you, Mr. Miller.
Thank you. Thank you all.
numbers 2020-349 and 2020-350. I think we just had a cross-examination of Mr. Wolf, who we've excused, and there's been no objection given at this time to allow Mr. Kurtz to call his witness in this case. So, Mr. Kurtz, if you will, please call your witness.
We call Steve Barron. Actually, the company requested that Mr. Barron testify, so I'll turn it over. He's on the screen, but I'll turn it over to the company.
Okay, do you mind to do, I'll swear him in and ask him for his name and address. Do you mind to do an initial amount of direct?
No.
And just to ensure that he has, just to introduce the witness. All right.
Okay.
Mr. Barron, do you mind to raise your right hand, please? Thank you. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
All right. Please state your name and address for the record.
Stephen Barron, and my address is J. Kennedy and Associates, Inc., 570 Colonial Park Drive, Suite 305, Roswell, Georgia, 30075.
Okay. It's 4 o'clock.
Thank you,
Mr. Kurtz, you may ask.
Thank you. Mr. Barron, did you provide testimony in the earlier phase of this case?
Yes, I did.
Okay. Your Honor, I turn Mr. Barron over to the company.
Yeah, and Mr. Barron, do you mind, just for the benefit of the commission and the parties, to indicate what documents you have in front of you, or what documents you have at hand available if you're in front of a computer? I assume you're in front of a computer.
Yes, Mr. Chairman. I have, I think, 3 pages from my original direct testimony in this case, pages 8, 9, 10, well, 4, I guess, 8, 9, 10, 11, 12. I have 2 pages from, I believe, Mr. Seeley's testimony, his supplemental rebuttal, and I have a copy of supplemental exhibit RMC2, which is the NMS2 tariff. I also have a pad that I have some notes where I went through some of the testimony, but not all of it, that has been filed, I guess, since the commission's order in the its first phase.
The June 30th order?
I recall reading, I don't have a copy of the order.
Okay.
I do not have a copy of the order.
I see what you're saying. All right, thank you, Mr. Barron. We'll just run down the list first in the ordinary order. Mr. Horn, Mr. Cook, are there any questions of the AG's office to Mr. Barron?
No questions, Your Honor.
Okay. Mr. Spinardi, any questions for Mr. Barron?
Mr. Chairman, we don't necessarily have any questions at this stage, but I want to point out to the commission that Mr. Barron didn't file any testimony in the supplemental proceedings, the additional proceedings. He filed on March 5th. The companies had discovery against him. They were allowed to cross-examine him at the hearing that we had in April. They filed post-hearing briefs. Through a letter entered into the record on July 12, 2021, and this was to the executive director from Mr. Cook, it states, in pertinent part, Mr. Barron's testimony at pages 8 through 12 sets forth the positions of the AG KIUC regarding the following tariffs: net metering service 1, net metering service 2, small capacity cogeneration qualifying facilities, and large capacity cogeneration qualifying facilities. And we had an extended conversation this morning, and I think the record will reflect it took place around 10:35 a.m. on due process. The companies certainly have had due process with regard to the testimony that Mr. Barron has previously filed. And I think the record always speaks for itself, but I think the phrase always that catches me is this phrase that was used, gotcha, that this is to avoid any sense that somehow or another there's this got you aspect about this hearing. And so certainly CASIA is going to object to anything that's about cross-examining this witness on testimony that hasn't been submitted. Certainly we are going to object to the fact that there's no due process grounds for allowing continued examination on testimony that the parties that presented the witness itself
say that it stands as was submitted on March the 5th and otherwise tested at the hearing. So I think the company should go first and find out whatever they have, whatever questions they have to ask. And we may object again, but we would rather follow the companies because I don't know what they're going to ask because there's been no testimony submitted, there's been no discovery in the record in this phase. We don't know their position, and that's the whole thing about at least giving us some fair opportunity. Again, we're trying to avoid what was characterized earlier is we're trying to avoid hearing this gotcha aspect of the hearing. So, and if they want to rebut it or if they, whatever positions they want to take. But that's the problem that CASIA has with this introduction of this witness.
So, so Mr. Barron did provide testimony on the LQF, the SQF, and the net metering at the initial part of the case. And what you're saying is you're sort of not waiving your objection. You may assert your objection if the cross-examination of Mr. Barron goes beyond Mr. Barron's direct testimony in this case on those issues.
Yes, sir, Mr. Chairman,
Okay.
that's perfect.
That's fine. And I'm going to go ahead and ask if you have any questions for Mr. Barron. We've been going through everybody twice, and there's certainly the opportunity we're going to make sure everybody, if there's a question that somebody wants to ask of a witness, we're going to give an opportunity to ask it here, subject to people can waive or assert the objections that they would like to make. But I'm going to go ahead and ask if you have any questions. If you don't, that's fine. Then move along to Mr. Riggs. After staff, council, and the commissioners have an opportunity to ask them questions, to give Mr. Kurtz an opportunity to redirect, and then we will come back again, and if you have any additional questions at that time, you're more than welcome to ask them, and we'll do the same thing again.
Most certainly, that's fair, and we do have about a half dozen questions then that we're ready to ask.
Okay, please proceed.
Good morning, Mr. Barron. Can you hear me?
Yes, I think it's afternoon, actually.
Mr. Chairman?
Oh, I'm sorry. I'm going to wait. Someone else wants to speak.
Mr. Fitzgerald's getting another cab. Mr. Fitzgerald, did you have something?
Hi, Mr. Chairman. I just, for the record, at this point, we don't have any questions.
Okay, all right, thank you.
Okay.
Please proceed, Mr. Sonoma.
Thank you, and I'm sorry, you're correct, Mr. Barron, it is the afternoon. I'll make this brief. On March 5th, 2021, Kentucky Industrial Utility Customers, Inc., and I'm going to refer them from now on as KIUC, and the Kentucky Office of the Attorney General jointly filed your direct testimony and exhibits into the record in both of these proceedings. Is that correct?
Yes.
Okay, and are you aware of the Commission's order on June 30th, 2021, entered into the records in both cases that establishes a procedural schedule for further review of the company's net metering and qualifying facilities proposals?
I'm generally aware of that order.
Okay, and thank you. And for ease of reference, we'll just refer to the activity in these cases after June 30th, 2021 as additional proceedings.
All right.
Okay. For the additional proceedings, on behalf of KIUC or the Office of the Attorney General, did you prepare supplemental testimony for the additional proceedings?
No, I did not.
Okay. And on behalf of KIUC or the Office of the Attorney General, did you prepare supplemental rebuttal testimony for these additional proceedings?
No, I did not.
For the additional proceedings on behalf of KIUC or the Office of the Attorney General, did you prepare an update to your testimony and exhibits filed on March 5th, 2021?
No.
Okay. And for the additional proceedings on behalf of KIUC or the Office of the Attorney General, did you respond to any requests for information by the companies, commission staff, or any of the interveners?
No, I did not receive any, nor did I respond.
Thank you, Mr. Barron. I appreciate all of your answers, and thank you, Mr. Chairman. That's all the questions we have at this stage.
Mr. Spinard. Mr. Fitzgerald, you said you had no questions for Mr. Barron, is that correct?
At this point, subject to something being raised in the Lg&E's and KU's questioning, at this point, we have no questions. Mr. Barron, it's good to see you, by the way.
Mr. Mr. Miller left us, didn't he? Mr. Childers, do you have any questions for Mr. Barron? Does Sierra Club have any questions for Mr. Barron?
No questions, Your Honor.
All right, thank you. Mr. Riggs, do you have any questions for Mr. Barron?
Your Honor, thank you. Good afternoon, Mr. Barron. Can you hear me?
Yes, I can.
Mr. Barron, are you an economist?
Yes, I am.
You have a master's degree in economics from the University of Florida you earned in 1974, is that correct?
That's correct.
Okay. How many years of professional experience do you have in the electric utility industry in the areas of cost and rate analysis and economic analysis?
It exceeds 40 years. I started with the Florida Public Service Commission staff when I got out of graduate school in 1975, I guess.
How many cases have you filed testimony, generally speaking?
It probably approaches, it's between 350 and 400.
You've testified in every KU or LG&E case since 1981, haven't you?
I'm not sure I've testified in every case, but I have been involved in quite a few LG&E and KU cases since '81. I think in 1981, it was actually on behalf of LG&E.
So when I said cases, I meant, and I apologize, I should have said rate cases. You've testified in all of their major rate cases since.
Yes, I can't say that I've been in, I don't know if I've been in every single one, but certainly in recent years, every single one, and it has gone back to at least the early 80s.
You presently represent the Georgia and Louisiana commissions as well as industrial customers, is that correct?
That is correct. And we also represent a number of other commission staffs or consumer advocates throughout the country.
Mr. Barron, in response to the question, I think, from Mr. Spinard about who you're representing in this case, I understand it correctly that you're representing in this specific testimony both the Office of the Attorney General as well as the Kentucky Industrial Utility customers?
That's correct.
And the members of the KIUC include, for example, an LG&E customer like Ford and a KU customer like Toyota, is that correct?
That's my understanding, yes.
Okay. Now, during your career in the electric utility industry, have you ever performed a marginal or an avoided cost of service study? I have been involved in studies like that. I believe the work I did, one of the projects I did for LG&E back in 1981, and I'm not certain of the date, was some type of marginal cost analysis, but I have been involved in those throughout my career. Okay. So it would be fair to say you're familiar with the term marginal cost, correct?
Yes.
Would you agree that the term marginal cost can be defined as the change in cost due to a change in demand?
Yes, that would be one way of describing it, yes.
Now, isn't avoided cost a similar concept?
I tend to think of avoided cost in that manner. Perhaps the only difference, I think, is in its common application in the utility industry today, avoided costs would tend to be calculated based on some larger increment of change. But essentially, avoided cost is the change in cost or the incremental cost associated with an incremental usage or decremental usage.
Okay. Are you familiar with the Public Service Commission of Kentucky's regulations definition of avoided cost that states, quote, incremental costs to an electric utility of electric energy or capacity or both, which, If not for the purchase of the qualifying facility, the utility would generate itself or purchase from another source, close quote.
Yes, I recall reading that definition at some point.
Okay. Therefore, avoided cost is the incremental energy or capacity cost that the utility would not incur if they purchased energy from a QF or a net metering customer, correct?
That would be one example of avoided costs, and particularly as relevant in this case, I think I would agree with you, sure.
Okay. What is the difference then between the marginal energy cost and the marginal generation capacity cost?
The marginal energy cost would generally be a very short run or short-term incremental cost, and it's usually associated with the operation of a utility's portfolio of generators, or a purchase power cost. If you're in a market-based environment like PJM, it would be LM, locational marginal price. If you're not in a RTO, as the company's case, it would be similar to what's called system lambda, which would be the incremental or decremental cost of the next unit of production. That would be a marginal energy cost. Marginal capacity cost is really a fixed cost associated with a longer term avoidance of the need for additional capacity, but it could also be calculated presumably in a decremental fashion also.
Embedded costs are not the same thing as avoided costs, are they?
That's correct.
Don't embedded costs relate to capacity costs that have already been incurred by the utility?
Yes, I mean, basically, embedded costs is a construct that's usually used in a rate-making environment where there's a test year, and during the test year, there are a variety of fixed costs. If we're talking about, let's say, generation capacity-related costs, it would be the fixed costs associated with own generation, purchase power demand costs, or something of that nature.
Well, aren't embedded capacity costs essentially sunk costs?
Again, they would be in the sense of test year rate making. So if the embedded cost was defined as the 12 months ended July 2021, then clearly those would be sunk costs. But to the extent, so generally embedded costs would be similar conceptually to a sunk cost. A sunk cost is usually a term used in an economic analysis referring to costs that cannot be avoided.
Now, avoided capacity costs can be higher or lower than embedded costs, correct?
Yes, that would be true.
Therefore, avoided capacity costs depend on the changes in capacity-related costs that are planned in the future, correct?
Generally, that's how they are traditionally calculated. There may be multiple ways of doing it, again, depending on whether you're in an RTO environment or you're like the companies in what I would call a standalone situation. But generally, avoided capacity costs look at the change over time of an expansion plan as pursuant to a change in load, so that if you increment or decrement load by a certain amount, and you look at the expansion plan over many years, calculate the present value differences, that would give you a measure of the avoided cost, the long-term avoided cost of generation capacity for an increment of load.
Now, it's possible, given your testimony, I just saw the signal flash. So we're still connected. I thought we had disconnected for a moment. Now, it's possible, Mr. Barron, that a utility's marginal generation capacity costs could be very minimal or small, correct? It's possible.
Yes, sure, I would expect so.
So, for example, if a utility has sufficient capacity to meet any increased demands over its planning horizon, it's possible that the utility's generation capacity costs could be nearly zero.
That would be, that would probably be true, that if, again, as I was describing in my prior answer, if you look at an expansion plan and say we have a base case where we're going to retire some units in 3 years out or 5 years out and add certain types of units 6 years out, depending on load requirements and so forth. But over time, we have an optimal expansion plan to meet a certain level of load expectations year by year. And then we look at what happens if we change the load. Let's say we increment it by a megawatt every year. What would be the expansion plan? And that would give you, the difference in those two would give you a measure of avoided capacity costs for, or the change in cost for a change in load, which is the definition we were discussing early on.
To take the flip side of the proposition, if a utility's demands are decreasing, it's possible that a utility could continue to have capacity to serve its existing customers, and its marginal or avoided capacity costs could be zero or very low, correct?
Yes, I mean, there's a lot of, it depends how complex you would want to get in the analysis, but as a general matter, that certainly could be the case.
And would that be the same case when it came to analyzing transmission costs, correct? That is, if the utility's peak demands are decreasing, it's possible for its marginal transmission costs to be zero or nearly zero, correct?
Yes, and again, if you think of it as in the construct that I was talking about of the change in a long-term plan for a change in load, if, let's say, the base case had 10,000 megawatts of load and a transmission system designed to meet that didn't need to be expanded, if the load was not growing or well, let's say it didn't grow at all over a 20-year period, that was the expectation, then the incremental cost would probably be de minimis.
Okay. Now, in calculating marginal generation capacity cost, is it necessary to consider the time frame when a utility needs to install additional capacity?
That certainly would be a factor in the type of analysis that I was describing, where you look at an expansion plan and look at the change in the cost as a result of a change in load. So I would expect that, I mean, I've read the testimony of Mr. Seeley and I think Mr. Sinclair, and it's my understanding that the company's plans, and I haven't reviewed those plans, show a need for capacity maybe no earlier than 2028. And so I would think that would affect the calculation of avoided generation costs.
Okay, now with respect to the calculation of that avoided generation cost, for the sake of the question, if there's no capacity need for a number of years out, is it necessary to at least discount the cost of future capacity costs in determining the marginal or avoided capacity costs?
Yes, I would agree with that, if basically, if you assume that, say, additional supply today wouldn't have any impact on cost until 2028, then the value of that should be calculated on a net present value basis to today, or it would have to be based on some longer-term levelized cost, which would effectively incorporate the same concept.
So what I understand your answer to say, and please correct me if I'm wrong, is that if a utility does not have a need for capacity, say for 7 to 15 years, then you would agree that it would not be appropriate to simply use the undiscounted cost of a generating unit to calculate the long-term marginal or avoided costs.
Yes, I mean, basically what, in the concept, in the construct of what we're talking about in this case, which is whether the value of avoided generating capacity, for example, and the amount that would be included in a payment rate to net metering customers' exported energy, that the net present value of the benefit of any additional capacity provided by the exported energy would have to be reflected, so that if the capacity if you assume, and I haven't done a study on it, but if you assume that that capacity had no value today or next year or the year after, and you would certainly want to incorporate that into the calculation of that payment rate based on avoided capacity cost.
And you would incorporate that into the calculation, generally speaking, by discounting it, correct?
Yes, yes, that's how it would be done.
Now, based on your 40-plus years of experience in working in the electric utility industry, can solar facilities be called on at any time to provide capacity to the grid?
Well, they're intermittent capacity. Generally, solar facilities are usually deemed to have what's called a capacity value, but with respect to being able to be called upon to serve a reliability or capacity need within, say, 10 minutes or 20 minutes or 30 minutes notice, obviously the availability of solar to produce energy is a function of sunlight.
So you describe solar's ability to provide capacity as intermittent energy, I think.
Yes, yeah.
So in other words, solar facilities do not provide what's called firm capacity, do they?
Certainly on a dispatchable basis, that's correct. As I said, solar is usually, for planning purposes, deemed to have some level of capacity value for planning purposes.
Mr. Barron, should the companies, specifically KU and Lg&E, plan their resources and conduct their operations based on the principle of lowest reasonable cost, in your opinion?
Yes, I absolutely agree with that.
Okay. Would it be, therefore, sound economics and appropriate for a utility to pay a high QF customer or a net metering customer generator for capacity or energy at a higher cost than for which he could purchase similar capacity and energy from a purchase power agreement?
I would think as a general matter, no. To the extent that that would occur, the utility, all else being equal, assuming there was no legal or regulatory requirement to do otherwise, that would result in costs and charges to the body of ratepayers that are not least cost.
Okay. Thank you, Mr. Barron. Those are all the questions I have.
Ms. Vinsel, do you have any questions for Mr. Barron?
Just a very few. Good afternoon, Mr. Barron.
Good afternoon.
I didn't mean to talk over you, sorry. I want to
That's
clarify. I didn't hear Mr. Riggs' citation to the definition of avoided costs, and if you made it, I apologize. But this definition that you were first asked about avoided costs, and I'm asking you only in a lay opinion, not in legal opinion. Are you familiar with the regulation that the commission has for small power production and cogeneration?
I could not recite it to you now. I may over, at some point in the last few years, have looked at it, but I certainly can't recall any specifics.
I ask only because I have it in front of me. Like you, I couldn't recite word for word. But the definition that Mr. Riggs provided of avoided costs comes directly from that regulation. And are you aware, again, just from your lay opinion, whether or not this regulation is based upon federal law, the PURPA law, and the definitions?
No, I'm not.
So are you familiar with any of the federal PURPA definitions of avoided cost?
Again, over a number of years, I'm sure I have reviewed those in some proceeding that I have been in, but I have not reviewed them recently, so I don't know if I could, certainly I couldn't recite it to you now.
That's fair enough. I have nothing further, Chairman.
Vice Chair?
Nothing.
Good afternoon, Mr. Barron.
Good afternoon.
Please take your time, get your drink.
Sorry.
No, I wasn't being facetious. I mean it. Please do. When I lean forward, you never know. There was another person who sat in the seat when they leaned forward. You never knew how long it was going to be. Mr. Riggs asked you some questions about avoided costs and embedded costs. And my experience with you, Mr. Barron, is you do a number, in addition to being an economist, and I guess maybe this is just part of being an economist, you do a number of cost of service studies across the jurisdictions that you work in. Is that right?
That is correct. Mr.
So
Chairman.
embedded, the term embedded cost is not something that's new or foreign, or probably a term you go a week without hearing. Is that probably right?
That's fair. That's fair.
So when we talk about, well, let me take a step back. Embedded costs, just from a cost of service perspective, a test year level of embedded costs with a December 31, end of year ending balance. Does that include only capital cost, or does that include expenses in which a utility might have incurred during that year?
It would include expenses as well.
Okay.
It's a full complement of costs that comprise revenue requirements.
Okay, so when I say expenses or embedded costs from a cost of service perspective, it's the more general term cost or expense rather than the utility distinction between a capitalized cost and a cost that's recognized within a year. Is that correct?
Yes, I would agree with that.
Okay. And so if the utility is moving forward in a going forward basis and comes upon in their operation a cost in which is technically avoidable, but rather than avoiding it the cost is incurred. For the utilities purposes, at that point, it's an embedded cost. Is that fair?
Yes, I think generally, I mean, I would view embedded costs as those costs that are on the books of the company during the test year.
Yeah. And if you, just at a higher level, embedded costs are effectively costs that are incurred, whether they were avoidable or not, right?
Yes, embedded costs really, at least from my perspective, there's no assumption one way or the other about whether they should or should not have been incurred or whether they could have been avoided or not. They are simply the costs that were incurred.
Right. So in a test year, if let's just make up a generating unit, right? Mill Creek 1 was discussed earlier. If Mill Creek 1's fixed O&M expense is $10 million and their stay open going forward capital cost is $10 million a year, the test year will have reflected that $20 million on that basis as an embedded cost for cost of service purposes. As a general matter, is that right?
Yes.
Okay.
Yes.
But that doesn't mean necessarily that if Mill Creek 2, or Mill Creek 1, excuse me, was retired on December 31st, 2021, that in 2022, the company is necessarily going to incur those going forward capital and fixed O&M costs, right?
Correct.
So it went in the matter of...
snapshot of...
Sorry, please go ahead, Mr. Barron.
No, I was just saying, this is embedded costs are a snapshot of a time period.
Okay.
Historic time period generally.
Right, and so because something is an embedded cost in one time frame does not necessarily mean it is or isn't avoidable. Is that correct? Going forward.
Yes, I just want to make sure, I mean, I think I'm certain that I'm agreeing with you, but I just want to put it and make sure it's in the right context, that embedded costs represent the costs that have been incurred during a specific time period, putting aside projected test years or pro forma adjustments. But that for any individual item that those costs represent, that it could have a different value in the next period. And if it's avoided, it's avoided.
Right. You can't do anything about the cost you incurred, but you could possibly avoid incurring that cost going forward.
Yes.
Or the cost for the same action or activity or, increment or decrement of demand going forward.
Yes, I think that's fair. I mean, obviously, the context in which this is a very broad-based hypothetical, but yes, there's nothing I would disagree with what you're saying at this point.
Yeah, it's an oversimplified sort of conversation, but I'm trying to get to brass tacks here. So if embedded costs include costs that are fixed, fixed expenses, not avoidable, costs that technically could be avoidable, and include capital costs, and include operating expenses, right?
Yes.
All those things. And we discussed earlier that a cost that maybe everybody agrees is avoidable, but doesn't get avoided, in the backwards looking analysis that is embedded cost of service rate making, that's an embedded cost at that point because it was incurred during that previous time frame. Is that right?
Yes.
So avoided costs that are incurred and not avoided become embedded costs.
That's true, yes.
Okay, so you would agree that there is a relationship between avoided costs and embedded costs. It may not necessarily be a correlation, but there is a relationship.
Yes, except I guess I'm having a little trouble trying to, it strikes me that avoided costs and avoided costs is an economic concept. Embedded costs is really more of an accounting concept. So trying to tie the two together, I'm not sure that I'm grasping how that would be done, but in terms of your questions, they're not a problem.
Okay. And the reason I ask is that I think that's a perfect comment, Mr. Barron, is that embedded costs are an accounting for costs that have been incurred, right? It's here's what you, it's like your monthly bank statement, right? Or your monthly credit card statement. This is what you spent. You can try to take something back maybe and change your credit card statement, but otherwise that's just an accounting of what you actually spent, right?
Yes.
But the fact that you spent a certain amount the past month on clothes doesn't necessarily mean that you have to spend that amount going forward, right?
Correct. Okay. And the decision as to whether to spend it or not is really entirely, it's based on the factors that are relevant at the time.
That's perfect. If it's a mortgage and you don't plan on selling your house that next month, your bank statement, you did reflect it the next month, you're going to have that cost the following month, right?
Right.
Okay.
In that case, it's not avoidable, at least certainly not in the very short term.
That's exactly right. That's where we start getting to talk the economic difference between short term and short run and long run. I'd also like to ask on this issue of avoided cost and the similarity to marginal cost. I think, and maybe this is what you were getting to with your response to Mr. Riggs. Mr. Riggs was asking you, I think this is paraphrasing maybe what Mr. Riggs asked you about marginal cost being the change in cost based on a change in demand. As if marginal cost is by definition linear. Right, you move one way amongst an axis, and if there's a linear graph, it moves you along that line with that change in demand.
Yes, I mean, it could be a curvilinear. Generally, in the case of in the utility industry, energy costs are probably the closest to short-term marginal cost, and doesn't necessarily follow on it's not linear necessarily. I mean, as you approach higher cost generation in your portfolio, the cost per increment of load to serve that, the energy costs might go up, might be much higher than it was in the prior increment.
That's actually what I was going to ask you. It's not perfectly linear, or even a curved line. It may necessarily, when you start talking about utility avoided costs, it may be a stair step, right? That there may be some change in demand that doesn't necessarily change cost, and then all of a sudden it may significantly change cost. One additional increment in demand. Is that your experience?
Well, in the case of energy costs, let's say marginal energy costs or avoided energy costs, it does tend to be a smoother curve. In the case of capacity costs or fixed costs, it becomes much more complicated, as Mr. Riggs was asking me about in terms of the timing of capacity additions to meet load and so forth. And I think that would be probably closer to maybe a stair step or some other type of curve in terms of measuring avoided cost.
Yeah, and avoided generation capacity is exactly what I was going to ask about with that stair step. The longer run, capacity, I guess it presents complications in a number of senses. It's very expensive as a general matter, right? We're talking millions of dollars. It's fairly long lead times as a general matter. It's usually not months, it's usually years when you're talking about the change in cost or the change in demand. And I've heard generation referred to as chunky. Do you know what I mean when I say that that capacity or generation is chunky, right? It doesn't come in 1 megawatt increments usually. It usually comes in maybe closely the nearest dozen, but usually the closest, the nearest 100 megawatts.
That's why typically, or at least I've seen in many, many cases, the calculation of avoided capacity costs is a comparison of two optimal expansion plans based on a base case and let's say, a load increment case. And the net present value of all of the costs in both of those would tell you the change in future revenue requirements associated with generation capacity for a change in load. So that's exactly why the analyses tend to be done that way.
Okay. And then my last question is if you can compare, for instance, avoided cost that just so happens to be linear, right? That there's a direct correlation in a short run time period versus an avoided cost that is more of a stair step when you look at the change in cost versus the change in demand. If you change your demand by 1 increment on the stair step and it doesn't actually change the cost any, and you move along, should you just assume that there's no avoidance of costs along that change in demand, or should you, to your maybe this is what Mr. Riggs was getting to, or your answers to Mr. Riggs, should there be some sort of acknowledgement that there's about to be in 10 or 2 or 100 megawatts a significant change in cost, right? And discount or take that into account as you move along that data set?
Well, you definitely would discount it, and it really, let's say, move away from net metering, but towards, let's say, a PPA, a capacity PPA purchase by utility that has a need for capacity in 2028. But you want to enter, there's good deals around today, and it turns out that it's economic to enter a 20-year contract for that PPA capacity starting today, even though the value of that capacity to your system is de minimis for, let's say, the next 6 years or 7 years. You still could calculate over a long-term period, let's say if you're entering a 20-year contract, the value. That would incorporate net present value calculations or levelized cost calculations, which again are the same, one and the same. But the critical thing, I think, in looking at it is that you have a 20-year contract, a commitment to provide that future capacity. It certainly, it would be problematic to pay a PPA, a capacity charge every year until 2028, and then not have that capacity from the PPA available because the customer had no obligation to provide the capacity then. So the contract is an important element in that. But I don't think I'm disagreeing with anything you're suggesting, but it is a complicated, economic analysis that in order to protect consumers, you really do need to evaluate these things.
My last question is, Mr. Riggs was asking you about whether it's possible for an avoided generation capacity value to be zero or near zero or de minimis. And I think, I don't want to characterize it, but I think you answered it's possible, was my understanding. Is at a very base level, the questions I think you may have been on earlier when I was asking Mr. Sinclair, is the stay open well, I say stay open as a broader term, but really stay open cost for a generator, I'm referring specifically to fixed O&M and going forward capital costs, right? Costs that you are explicitly incurring to continue to operate the facility that you would not necessarily if you retired the facility. Are those, if the retirement of that, are those a fair proxy for the utility's avoided capacity cost in a time in which the utility has adequate generating capacity or is within its current, target reserve margin or whatever it may be, not long, not short?
I think I understand your question. Basically, you have a unit that could be retired or maybe put on what's called extended cold shutdown, where it's not retired, it's not demolished, but it doesn't operate because there's a more economic alternative. I suppose there could be a calculation based on the savings from that. Again, I think it would be a complex calculation to know what costs really truly are being avoided by the utility in that situation. So it's much more difficult than, say, if you're in an RTO where you have a revealed market price every year, every week, every month, knowing exactly what the market price is.
Have you been in any jurisdictions in which utilities have proposed to change their generators to operate seasonally, where they shut down in shoulder months and only operate in the summer and winter?
I'm trying to remember, and I have a number of colleagues that I work with, and so it's possible. I don't recall being in a proceeding like that, but I have a recollection of one of my colleagues being in a case and talking to him about that. But I have been in cases where utilities have proposed what's called extended cold shutdown of older facilities where they didn't want to retire them, but it was economic at least and I believe Big Rivers may have been in a situation like that. I'm sort of recalling now.
Yeah, and I think they may have been. And what were the economics effectively by doing that? They were avoiding costs that they otherwise would have incurred keeping it active and operating it?
Yes, I assume that in that case, it was less expensive to do that, and if they needed capacity, there were market alternatives. They could buy it cheaper.
Yeah, okay. No, this has been very helpful. I appreciate it, Mr. Barron. Mr. Kurtz, do you have any redirect to Mr. Barron?
I do, very briefly. Thank you, Chairman. Mr. Barron, this is sort of a follow-up to Mr. Riggs. Assume that the fair market value for 50 megawatt solar power plant, 20-year term, is $30 a megawatt hour, fixed over the 20 years, and that the utility who buys it, fair market value, gets to keep the RECs, the renewable energy certificates, but the QF regulation requires the utility to pay $36 a megawatt hour, 20% more, and the developer keeps the RECs. So under that scenario, and the utility is required to buy the QF power plant, who is harmed in that scenario?
I'm sorry, I missed the last part. Who was
harmed? Who is hurt if the utility?
Harmed. I think the ratepayers of the utility, assuming the utility gets to recover the costs, the ratepayers of the utility would be harmed.
Who is benefited?
In that case, the QF customer or
The
supplier.
developer, the owner of the power plant?
Yes.
Is there any way for the commission to audit the books of the QF power plant owner to determine whether or not they needed the extra money to actually build the power plant?
Not that I'm aware of.
You talked about a discount rate. If the consumers of a utility are required to buy a QF power plant before they need it, what would the appropriate discount rate methodology be?
Well, normally in these types of analyses, and I've been involved in cases where this type of analysis has been done, usually it's the utilities' cost of capital. But in theory, from the customer standpoint, to the extent that a customer has a higher discount rate and the customer is the one being harmed, you certainly could argue that the customer's discount rate might be appropriate. But generally, it's the utilities' cost of capital that is the weighted cost of capital.
So let's take a residential ratepayer who has a credit card balance or has a payday loan, and they're forced to buy a QF power plant before it's needed. Their discount rate may be 17, 18, and if it's payday, 20%. In other words, they're out the money. That's their personal cost of capital. That's their discount rate.
Yes, that's correct. And I've seen arguments in cases where that has been used.
And the higher the discount rate, the greater the present value discounting. If you're buying something before you need it and you discount it at 18%, the present value is less than if you discounted it the risk-free treasury bond rate of 1.2%, for example.
Right. The value of that QF in providing a capacity, avoided capacity, say 10 years out into the future, at a higher discount rate is going to be much different than if you used a lower, like let's say a treasury rate.
Thank you, Chairman. Thank you, Mr. Barron.
Mr. Spinard, do you have any questions for Mr. Barron?
Yes, Mr. Chairman. Good afternoon, Mr. Barron. Just hopefully very briefly, I believe that the record always speaks for itself, but I believe in response to a question from Mr. Riggs concerning a PPA, perhaps you used the phrase all else being equal. Do you recall that?
Yes, that sounds like something I might have said, yes.
Right, in your answer. And again, the record always speaks for itself, but in terms of your role as an economist, are you familiar with the Latin phrase ceteris paribus?
Yes.
And is it fair definition to say, assuming ceteris paribus, it allows us to simplify economics, and we can understand how something like higher price will affect demand, ignoring all other factors which might complicate the outcome. Is that a fair statement?
Your Honor, objection. Can you
Yes, I think
define the phrase, what's this phrase?
Ceteris paribus.
I apologize. I did not take Latin. Could you please define that phrase?
Well, that's what we're working with the witness to, because is that a phrase, is that a Latin phrase that you're familiar with in economics?
I have used it. I don't think I've used it, but I certainly have heard it used, and I've always interpreted it as analogous to all else being equal.
Okay, so when you say, in your response to Mr. Riggs, when you said all else being equal, you're using that from the economist standpoint of saying that's a simplifying assumption.
Well, I don't think, I'd have to read the transcript to know exactly the question and my answer. I don't think I was using that to comment on his question per se. I was really using it to comment on my answer, which is, for example, if prices go up, demand for if a price of a product goes up, demand for the product goes down, all else being equal. Well, the all else being equal in that sense might be, let's say it was gasoline and there was a shortage and there was hoarding by customers because of the shortage. Well, that might be an example of all else being equal. So it's just something that, there could be a lot of issues and complexities in an analysis. It didn't necessarily mean, I don't think I was commenting on the question, if that's what you're asking me.
Well, in terms of your answer, to put your answer into context, were you qualifying your answer or limiting your answer by simply saying that, basically putting some boundaries around your response to say, all else being equal, that's the answer?
Yes, that's exactly correct. And in answering that question, I don't necessarily, and I suspect it's the case, I didn't have every example of where it might not be equal. But I intuitively, I just believe that there probably were examples where there could be factors that we're not thinking about at the moment.
Okay, thank you so much, Mr. Barron, and my apologies to the witness and to everyone else for the introduction of Latin into the conversation. But
I just want to point out that the one time that I've been around 5.5 years that somebody uses Latin to explain something in economics is the day after our PhD economist goes off the commission. So poor timing is what I'm saying if you wanted any of us to understand. So thank you, Mr. Spinard. Mr. Fitzgerald?
Thank you, Mr. Chairman. Mr. Barron, can you hear me okay?
Yes.
Wonderful. Are you familiar with the concept of economic externalities?
Yes.
What are they?
Externalities would be economic impacts or economic costs that are not directly incorporated in an economic analysis. That probably the best example in an economic analysis or cost-benefit analysis would be, say, certain environmental costs for which there are no regulatory costs associated with the fact that they exist. For example, right now, CO2 would be, I would consider it an externality because there's no regulatory or legal requirement to meet a certain level of maintenance.
Okay. Generally speaking, if a real cost or a real benefit is left out of a price, is that price more or less efficient?
I don't know. I guess, that sounds like, I don't know that I could really answer that.
Okay. So the idea that a proper pricing would include the real costs and the real benefits is not something you're familiar with?
Well, I don't know what you mean by real costs and real benefits.
Okay. Well, let's start with carbon. Okay. Are you familiar with the Brown Station 10 megawatt solar plant?
Actually, my only familiarity is I heard it referenced today, I think.
Okay. Okay. Well, we'll leave it at that. Are you aware, are you familiar with the IRPs that have been filed by KU and LG&E concerning future capacity?
Over a number of years, I have reviewed, looked at IRPs, and certainly parts of IRPs related to load forecasts or reliability.
Let me ask whether, in your experience, and how many years is this that you've been doing utility-related economic work?
It's over 40 years.
Okay. In your memory, was there a time at which the costs of sulfur dioxide controls were considered an externality?
The cost of air quality, you said? What?
The cost of controlling sulfur dioxide emissions?
Yes, probably that's the case. I can't recall, but yes, I would imagine that's the case.
Okay. Do you recall whether the cost of controlling fine particulate pollution from smokestacks was at some point considered an externality?
Again, I don't recall, but if I had to hazard a guess, I'd say certainly during my career, it probably was until there were specific regulations that required controls and therefore costs associated with it.
Okay. Are you familiar, Mr. Barron, with the concept of social discount rates?
Generally, I have some familiarity with it.
What's your understanding of the phrase?
It's a measure. It's basically determining a discount rate based on some measure of I guess the value to society of an economic benefit or cost in the future versus today. I recall reading some articles probably 30 years ago in that regard, but I haven't dealt with it in a long time.
Okay, so do you know offhand whether social discount rates are generally higher or lower than private discount rates?
I don't recall.
Okay, you were talked earlier about you were asked by Mr. Riggs about the capacity value of solar, and I wanted to go back to that if I could. You talked about the being able to be called upon. Is what you're describing the dispatch ability of a particular energy source?
Yes, and I think that's how I answered it.
Okay, and capacity value can be calculated, is that correct?
Yes.
And it is calculated for solar?
Yes.
And I believe you testified that solar is deemed to have a capacity value?
Generally, it does, yes.
Okay, and is that at least in part because it operates during summer system peaks, for example?
Yes, but the calculation of solar or wind, for that matter, capacity value is usually based on the effective load carrying capability, which is an analysis to measure the value in terms of reliability.
Okay, and
usually over a year.
Okay, and did you make those calculations in this case? Were you asked to do that as part of your testimony?
No.
And are you aware where the company made those calculations?
I don't recall.
Okay, you mentioned that solar is intermittent, and I just wanted to come back to that, and it may be that intermittent has a different definition economically than it does in the utility world, but what does intermittent mean to you when you say it's an intermittent source?
Well, generally, I think solar and wind renewable resources characterize as being intermittent because changes in wind or solar radiance affects the output. And so the particular, in other words, if a solar unit had a nameplate capacity of 100, let's say 50 megawatts, it wouldn't necessarily be able to provide 50 megawatts every hour because it's a function of solar radiance.
Okay, but is the solar resource, or the wind resource for that matter, that's being harvested, is it fairly predictable?
There certainly are models based on historic weather analysis that are used in trying to project what the output of units are depending on the geographic location.
Okay, and in fact, I don't know if you were in the room when I think Mr. Sinclair testified about the charts that they have and how they can predict what may be actually the capacity, for example, of the Brown unit on a particular day in a particular month.
Yes, I think I heard that, but I'm generally familiar with that.
Okay, is it fair to say that solar has a high availability rate?
From a mechanical standpoint, I think the answer is yes.
Okay, and so when you say intermittent, do you really mean variable?
No, I mean intermittent because that every analysis that I've ever read refers to renewable resources as intermittent resources because of the fact that the output is a function of an unpredictable input, which is weather.
Okay, but in my limited 66 years, the sun has risen every single day. Okay, so what we're talking about solar. It has a high availability rate. It has a predictability to it, and so, well, I don't want to quibble over words. Okay, so you say intermittent, I say variable. Let's call the whole conversation off and go on to the next thing. You mentioned when you were talking about purchase power agreements that the importance of a contract between a purchase power, between a producer and a utility. Are tariffs not a contractual relationship between a customer and a utility that are approved by the commission, where service is offered under certain terms and the customer has certain obligations relative to accepting that service?
Yes, but in the context that I was discussing a contract, a tariff is not that type of contract. A contract that I was referring to, it was a longer term, and it could be shorter term, maybe 5 years, 10 years, 15 years, obligation of the seller to provide capacity to the buyer. And a tariff generally wouldn't meet those requirements. So, a contract, if I enter a contract with you to provide you a glass of water in the next minute, that's a lot different than if I enter a contract to provide you water on demand for the next 20 years. So the term and the provisions matter.
Okay, and a net metering customer doesn't get credited for generation that they don't produce, do they?
Not for no, they don't.
Okay, and let me just, if I could go back to this, and I hate to do this to you, okay? This is not a door I opened, and I was fine excusing you from further testifying, but since we've gone through this kind of 1-2 with the company and KIUC, I'm obligated to do this, and so bear with me. you were asked by Mr. Riggs about the definition of avoided costs, and you were actually read that definition as it appears in 807 KAR 5:054. You recall that?
I recall him reading it. I couldn't tell you that that's the regulation.
Take my word for it, okay? Subject to,
I'll
a
take your,
strenuous objection from one of the other parties.
I'll take your word for it.
Okay, and I can reread that if you need me to for purposes, in fact, let me do that, just so we're clear. It says, section 1, definitions, paren 1, end paren. Quote, avoided costs, end quote, means incremental costs to an electric utility of electric energy or capacity, or both, which, if not for the purchase from the qualifying facility, the utility would generate itself or purchase from another source, okay? That's the definition. So here's my question. Are you aware of whether that definition has any relationship to a net metering customer? Under Kentucky law?
I cannot, no, I don't know. I have read I think at one point in this case, or perhaps it was in the Kentucky Power case, I read the provisions, I guess, of SB 100, but I can't answer it. I don't know the answer to your question.
Okay. And do you know whether a net metering customer under Kentucky law is considered a qualifying facility, which is what that avoided cost definition is limited to?
I don't know, but I assume the answer is no.
Okay. And do you know whether the net metering statutes use the term avoided costs in constraining or guiding the commission in establishing a fair, just, and reasonable compensatory rate for fed-in solar?
I can't recall without looking at the rule, the statute, whether the term avoided cost was in it or out of it. My recollection is that the concept behind it was an avoided cost concept.
Okay.
Which is really the important issue, I think, that the commission would have to consider.
Okay. Well, let me ask you, do you take issue with this statement that in evaluating the costs necessary to serve net metering service customers, that the evaluation would be deficient if the evaluation failed to consider known or reasonably expected measurable positive effects or benefits that accrue to the companies?
And your question, I heard the.
My question is, do you agree or disagree with that?
Well, it's a very broad-based statement. I don't necessarily disagree with it. Obviously, it depends on what what elements are included or are excluded in that evaluation. I think it sounded like, I'm just hearing you verbally without reading it in context, which I normally would ask to do. It sounds just like a very innocuous statement, like consider everything that might be important. This statute requires you to consider everything that might be important. That's the kind of statement that you just read to me.
Okay, well, the statement I read to you is from the May 14th order in the Kentucky Power case that established a methodology for considering and valuing the compensatory credit for net metering customers. Do you disagree with the methodology adopted in that order by the Public Service Commission?
I don't know. I did read the order. I'd have to read it again to know whether I agree with everything. Certainly, I agree that it was the commission's order.
Okay, well, that much we can agree on. Okay, Mr. Barron, thank you. I appreciate your time. I still do not know why you were called back for supplemental proceeding when you did not provide supplemental testimony, and I appreciate and understand and endorse the concerns that Mr. Spinard had. But I do appreciate your being here. There is one question that I do have as we wrap this up. Did you provide a opinion after the May 14th order on whether a net metering tariff that fails to incorporate both the costs avoided components and the benefits would be fair, just, and reasonable?
I do not,
Extent this calls for a legal conclusion, and also to the extent that it touches upon privilege.
Excuse me, I appreciate that, but that is, let me rephrase this, Mr. Barron. Did you enter into the record in a non-confidential or a confidential matter any opinion on whether the net metering tariff proposed by Lg&E comports with the methodology in the Kentucky Power case, or whether a net metering tariff that did not comport with that methodology would be fair, just, and reasonable?
and when you say entered into the record, do you mean filed testimony or something of that
Testimony,
nature?
data requests, offhanded opinion, yeah.
The answer is no.
All right. Thank you very much. I appreciate your time, appreciate you being back here, and thank you, Mr. Chairman. I have no further questions.
All right, Mr. Riggs, do you have any additional questions?
No, Your Honor.
Vice Chair?
Nothing.
Oh, sorry. Ms. Vincent, do you have any additional questions?
I have no further questions.
Apologize. I have just one. Chairman Schmidt always said, don't trust an attorney when he said it's just one more question. You know, I'm aware of generally, and I think this is far more simple, in environmental economics, Mr. Barron, you know, avoiding a harm or avoiding, you know, some sort of damage, the avoidance of that is a benefit in conducting a benefit cost analysis. And this may be a ridiculously simple question, but as a general matter with regards to what we're considering here, net metering, SQF, LQF, and to the point, I think the point that Mr. Fitzgerald was making, whether it even implicates NMS or not, with what we're doing here, would you agree that avoidance of a cost is a benefit? Avoidance of a cost is a system benefit?
Yes, except to the, I think it becomes, I hate to complicate things at the end, but to the extent that it's an externality that customers would not otherwise be required to pay for in their rates, then you can end up with an imbalance in terms of how we evaluate one resource which is deemed to have externality benefits, and maybe you can quantify them in some fashion, versus another resource that's used for in rate making, a generating unit, whatever, for which customers are not required to pay for those externalities. And if you don't recognize that in one case you're putting your thumb on the scale a little bit, you know, I think you could end up producing a result that maybe is not the most economic for customers.
Yeah, so I appreciate that nuance, Mr. Barron. So a cost to the utility, avoidance of a cost to the utility, that like we discussed earlier, looking back at some point will be an embedded cost. Avoiding a utility cost, is that a benefit to the remainder of the system?
Yes, if you put it in the narrow it to avoiding a utility cost, a cost which otherwise might be incurred by the utility and paid for by the customers, yes, I would agree.
Okay. Mr. Cook or Mr. Kurtz, do you have any redirect of Mr. Barron?
No, sir.
Okay. And Ms. Vincent, can Mr. Barron be excused?
Yes, you may.
All right. Thank you, Mr. Barron, for sticking with us this afternoon, morning, afternoon, into the evening. Thank you very much.
Thank you, Mr. Chairman.
Maybe excused. So we have 5:30. Does anybody have to take a break right now? Would anybody have an objection to going ahead and attempting to, I think you have
Beth McFarland?
Ms. McFarland. I think that's probably best. I don't suspect we could get through Mr. Conroy or Mr. Seeley I've heard Mr. Seeley provide answers before. We're not getting out of here at 6 if we take them now. So could we take Ms. McFarland right now? Would you
Yeah.
mind to?
No.
Okay, please call your next witness.
Yeah, I can just have a minute to stretch my legs.
We can actually, if anybody would like, we can take 5 minutes.
5.
All right, we'll take a short recess for 5 minutes. We'll adjourn until 5:38. We're back on the record in case numbers 2020-00349 and 2020-00350. Mr. Riggs, you have an additional witness you'd like to call today?
I do, Your Honor. I would ask to call Ms. Beth McFarland.
Mr. McFarland, if you don't mind to please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Please have a seat. State your name and address for the record.
My name is, whoops,
Ms. McFarland, you can remove your mask once you're in the box.
that feels good. My name is Beth J. McFarland. My business address is 220 West Main Street, Louisville, Kentucky.
All right, thank you. Mr. Riggs, you may ask.
Thank you, Chairman. Ms. McFarland, would you state your business title for the record?
I'm sorry.
Would you state your business title?
I am Vice President of Electric Transmission for Lg&E and KU.
And how long have you been with the companies?
I've been with the company since 1997.
Ms. McFarland, did you cause to be prepared and file with the commission in this proceeding supplemental direct testimony on July 13th, 2021, and supplemental rebuttal testimony on August 5th, 2021?
Yes.
Ms. McFarland, if I were to ask you the questions contained in your supplemental direct testimony and your supplemental rebuttal testimony today, would your answers be the same?
Yes, they would.
Do you adopt and affirm both written pieces of testimony as your testimony for this hearing today?
Yes, I do.
Ms. McFarland, for the record, would you state what documents you have with you at the stand or what access to documents you have?
I have no documents, just a pad of paper.
All right. And do you have access to the screen and Mr. Lovecamp's computer?
Yes, sir.
Okay. The witness is now available for any questions, Mr. Chairman.
Thank you. I guess Mr. Cook or Mr. Horn, do you have any questions for Ms. McFarland?
No questions, Chairman.
Okay. Mr. Kurtz, do you have any questions?
No questions.
Mr. Spinard?
No questions, Mr. Chairman.
Mr. Fitzgerald? Any questions?
Mr. Chairman, I have a precious few.
Okay. I'm
Mr.
just now
McFarland,
realizing
can
I
you hear
did
me
not
okay?
ask- I did not ask Mr. Childers if he had any other questions, but knowing Mr. Childers, he would have spoken up had any additional. I apologize, Mr. Childers.
That's okay, no questions, Your Honor.
All right, great. Mr. Fitzgerald, you may go ahead.
Great, thanks very much. Ms. McFarland, in your supplemental rebuttal testimony, do you have that in front of you?
Yes, I do.
Wonderful. Could you turn to page 4 and look at line 14? I just had a question regarding a definition here.
Yes.
Wonderful. You referenced the, quote, current planning horizon, end quote. What is that horizon for purposes of your work with the company?
Yes, that would be our 2021 business plan, which would be 5 years.
Great. And is that a rolling 5-year plan that you update every year?
It is.
Great, thank you. On page 4, line 19, could you take a look at that and let me know when you're ready?
Line 19, you said?
Yeah, line 19, same page.
Okay.
Okay, the phrase embedded or potentially avoidable transmission costs. Do you see that phrase there?
Yes, I do.
Okay, who holds the data for what those embedded or potentially avoidable transmission costs would be? Is that something that it's in the possession of the companies?
Yes, the companies would hold that data.
Okay, and is that part of the, is that incorporated into ongoing planning?
Can you repeat that question, please?
Yeah, I was just asking, in the planning that you do you incorporate the embedded or potentially avoidable transmission costs when you're doing planning looking forward?
When you say embedded, I would refer to those from a transmission perspective as historical costs. So.
Okay, great.
So to the answer to that question would be no, we do not consider those on a go-forward rate.
Okay, and do you consider the other part of the phrase, what is potentially avoidable transmission costs going forward?
Could be, yes.
Okay, so
Potentially
for example,
avoidable costs going forward, yes.
okay, great. And were you here earlier when I was discussing with one of the other witnesses the idea of no wires solutions?
I was.
Okay, and do you consider in your planning for, you know, the kingdom that you preside over for the company, do you consider no wire solutions when you're considering potential, what you call potentially avoidable transmission costs?
Well, we complete a very robust transmission expansion plan that would involve forecasts from our load-serving entities. So we would receive those forecasts and we would essentially run models and studies to look for obviously congestion and solutions. And then as we put together what we would call CAPs, corrective action plans, we would complete a cost-benefit analysis, an investment proposal, and in that investment proposal, we would look for alternatives.
Okay, great. And just these are the last two questions, okay? And if I ask you a third, just say, sorry, you said two alone. Do the investments that the company makes in transmission, are those subject to a return on equity, a return for the shareholders?
From a return on equity perspective, I feel more comfortable with either Mr. Conroy or Mrs. Seeley answering that from a rates perspective, please.
Perfect. That's perfect. I will ask them that. And then the last question is, let me pose a hypothetical. If the company's overbuilt the transmission or the distribution system, how might that impact the evaluation or consideration of the, quote, potentially avoidable transmission costs?
Again, from a billing and rates perspective, I'm going to refer that to Mr. Seeley or Mr. Conroy.
Mr. Conroy, okay, then you are off the hook. Thank you so much. Appreciate your work, appreciate your testimony. Mr. Chairman, that's all I've got.
Okay. I already asked. Mr. Childers, did you have questions?
No, Your Honor.
Okay. Ms. Vincel, do you have any questions?
No, staff has no questions.
Vice Chair?
No questions.
Good evening. It's almost evening. Ms. McFarland, how are you?
Good.
I just want to ask a couple of follow-up questions to Mr. Kurtz's cross-examination and Mr. Sinclair earlier. Can Mr. Lovecamp bring up Mr. Sinclair's supplemental rebuttal exhibit DSS3? I believe that's the Lg&E the Lg&E, I think is the technical term, the Lg&E interconnection queue active project sorted by nameplate capacity, I think, or summer capacity. Let me know when you have that in front of you.
Yes.
Okay. And so the capacity of those resources runs from 8.5 megawatts summer capacity to 1,200 megawatts summer capacity. Is that right?
Yes, that's what I see.
Okay. So are you aware of the request for proposal to sell electric capacity and energy to the companies that the companies released in January of this year? Generally, that they released an RFP for generation in outer years?
I am aware of it, yes.
Okay. And do you remember it occurring in January, early January? Does that sound about right?
It sounds right, subject to check, that sounds correct.
All right, and just for the benefit of the record, I do have a copy of Schramm, is that Chuck Schramm, is that how you pronounce his last name? That works
Yes, that's correct, Chuck Schramm.
All right, Mr. Schramm's letter, if I can here, let me know if you see it on the screen there. This is a January 7th, 2021 letter from Mr. Schramm, subject request for proposal to sell electric capacity and energy RFP.
I'm sorry, you asked?
This is the document that you said you were familiar with.
I don't know that I'm familiar with this document necessarily, but it's I don't believe I've ever read this document, no.
Okay, well, we'll get to look at it together here for
Okay.
just a second, at least at a high level. So this is the January 7th, 2021 letter from Mr. Schramm there. And I'll just read the first paragraph. Not that I'm going to ask you anything specific about this, but Louisville Gas and Electric Company and Kentucky Utilities Company, together the companies, are evaluating alternatives to provide least cost long-term supply of capacity and energy to serve our customers. The companies are exploring the addition of 300 megawatts to 900 megawatts beginning in 2025 and no later than 2028, and may consider dates earlier than 2025. To diversify the company's generation portfolio, including cost-effective firm peaking, including storage, intermittent non-firm renewable with or without storage, and/or firm dispatchable baseload and load following capacity and energy. Is that what that first paragraph says?
Yes.
Okay. So, if we can, do you mind to look again at that? I think I have it here just for your benefit. That supplemental serve rebuttal exhibit DSS3, page 1 of 1. Mr. Sinclair was asked about this earlier, and he kind of said, well, this isn't my wheelhouse, but this was given to me by the folks that do it. So taking a step back before we get into the details of this, at a very high level, and I don't know the technical thing, but the companies, for reasons that FERC has made clear, but I don't necessarily know, the companies engage an independent transmission planner for its bulk transmission planning. Is that right?
Can you repeat that question?
Yeah. So, are you aware of Lg&E and KU's relationship with Transerve?
Yes, of course.
The independent transmission
operator,
operator?
yes.
Okay.
Mhm.
So there's a relationship there, and they do a lot of the transmission planning at the bulk level on behalf of the companies, right?
Yes, they serve certain functions for us, yes,
Okay.
indeed.
And they're this independent, it's in lieu of, for utilities that aren't part of an RTO, maybe, they serve some of those same functions that an RTO would, just for an independent company. Is that your understanding?
I'm not familiar with RTOs in any detail, so I would not feel comfortable making that analogy.
Okay, so
But
can
I
you
certainly can speak to the Transerve and the ITO.
Yeah, so can you tell me what, sort of, at a very high level, what Transerve does for the companies on the transmission front?
Well, first of all, they would review and approve the interconnection request. They would do system impact studies for us. They maintain our open access OASIS system and a number of other functions.
Okay, and
There's many.
That's a buffer there. You know, the companies run generation, they participate in the market. There's a buffer there between competitive generators that are wanting to interconnect in the company, and that's sort of part of the role that Transerve is playing.
Yes.
Is that fair? Okay. So I'll also share on the screen, and I appreciate that you mentioned it. Fingers crossed it works. Let me know if that OASIS, I know, I promised to zoom in here in a second. It's a very big document. But is this the open access transmission OASIS document that you were talking about earlier, the transmission interconnection queue?
Yes, I believe that's it.
Okay, and I will, I appreciate our IT staff zoomed in. I will zoom in as well. Hopefully that makes it a little better.
Yeah.
So we'll start in the far left, but there's a queue number that seems to, Lg&E, I assume that means it's your project. Generation interconnection, there's GIS, I'll just say that. And then there's a sequential number, it looks like, by year, based on the application date. Do you see that? It goes from 001, 002,
Yes.
03. Then it states the county the project's located in, the state, the control area, the point of interconnection, the request status. I think the options are in service, GIA signed, active, interim GIA, and withdrawn. Interim GI requested is another column. Available reports, FBS, ISIS, SIS, and FS. Whether it's an affiliate or not, that's new. That was, I think, as a follow-up to a question once about whether some of these are affiliates, but it shows whether, it indicates whether the request is from the companies or an affiliate of the companies or not. Then there's an in-service date, 2 columns for in-service date, 2 columns for generator information. This is a big, sorry, I'm going all the way through. 2 columns for capacity, and then a couple of columns there for where the studies are, right? Do you see that?
Yes.
Okay. So do you remember that the letter from Mr. Schramm was January the 7th of 2021? So we'll go down here. Thankfully, these are provided sequentially by, it seems, the Q number. And we'll see here, sorry, I'll stop right about here, right? This will give us about 2 or 3 years. So the beginning of 2019, the first project is this Washington County and Marion County project. Do you see that?
Yes.
Okay. And do you see that for the remainder of those projects, if you just give a look, if we could zoom out there just for a second. Okay. In the screen you have, do you see the column about whether it's withdrawn or current, or do I need to move over more?
I do.
Okay. The only one of those that is active is the Meade County project. Is that right?
From what I'm seeing,
Right.
yes, from what I'm seeing, yes, that's correct, what's on my screen.
Okay. All right. And I accessed this today. You can see in the URL up here that I've highlighted. I think the last update may have been 8/10/21 in the URL, but there are 3 that have LGI-A sign currently suspended. Do you see that?
Yes, I do.
Okay, and those go through March of 19 onto the next page. And we look at the top of these. The only ones that I see that are active on this page are the first one, Caldwell County. Do you see that from 2019?
I do.
And then there's one down here, Mercer County, that entered May of 19. Do you see that?
Yes, I do.
All these other ones are withdrawn, right?
That's what it appears, yes.
Okay. And then we get down to the end of 2019. There's no more active in 2019 except for this Hardin that says active provisional LGIA signed. There only seems to be 2 projects for 2020. There's a Madison County and a Mercer County. Both are active. And then in 2021, there's a single project for Caldwell County on January the 6th, which is active. And then on the 8th, there was a Union County one, but it's withdrawn, right?
Yes, that's what it appears, yes.
So following the 8th, there was another one on the 8th that's Muhlenberg County that's active. And then it would appear that all of the ones since that Muhlenberg County filing are all active, right? That's what this says. So I guess I would ask, do you have any reason to believe? I don't really believe in coincidences. I think price signals matter. I took enough economics class to figure that out. Do you think it's reasonable to believe that some of these interconnection requests, or at least the initial application, are related to the company's RFP for all resources that it put out at the beginning of January 2021?
I would speculate that's likely true.
Okay. And based off the ones that are included up through 2019, you heard Mr. Sinclair, I assume, talk earlier about there was a previous RFP in the 2018-2019 that led to the 100 megawatt Rood Solar project, right?
Yes.
And a lot of those would correspond to those that were at least the same time frame, the ones that had applied and had withdrawn. Is that fair?
That's fair.
Okay. And so Mr. Sinclair provides these in that chart. And I guess my question is, based off your experience, do you expect all of these to move forward in the company's footprint based off of what's previously happened once the companies have provided contracts to the winner of an RFP or the chosen entity of an RFP project?
Can you repeat that last part? I'm sorry.
Yeah, I guess I'm saying, based on your experience, do you expect that all these active projects will be built?
No, I do not.
But price signals matter. right?
Yes.
I remember my very first economics classes, the professor said the first thing you have to remember about economics is that you have to assume the consumer is rational. And he said, and the first thing I'm going to tell you about life is no person is ever rational. But assuming that these investors are rational, if these are, most of these are, sorry, excuse me for a second, if we scroll over, most of these are, I want to make sure I get them all right, the ones that are post. We'll start with Madison County here, which is a October 2nd, 2020. Almost all of these projects are above 80 megawatts, correct?
I don't see the, I'm not on the megawatt column.
Oh, let me continue to scroll. Let me know when
Okay.
you see the
Well,
megawatt.
Yeah, okay,
Okay.
yes.
All right, most of them are all, like the only one I see, and I can't see the very bottom two, but the only one that I see that's below 80 megawatts, the PERPA threshold, is a 50 megawatt project at the top. Do you see that?
Yes, I see that at the top.
All right. And a couple of these, a significant number of them are battery. Do you see that? Instead of solar plus battery, a lot of them are just, there's about 5 of them that just say, 6 of them that just say battery.
Solar/battery, yes.
Okay.
And battery, yep, battery alone.
Yeah, there's a long column of, well, maybe you can't see what I'm seeing. There's even more.
Yep,
Yeah,
I see
that,
it.
that just say battery there towards the
I
bottom.
do.
Yeah, okay. All right. But if you were to pay these people, based on your experience, $60, $70, $80 a megawatt hour, do you expect all these people would show up and take that benefit kindly?
Yes,
Okay. And the companies don't eat that cost, do they? Right? That's the cost of, the companies would have an expectation that if they are under an obligation to pay that to procure energy on customers' behalf, the customers would effectively end up paying that $60, $70, $80 a megawatt hour. Is that your
Yes.
experience? Okay. I appreciate it, Ms. McFarland. Those are all the questions I have. Mr. Riggs, before I turn it over for redirect, I would ask, would the company be comfortable providing this as a response to a post-hearing data request? Or are you all fine with it having been produced in the middle of the hearing and being on the record?
This is the reference to the Oasis OATI.
The company's interconnection queue as of today.
Yeah. Well, we'll provide it.
Okay. And we're happy to, I'm happy to have the staff asset and posting data, but just
Yes.
provide today's, as of today, this exact document. Is that
Yes.
okay?
Yes, that's
You'll be able
fine.
to provide that, okay. Can we do that, Ms. Vincel?
Yes.
All right, thank you. All right, Mr. Riggs, do you have any redirect?
I do not.
Okay. Are there any other questions for Ms. McFarland? If none, Ms. Vincel, can Ms. McFarland be excused?
Yes, you may.
All right, thank you very much. Okay, so we're at 6:04. As I understand it, Mr. Riggs, you'll have 2 more witnesses to go tomorrow, is that correct, Mr. Connor and Mr. Seeley?
Yes, and to the extent that the commission has questions, Ms. Saunders, who has co-sponsored data responses in the 7th and 8th round.
Okay.
But I do not plan to call her as a witness unless there are questions for her, but she is present and available.
Yes, staff has questions for her.
Okay. And she'll be attending remotely, is that correct?
She
Or
will
she's in
not. She
person?
has been here today. She will be here tomorrow.
Okay, perfect. All right. Is there anything else that we need to take care of before the end of the day?
We're going to start tomorrow morning at 9. Okay.
We will start tomorrow morning at 9 a.m. My very first hearing, I think, that I ever participated in, Mr. Riggs, was the first one I remember. Vice Chair Logston presided over. and he announced that, I think we had asked for a continuance of the hearing, and he had announced that the reign of Jim Gardner was over. We're moving our hearings back to 10 a.m. I regret to inform everybody that I'd like to continue to stick with the 9 a.m. hearings.
No, that's just fine, just wanted to confirm.
Yeah, if we could, we'll start back again at 9 a.m., and you'll be calling Mr.
Seeley?
Mr. Seeley first. Okay. If there's nothing else, we'll be adjourned until then.
Thank you.
Thank you.